Mr. Shipton. Could I ask you to stand a moment and whether you'd prefer to be sworn or to make an affirmation?
Sworn, Commissioner.
Please swear the witness.
I swear by Almighty God.
I swear by Almighty God.
That the evidence I shall give.
That the evidence that I shall give.
Will be the truth.
Will be the truth.
The whole truth.
The whole truth.
And nothing but the truth.
And nothing but the truth.
Thank you very much, Mr. Shipton. Do sit down. Yes, Mr. Collinson.
Commissioner, please. Mr. Shipton, would you give the Commissioner, please, your full name?
James Roger Francis Shipton.
And your position?
Chair, ASIC.
Business address?
120 Collins Street, Melbourne.
Now, in the materials you've got there, you should have a copy of your summons to appear before the Commission.
I do indeed, Mr. Collinson.
I'll seek to tender that document if the Commissioner pleases.
Thank you.
That will become Exhibit 7.62, the summons to Mr. Shipton.
Now, Mr. Shipton, if you could take your primary statement next, please.
Yes.
Just a few amendments in two places I want to take you to, please. The first is paragraph 151. Commissioner, I'll hand up what this is, some amendments to the table in paragraph 151. We have a typed version of the amended figures, but we thought it wouldn't take that long to put the amended figures in the original. If that
would have been much better if they'd gone in originally, wouldn't they, Mr.
Yes,
Collinson?
that's so.
Hand them up. Yes.
Now, Mr. Shipton, if you've got a pen there, can I just ask you to make these changes to the column 2018-2019?
Yes.
Where it says 45, could you just change that to 56?
Yes.
Where it says 2 in the next line, please change that to 3.
Yes.
In the next line, where it says 4, please put in 6.
Yes.
In the next line, where it says 1, please put in 3.
Yes.
Next line, change 20 to 24.
Yes.
Next line, change 5 to 7.
Yes.
And then in the total, could you please change 77 to 113?
Yes.
Now, just in the total column, instead of 1211 at the top, please put in 1222.
Yes.
Change 29 to 30.
Yes.
And jumping one, if you change 119 to 121.
Yes.
And change 363 to 365.
Yes.
And change 419 to 423.
Yes.
And please change 167 to 169.
Yes.
And then at the very bottom where it says 2839, change that please to 2875.
Yes.
And if you could initial, please, adjacent to those changes to the table.
Yes.
Yes. One final matter, if I could ask you please to go to paragraph 185.
Yes.
I understand you want to delete paragraph little a.
Yes.
So if you could rule a line through paragraph A.
Yes.
And please renumber paragraph B as paragraph A.
Yes.
And if you could renumber over the page, C and D should become B and C.
Yes.
And if you could initial those changes on both those pages.
Yes.
With those changes, Mr. Shipton, is that statement of yours true and correct?
Yes, it is.
I'll tender that statement if Commissioner pleases.
Exhibit 7.63, statement of Mr. Shipton.
If you could take now, please, your supplementary statement, Mr. Shipton, is that statement true and correct?
It is.
I tender that statement.
Exhibit 7.64, the supplementary statement of Mr. Shipton. Yes. Yes, Ms. Orr.
Mr Shipton, you commenced as the chair of ASIC on the 1st of February this year,
Correct.
and prior to joining ASIC you were the executive director of Harvard Law School's program on international financial systems,
Correct.
and before that you were an executive director and commission member of the Securities and Futures Commission of Hong Kong.
Correct.
You held that position from 2013 to 2016,
Correct.
and you are now one of 7 members of ASIC.
Correct.
And ASIC is required by statute to have no less than 3 members and no more than 8 members. Is that correct?
That's my understanding, yes.
And ASIC's other 6 members are the 2 deputy chairs and 4 commissioners.
Correct.
Now, Mr Shipton, you've said publicly that you see the purpose of regulation as being to modify behaviour with respect to agreed norms in order to preserve the benefits of the underlying enterprise. Is that your view?
Yes, that is my view.
And ASIC has a range of tools that it can use to modify behaviour?
Correct, yes, it does.
And the tools available to ASIC include both reactive and proactive tools?
Yes, I would classify it like that, yes.
And the chief reactive tools, do you agree, are enforcement-based tools?
I would say that enforcement-based tools are both reactive but have a very strong proactive element as well.
And would you call them the chief reactive tool that you have?
Yes, and I have said that they are, I think I've used the expression in the public, main reactive tool.
And you've said publicly that they're designed to punish previous behaviour and deter future recurrence.
Yes, I have.
And your chief proactive tools at ASIC include engaging with the industry?
You say chief tool. I wouldn't say that is the chief
I'm sorry,
proactive.
I didn't mean to suggest that was the only chief tool. Is that one of the chief
That is
proactive tools?
That is certainly one of the tools. Whether I wouldn't apply the word chief to it, but I would say it's certainly one tool.
What would you describe as the chief proactive tool that you have?
It's very difficult, and I prefer to avoid usage of to the extent possible of tools, prioritisation of tools, because there is a degree of equality amongst them. But I do believe that there is a foundational tool.
What is the foundational tool, Mr Shipton?
The foundational tool of any regulator, I believe, is enforcement.
And other tools that you have that you've referred to publicly in the proactive setting, as well as engaging with industry, include granting and revoking licences and authorisations.
That would be one tool, yes.
Providing regulatory guidance.
That is a tool, yes.
And conducting reviews and issuing reports.
That is a tool, yes.
Now, I want to ask you about how ASIC has used and proposes to use both reactive and proactive tools to modify behaviour in the financial services industry. But first I want to ask you about ASIC's role at a more general level. Over the past 20 years, ASIC's remit has expanded considerably.
Yes, it has.
Now, could I show you a diagram that tracks through how ASIC's remit has expanded over time? It's part of an exhibit to your statement. It's a page within the ASIC capability review, ASIC 0800 0016 0917. And this was the capability review into ASIC done in December 2015, which I'm going to come back to and ask you some questions about later, Mr Shipton. But for now, could I ask you to look at 0959 within this document? And we see here that in 1998, ASIC's existing responsibilities as a corporate securities and futures regulator were expanded to include responsibility for consumer protection in respect of financial services.
Yes.
And in 2002, responsibility for financial services conduct and disclosure was added.
Yes.
And in 2006, ASIC's remit in respect of superannuation was expanded.
Yes.
And in 2010, ASIC's responsibilities were again expanded in respect of consumer credit.
Yes.
And at that time, ASIC also took over market supervision functions, the supervision of domestic licensed equity, derivatives and futures markets.
Yes, from the ASX, yes.
And in 2013, ASIC assumed additional market supervision responsibilities and responsibilities for the FOFA reforms.
Yes.
And the result of all of that is that ASIC now has a wider regulatory remit than comparable market conduct regulators overseas. Do you agree with that?
That's my understanding, yes.
And in the same period, your regulated population has also increased significantly.
Yes, it certainly has.
But despite that, we know from the submissions that ASIC made in response to the interim report that ASIC's staff numbers and budget have increased relatively modestly.
Yes, modestly would be a good description.
Is there another description you would use, Mr. Shipton?
No, I think modest would be an appropriate one.
And how do you think that ASIC's resourcing compares with that of conduct regulators in other jurisdictions?
In my own experience, I believe that ASIC is under-resourced compared to some of our peers globally.
And how does the level of resourcing that you have affect the way that you perform your functions and exercise your powers?
Well, it weighs very heavily on the regulatory choices that we have to make, because it means that we are restricted in our ability to take on matters or to pursue matters in a way that perhaps we'd like to.
And could you explain further how that plays out, Mr. Shipton? Does it mean that you are not able to investigate matters that you would like to investigate?
It means it would be across the full spectrum of our regulatory activity. We are constrained in probably every aspect of our regulatory work, certainly in investigations, certainly in other matters relating to enforcement, but I would also make the case that we are constrained in our surveillance, our supervision, our important work on financial capability and other work that we undertake.
Now, Mr. Shipton, the government periodically publishes a document called a Statement of Expectations that sets out its expectations about how ASIC is going to perform its functions and exercise its powers.
It most certainly does, yes.
And ASIC formally responds to that Statement of Expectations by publishing something called a Statement of Intent.
A statement of intent, indeed.
And the government gave ASIC the most recent Statement of Expectations in April this year, a couple of months after you started as chair.
That's correct, yes.
And ASIC then published a Statement of Intent in response.
Yes, we did.
Now, you've exhibited a copy of the current Statement of Expectations to your statement, and I'd like to take you to that. ASIC 080000163087. Now, this is the current Statement of Intent, Mr. Shipton. I'm sorry, the current Statement of Expectations.
Yes, it is.
And if we look at paragraph 2 of the Statement of Expectations, we see that it says, this statement outlines the government's expectations for how ASIC fulfills its role, including how it balances its objectives and responds to changing circumstances.
It does say that, yes.
And could I direct your attention to paragraph 7, which says, a key role for ASIC is to reduce the likelihood that consumers will suffer losses as a result of misconduct by corporations and financial services licensees. This is done by ASIC enforcing and promoting expected standards of conduct using the range of regulatory tools at its disposal, including stakeholder engagement, surveillance, guidance, enforcement and policy advice. Now, could I ask you a bit about each of the regulatory tools mentioned in that paragraph, Mr. Shipton. The first is stakeholder engagement. Can you explain what you understand the government to be referring to there?
Stakeholder engagement, as I understand the government, it's difficult for me to speak for the government, and I would avoid not doing so. But what I would, if with permission, is to talk about my interpretation of what stakeholder engagement.
That's what I'd like, your understanding of what this is asking of ASIC.
I believe that they're asking us to engage with industry to understand their drivers and their business models. But I also took stakeholder engagement to mean that we would be speaking directly and frankly to members of the financial sector industry about our regulatory expectations. I would also add that I take the word stakeholder to be very broad, to include civil society, consumer groups, members of parliament, and other civil and business leaders.
The second regulatory tool in that section is surveillance. Can you explain briefly how ASIC conducts surveillance?
Traditionally, ASIC has been conducting surveillance in the form of, let's call it, desktop or paper reviews of situations, of transactions, or of themes across the financial sector or corporate sector. It's really a review, an oversight, an assessment type exercise. And it does involve, obviously, engagement with the regulated population.
And the third tool referred to is guidance. Does that refer to the regulatory guides and reports that ASIC publishes?
I took that to mean both the formal guidance that we produce, but also speeches, statements that we make in public, but also engagements and liaisons that we have with, again, the regulated population, but also more broadly to the community and influencers, professional advisors, for instance, in the financial and corporate arena.
And the fourth tool is enforcement. I want to return to that in greater detail, but that includes, do you interpret that as including commencing court proceedings, taking administrative action, suspending or cancelling a licence, issuing an infringement notice? Are they the sorts of matters that you interpret that to be referring to?
Most definitely, yes.
And the fifth matter referred to there is policy advice. What do you understand that to be a reference to?
I understand that to be a reference of our engagement with the government and indeed with the Parliament in relation to the determination of new legislation, regulations, particularly in relation to tools, powers, remit of jurisdiction, and those types of matters.
Now, I want to ask you a little more about ASIC's stakeholder engagement activities. If we turn within the Statement of Expectations to paragraph 31, which is at 3090, we see that the government says that it expects ASIC to have an open and sound working relationship with supervised entities and to ensure that industry participants are encouraged to communicate considered and candid views to ASIC.
Yes, that
Now,
is a government expectation of us.
Can I ask you to look now at what ASIC said in its statement of intent in response to that particular expectation? The statement of intent is also exhibited to your witness statement, ASIC 080000163133. And if we turn to 3137, we see ASIC's response to the expectation that I just took you to. Under our relationships, regulated population and industry stakeholders, ASIC says, we will engage with regulated entities in a variety of ways, for example, through advisory panels, roundtables on specific issues across sectors and regular meetings. These forms of engagement help us to gain a deeper understanding of industry and consumer developments, consult on policy matters, consider and help to address systemic risks or harms in the sectors we regulate, and discover potentially harmful behaviours by particular entities. And it goes on to say, Commission level engagement with stakeholders at all levels further assists us to understand market trends and emerging issues. Now, that reference to Commission level engagement is a reference to the members of ASIC, the commissioners meeting with ASIC stakeholders.
Yes, it is.
Including financial services entities.
Yes, as I mentioned earlier, I took stakeholders to have a broad meaning and definition.
So it includes the regulated population.
It certainly does.
And you tell us in your second statement that since 2015, ASIC has had a stakeholder engagement strategy for members of the Commission.
That's correct, yes.
Now, can I take you to that document, which you've exhibited to that statement, ASIC 080000163760. Now, this is your stakeholder engagement strategy.
Yes, it is.
And we see in this first page, having the Commission engage with the boards and senior executives of our key stakeholders through regular meetings contributes to ASIC achieving our strategic priorities. Do you see that in the first paragraph?
Yes, I do, yes.
And the strategy goes on to say, from 2016, do you see this a couple of paragraphs down? In addition to this, from 2016, the Commission commenced an enhanced engagement program to ensure they meet regularly with boards and senior executives of our largest financial institutions and boards of key industry associations. Under our enhanced engagement program, the Commission will hold more than 50 meetings with boards and senior executive groups of financial institutions and industry associations each year.
Yes, that's correct. And in 2016, as I understand it, it was coming out of recommendations from the capability review.
Thank you. And further down in this document, under the heading Financial Institutions, we see meeting with the boards and senior executives of our largest financial institutions provides an opportunity to exchange information and discuss issues directly with the leadership of these organisations. It enables ASIC to hear directly from our stakeholders about any issues or concerns and to receive updates on new developments in the institution. It also allows ASIC to provide direct feedback to those involved in overseeing these institutions about compliance and/or enforcement issues we're seeing in their organisation. In many cases, boards would not otherwise have an opportunity to hear this feedback directly.
Yes.
So your stakeholder engagement strategy requires regular meetings between the Commission and the boards and senior executives of the entities that ASIC regulates.
Requires would connote that it's sort of set in stone. I would say that it's a practice that we have established.
It's a practice that is the subject of a particular strategy document.
Right.
That requires relatively frequent meetings between members of the Commission and the leaders of these organisations.
I think we're saying the same thing, but yes, the practice is that we have been having these meetings following this this strategy document. The point I'm just trying to make is that if we don't meet these objectives, there wouldn't be consequences.
I see. But is it intended to continue with this practice?
Yes, this is the current strategy and current practice that we are adhering to, I believe, to a greater or lesser extent.
And how frequently do these meetings take place?
Well, I can only speak from my experience in the last 9 or so months that I've been in the role, and we have had reasonably frequent meetings with boards and senior executives of large financial institutions, but I'd also point out with many others as well.
And what do you mean by reasonably frequent, Mr. Shipton?
It depends what type of meeting that you're asking for. This paragraph is talking across a range of different types of meetings, or these paragraphs, I should say. They're talking about a range of different meetings, with boards and senior executives. So take, for instance, the boards. We would have an annual meeting with the boards of some of the larger financial institutions. That's, as I said, on an annual basis. I've had a number of meetings which you'd say an ad hoc or out of cycle when I first started this role, because I was new both to the role and essentially new to the Australian financial system, having spent a large part of the 20 to 25 years outside of Australia.
Separately to those meetings, do you also have direct contact with the senior executives and boards of the entities that ASIC regulates?
I do, yes.
And how frequently does that occur?
That would occur. There's no constant rhythm to it, as it were, but there are conversations or notifications that happen. Let's say 2 or 3 or 4 times a month. They can be as much as leaving a voice message about an imminent an imminent announcement on the market, given that we're a market regulator. It could be me calling a CEO to express dissatisfaction, which I've done on a number of occasions, or it could be a meeting to discuss engagement and passing on my own thoughts, views and perspectives, in other words, regulatory feedback.
What have you called CEOs to express dissatisfaction about?
I've called CEOs to express dissatisfaction on a number of occasions as regards the handling of particular matters that are being handled by our enforcement teams. I have called CEOs and spoken at meetings about my dissatisfaction about what I call legal trench warfare. I have also expressed my dissatisfaction to these leaders about the lack of professionalism in the Australian financial sector. And I've also spoken to these leaders, to a man and a woman, about the fact that I believe that they have forgotten that they are dealing with other people's money.
When you say that you've spoken to them about the handling of particular matters by your enforcement teams, what are you referring to there?
I am referring to on a small number of occasions where concerns by the enforcement team have been escalated to me, either directly by the team member or via another commissioner, about handling or delays or intransience by the financial institution. And I have asked CEOs to firstly be aware of the issue, and secondly to respond in a more timely fashion to us. I do not get involved in the matter itself. My role is to escalate and amplify our concerns.
And when you're speaking of delays there, delays in doing what?
For instance, responding to information requests in relation to trying to get documents, in relation to responding to substantive requests for clarification or information.
And how has that worked for you when you've contacted leaders of those organisations about those matters?
It's been extremely successful.
So they have been receptive to your approach?
They have been receptive to my approach, and it has had a operational impact to speed up the response. And it speaks to a broader point that I firmly believe that CEOs, chairs and other leaders of these financial institutions should be more engaged and more aware of some of these issues that are taking place between their organisations and our agency.
Is the contact that you have, that sort of direct contact with the leaders of these organisations, more frequent for the large financial institutions?
It has been for the large financial institutions, but I am keen to broaden out my engagement with other leaders of the financial sector and, importantly, other advocates of, let's say, consumer welfare and other influencers in the financial and corporate sector.
On Tuesday this week, Mr. Common from CBA gave evidence that you and he get together in a structured way every quarter. Did you hear that evidence, Mr. Shipton?
I didn't hear that evidence.
Is that correct?
I would not clarify them as get-togethers. I would clarify them as meetings.
I see. What is the difference there, Mr. Shipton?
Well, just in my own interpretation, and maybe I'm being pedantic, so apologies, I would just, I took get-together, I personally interpret, and maybe it's my own personal interpretation, as a more familiar, more social gathering, and I just wanted to clarify, at least in my own mind, that I have very structured, I aim to have very structured formal meetings with people like Mr. Common.
And he said that you also speak more frequently than that in a less structured way. Is that correct?
Well, less structured way, my take of the less structured communication with Mr. Common is that we often speak by phone. Often pre-market, as I said, because Mr. Common is giving us, as a markets regulator, the heads up of a market announcement which is coming the next day. That's important for us as a market regulator, but it's also very important for us to be aware of business developments inside a financial institution as important as the Commonwealth Bank.
Mr. Common spoke of a number of things that he contacts you to discuss, and one of them was whether CBA is appropriately engaging with ASIC on particular topics. Is that correct?
Yes, and he's engaged with me on those types of issues. He's been proactive, and I've been proactive back in engaging with him as well on points of engagement between his bank and my agency.
He also said that he spoke with you at times to get a sense of what might be on ASIC's mind.
He certainly has. In fact, I would go farther and say that I have spoken directly to him and his senior colleagues and the board exactly about our expectations and my expectations as a regulatory agency.
Is that type of contact that Mr. Common has described having with you, and you've now described, common from the CEOs of the other major banks as well?
Yes, I would say that it's common. It's a common point of engagement, and there is a consistency to a greater or lesser extent across the financial institutions, yes.
And you encourage that sort of contact?
I'm open to that sort of contact. I think it's very useful. I think it's useful for two main reasons. One, it gives me an opportunity to pass on my expectations and feedback directly to the most important people inside a financial institution. And secondly, it allows me personally to have a benchmark as to whether or not I think over time these institutions and the leaders of these institutions are changing.
Is it important to you to build a relationship with the CEOs of the major banks?
By relationship, I would take that to mean a professional relationship and a relationship and indeed a culture of open and frank dialogue. I'm heavily influenced by a report done in 2011 by the International Institute of Finance, which is a global industry body, which speaks about a culture of no surprises and the importance of a culture of no surprises between regulated entities and the regulator themselves.
Mr. Common's evidence also was that you occasionally call him to discuss things such as the close and continuing monitoring program, which I'm going to come back to. That's
yes.
Correct? You contact him as well as being open to receive calls from him?
Correct, yes.
And do you do that with the CEOs of the other major banks?
I've done that with the CEOs of other major banks, and I have also passed on personally, via personal correspondence, important reports and feedback that I think it is important that the chairs and CEOs receive directly. One example of that is our important breach report earlier this year, because there are important findings, both industry-wide and bank-specific.
Would you say that you and the commissioners have good working relationships with the boards and CEOs of the major banks?
I would say we have an open working relationship and a professional working relationship.
And we saw from the statement of expectations the expectation that industry participants be encouraged to communicate considered and candid views to ASIC. You recall that?
Yes, I would put particular emphasis on the word considered. I think considered feedback is important, not any feedback.
But these meetings and discussions that you have with the leaders of these entities take place against the backdrop of Section 912D of our Corporations Act, don't they?
Yes, 912D is a core component of our regulatory regime.
Because 912D imposes a legal obligation on these financial services entities to report information about significant breaches or potential significant breaches of their legal obligations to ASIC in a timely way.
It most certainly does.
So the financial services entities are already required by law to report misconduct to you?
They are required by law to do so, yes.
So you don't need to hold meetings for that purpose?
Meetings are not held for that purpose. These meetings are not breach reporting meetings. They are not a substitute for breach reporting. I'm not aware that they ever have been, nor should they ever be so into the future.
And these meetings aren't the only way that ASIC can communicate its messages and expectations to these entities. You can do that through many other channels as well.
We certainly can, and we certainly do.
Do you think, Mr. Shipton, that there are any risks associated with frequent personal contact between regulators and the leaders of the entities that they regulate?
I do, and that is why I personally exercise the highest degree I can possibly apply of professional judgment when I have these interactions, when I have these meetings.
What are the risks that you're aware of, Mr. Shipton?
I think I've alluded to it with my clarifications earlier, that somehow this would be seen by the other side as too familial, too friendly, too social, and ensuring that these remain, as they are in my mind, professional and very much anchored in the purpose in which I do them, which is, as I said, information accumulation, regulatory messaging, and baseline assessment as to be brutally honest and blunt, their performance as regards compliance with our laws and regulations.
It's the commissioners who have the ultimate responsibility for making decisions about whether to take enforcement action against these entities, isn't it?
Ultimately, that the Commission is the ultimate decision-making body in matters like that, yes.
But through these frequent meetings with the leaders of these entities, you and the other commissioners necessarily develop a relationship with the boards and the senior executives of the organisations.
A professional relationship and a professional engagement, yes.
Well, it's part of human nature, isn't it, Mr. Shipton, that when we have a relationship with someone, it's usually harder for us to do something that might harm that person's interests.
That's why I'm emphasising the importance of having a professional relationship and, as I emphasised earlier, exercising the highest degree of professional judgment in relation to these interactions.
And what about the professional judgment of your fellow commissioners? What do you do to oversee how they exercise their professional judgment?
I have mentioned to my colleagues the importance of treating carefully and with a healthy dose of scepticism some of our interactions with the regulated population. In my interactions and feedback from my colleagues, it's very clear that they share that mindset as well.
Well, Mr. Shipton, even accepting that there are benefits to ASIC from regular engagement with boards and senior executives of these organisations, is it really appropriate that the same people who have that engagement are the people who are ultimately responsible for making decisions about whether to take enforcement action against these agencies?
I do think it's appropriate, again, on the foundation that we continue to exercise the highest standards of professional judgment in our interactions and that they remain as such.
Would you accept that ASIC's practice of having these regular meetings involves a trade-off?
No.
You don't accept that?
No, I don't accept that.
You don't accept that there are benefits to ASIC but also risks from that engagement?
As I mentioned before, one has to be aware and has to be attuned, has to be a degree of scepticism, but I come back to something I fundamentally believe in. We need to be exercising the highest standards of professional judgment in these engagements.
Do you think ASIC is transparent enough with the community about the risks involved in having the commissioners attend these regular meetings?
This subject matter I don't believe has come up in the public domain before, but I'm more than happy to have our organisation engage on the topic. I would also quickly highlight that we are, all of us, the commissioners included, we're governed by the rules and protocols as part of legislation against conflicts of interest and our code of conduct. And we have statutory obligations which go far beyond the professional standards that I mentioned before. In fact, not only do they go beyond, I would say that they reinforce. If I remember correctly, we as commissioners are under criminal sanctions if we do breach these legislative guidelines in relation to conflicts of interests.
In your second statement, you say that at these meetings, topics of discussion can, but do not always, include matters of relevance to current or potential enforcement or regulatory action by ASIC against the regulated entity. You say, although such engagement is kept at a necessarily high level. What do you mean by a necessarily high level, Mr. Shipton?
Well, and I will speak to my own experience in the last 9 months. And essentially, that is just talking broadly and almost in passing about a matter with these board engagements. To speak about the importance, maybe the awareness of, but we do not, and I've encouraged this, we do not delve into detail. Because we are exercising, I believe, the highest degree of professional standards.
Well, why is there any need to talk broadly about current enforcement matters at these meetings?
Because when they are touched upon, and they are certainly not in my view, main agenda items, but they certainly are key regulatory messages. When we take enforcement action, we are trying to send a message to that institution, but also more broadly. I would describe it as us reinforcing and amplifying the message in passing that we are trying to pass on via that action. But I agree with you that we should be very careful about delving into too much detail on these types of subjects.
Would you have a policy governing the types of topics that can be discussed at those meetings?
We don't have a policy, but again, I'm relying on my own good judgment, professional judgment, and the highest standards that I expect of myself, and I know the highest professional standards that my colleagues apply to themselves.
So I assume you don't have a policy governing the involvement of commissioners in making enforcement decisions about entities that they're attending meetings with?
Not to that precision. We do, as I said before, have overarching conflicts of interest policies, both written into codes and written into legislation.
You don't keep any minutes of these meetings between commissioners and members of the boards of financial services entities or CEOs of those entities?
Formal minutes are not taken, but my practice in relation to meetings, whether they be a board, meeting with a board or meeting with another senior leader, if there is a matter of significance, particularly a matter relating to an enforcement matter, for me to take a note and to brief my colleagues involved directly on that as soon as possible.
Wouldn't it be better, Mr Shipton, for the sake of transparency, for there to be a formal record of the meetings that you and the commissioners have with the leaders of these organisations?
It may very well be. These meetings were designed originally and have been pursuing along these lines, where they are meant to be a free-flowing dialogue between the board members and the commissioners of ASIC. I believe that the reason why there is no formal minutes, at least from our side, is to enable that dialogue to be free-flowing. But I will make one amendment to that, because after attending one or two of these board meetings, I thought it entirely appropriate to have somebody there who was not a commissioner, who is, in the cases that we've had in recent time, a senior executive leader, who observes the meeting and is not a commissioner but observes the meeting in many respects to ensure that we have a record and a witness to those discussions. And this is something that I've instituted in recent times. And it is also now correlated to the senior executive leaders who are involved in our close and continuous monitoring program.
So why not have that person keep a formal record of some sort of the meeting?
I think that is something we can certainly look into. But the expectation on that person is that they would keep a record, and they would escalate and they would highlight if there is a significant matter that needed to be recorded.
Well, what would constitute a significant matter that needed to be recorded?
Well, for instance, if, unbeknownst to our intent, somebody did launch into great detail on a matter which was, let's say, this is all conjecture, but something that is not of a more general matter. These board meetings, these liaisons with the board, to be frank, the ones that I've attended to, I've done most of the talking, to be frank. I've been passing on the messages, my expectations, and it's been a bit of a one-way dialogue. So no matters of significance, at least coming from a financial institution, has been raised, because I have been very forthright in using these platforms and forums to tell these people what I think.
So there hasn't been much in the way then of communication of considered and candid views by the entities in these meetings?
I actually find, which I was surprised when I first attended these meetings, I was surprised that such senior people spoke so little. So the degree of candidness was to some degree muted.
Do you think it would be preferable to keep some separation within ASIC between the enforcement function and the engagement function, so that the parts of ASIC who are engaging frequently and cooperatively with the entities are kept distinct from the parts of ASIC who are making the decisions about enforcement action against those entities?
Yes, to the degree practical, that is in part the design and the structure that we are moving to under the reform agenda that I'm implementing.
You're referring there to something I think that I want to come back to, which is the creation of a new layer of people within your management structure who will take many of the day-to-day operational responsibilities away from the commissioners. Is that right?
That is absolutely correct.
Okay.
In part, there's more to it, but I'm sure we'll come to that later.
Now, I want to stick to the topic of transparency, which I've raised in connection with those questions, and turn to another of the regulatory tools referred to in the statement of expectations.
Before we leave that, Ms. Orr, just could I go back to this question of engagement with entities? Would not having a note taker at these meetings ensure that there was a method of preserving the corporate memory within the organisation of what has been said, when it has been said and what was said?
Yes, I agree with that, Commissioner, and I think in part that was the intent behind having one of our senior executives for the first time attend these meetings in recent times.
But the preservation of corporate memory of contacts of this kind is itself surely a matter of very considerable importance to the proper governance of ASIC.
I certainly agree with that. I most certainly agree with that, and that is in part why I initiated having a senior executive leader accompany us on these types of engagements.
Yes, as I recall your answer to one of the questions, it was that he or she would take a note of matters of significance. What I'm talking about is a note taker, as more generally understood, a note taker who took a note of all that was said at the meeting.
Yes, it's a suggestion that I think is very worthy, and I am minded now to ensure that this happens from here on.
You said also that if questions of enforcement if mention was made of regulatory action that had been taken, you would wish to, as you put it, I think, reinforce and amplify the message conveyed by that regulatory action. What do you mean by that?
Well, firstly, Commissioner, I'm not aware of any of my interactions at this board level where there has been much time or significant mention of an enforcement action. But I would reserve the right that should a action be mentioned, or if there's an action taking place which is in the newspapers or something like that, using that opportunity to speak directly with the leaders of these financial institutions about the case at hand or the case in point, the regulatory message behind that, and in many respects, in fact every respect, either the specific deterrent aim or the general deterrent aim of that action. I would also hasten to add that we speak about other regulatory tools such as reports and on-site supervision and so on. And we talk about, again, what we expect to be the outcome by way of behavioural change, deterrence, stopping of actions, and so on.
Yes.
I said, Mr. Shipton, that I wanted to stick with the topic of transparency, which was part of the questions that I put to you earlier, and turn to another of the regulatory tools mentioned in the Statement of Expectations, being guidance. Now, you said earlier that that includes publishing reports.
Correct.
And ASIC issues a number of reports each year.
Yes, we do.
And some of those provide updates on your activities.
Yes, they most certainly do.
And some set out your response to submissions received on consultation papers.
That's correct, yes.
And some describe the results of reviews conducted by ASIC using its compulsory information gathering powers.
Yes.
Now, I want to ask you about that last category of reports containing the results of reviews where you've exercised your compulsory information gathering powers. Over the course of this year, the Commission has referred to a number of those sorts of reports in the hearings. And in the last round of the Commission's hearings, the 6th round, there were a number of references to Report 587, published a couple of months ago, on the sale of direct life insurance.
Yes.
Now, there were also references in those hearings to Report 498 on ASIC's review of life insurance claims handling.
Yes.
Are you familiar with both of those reports?
I'm aware of both of those reports, yes.
Both of those reports identified poor practices on the part of financial services entities and set out ASIC's expectations for how those entities should change their behaviour. Is that a fair description of them?
Yes, that's a fair description.
And both reports set out the results of detailed reviews that had been conducted by ASIC based on information brought in under compulsory information gathering powers.
Yes.
Now, underpinning those reviews was ASIC investigating the practices of certain financial services entities. Is that correct?
Yes, that's correct.
Now, could I ask you to look, we'll bring up report 498, that's the earlier of the two, the one dealing with claims handling in life insurance, RCD 000600160626. This is a report from October 2016, I'm sorry, have I given the wrong number? August 2008. Sorry, I may have given the wrong number. We have it. Sorry. Perhaps I gave the right number, but the wrong document came up. So this one is the report that was published in October 2016, report 498, and the findings in this report are based on ASIC's industry-wide review of claims handling in the life insurance industry.
Yes.
Now, if we look at 0640 towards the beginning of the report, we see that ASIC there identified the 15 insurers covered by the review. Do you see that in table 1?
Yes, I do.
But when it came to set out its detailed findings, ASIC did not identify which of its findings related to which of those insurers.
I believe that to be so.
And when ASIC set out case studies in this report based on its review, it didn't identify the insurer to whom the case study related.
I understand that to be the case.
And why not, Mr. Shipton?
I'm not aware why not. I wasn't in ASIC at the time. But I would only point to the fact that reports of this nature during my time have named entities.
Well, I want to come to
Please.
a report during your time, but do you agree that an important purpose of these reports is to get financial services entities to improve their practices?
Most definitely.
And do you agree that an entity that is publicly identified as being the worst performer amongst its peers is likely to have a strong incentive to improve their practices?
I most certainly do.
All right. Now, can we move to a report from your time? We tendered this report, I believe, in the sixth round of hearings, but for completeness, I would be happy to tender it again in this round, Commissioner.
If
No
it's
need.
gone in, it's gone in.
Thank you. Now, I mentioned report 587 earlier. That's at RCD 000300750138. Now, this is a report published on the 30th of August this year in your time as Chair of ASIC relating to the sales of direct life insurance.
Correct, yes.
And it summarises ASIC's findings from its review of practices of those selling direct life insurance.
Yes, it does.
And if we turn to 0251, we see an appendix to the report which named the entities covered by the review,
Yes, it does.
as we saw in the other report.
Yes.
But when we see comparative diagrams within this report, we don't see any reference to the particular insurers. If I can give you an example, at 0207, we see a table depicting claim outcomes for accidental death by firm, and we see that the data is presented as being referable to Firm A, Firm B, Firm C, Firm D and Firm E.
Yes.
Why didn't ASIC identify which of the insurers had engaged in which particular practices dealt with in this report?
I do not know in relation to this particular report. I have been briefed, though, however, that there are sometimes statistical reasons that it cannot be done. All I can say is that I've told the team in recent time that our strong preference, my strong preference, is moving forward, these types of reports should identify the institution by name.
Well, what type of statistical reasons could there be? Either these statistics are good or they are poor. You've chosen to publish them, so you have some degree of confidence in them. Why not identify the firms to which they relate?
As I said, I can't comment in this particular report. I was talking more generally about some of the difficulties moving forward, because I have had a conversation with my colleagues about moving forward, that my strong preference is to ensure that these types of reports do name names. I am not aware of the reason in this particular report why it wasn't. All I can say is that I have expressed in very clear terms, moving forward, that these types of reports should name names.
And did you express those sentiments prior to the 31st of August when this report was published,
No,
Mr. Shipton?
I did not express that prior to this report.
Right, so that's something that you've recently conveyed, is it?
It is something I have recently conveyed, yes.
And why have you conveyed that?
Because it came up in a decision relating to the publication of the breach report, and that was a matter which we reported, I think, on very significant practices by the financial institutions, and we decided to name names in that report, and from that experience of naming names, it was very clear to me, as you make the case with this question, of the importance of naming names. It's very clear. I agree with you entirely.
Well, Mr. Shipton, you say that you made the decision to name names in Report 594. Report 594, like this report and the other I showed you, included multiple case studies throughout the report to demonstrate particular instances of non-compliance with Section 912D. Those case studies did not identify the entity to which they related, did they?
Could you just clarify to which report you're referring
I'm
to?
referring now to the report that you've just directed me to, Report 594.
If my memory serves me correctly, we do identify and we do identify the performance, the timeliness of financial institutions on a relative basis.
Well, perhaps if I can bring up on the screen for you some portions from Report 594, which
Please.
is the breach reporting report that you say embodies the decision that you made to name names. Now, while I find some references to that, can I ask you, do you recall that one of the things that ASIC said in Report 594 was that there were two financial services entities that had referred to remediation historically as a distraction?
I do remember that comment.
And do you recall whether ASIC named those two entities in Report 594?
No, we didn't go to that detail, I don't believe.
Why not?
Because we believe that, I believe that the purpose of that report was to report on the broader themes, and the broader theme was a significant lack of timeliness in systems and processes in and around financial institutions. We can't. I think there is a degree of judgment needed to be exercised to the extent that we name names, and we clearly decided not to name names on every single aspect and reference point in that report.
Well, why not, Mr. Shipton? Your evidence a moment ago was that you had decided to name names and that Report 594 was demonstrative of that decision. Do you now say that the decision was to name names in some respects in the report but not others?
Well, we believe that in that report we were reporting about themes and processes of the financial institutions, the important themes and processes and failings. We refrained from speaking about individual cases in relation to that report, because this is a thematic, industry-wide report. That was the intent and purpose, and I believe that the intent and purpose of that report was duly served.
You said to me a short time ago, Mr. Shipton, that you agreed that an entity that's publicly identified in a particular way, such as by being the worst performer, is likely to have a strong incentive to improve their practices.
Yes.
So why not identify the entities, the two entities, who you called out in this report as having referred to customer remediation as a distraction?
Because, as I said before, the main purpose was to talk about systems and processes in financial institutions on a relative basis. That was the main purpose.
You don't think that purpose would have been well served by naming names throughout the report?
I don't think that it would have necessarily added to the broader impact and purpose of that important report. Again, the purpose was not to speak about case-by-case basis. The purpose and intent of that report was to talk about themes and processes as opposed to case-specific matters. So there is a difference between the purpose. If it was a matter which was primarily aimed at case-specific matters, then perhaps that would be a more appropriate forum. But this was a report about processes, procedures, systems, and decision-making inside financial institutions that were found wanting. But I am disturbed by that response. I agree with you, and I know that the team followed up directly with the institution on that.
What's the point of having case studies then in a report of this nature?
Well, case studies show are examples of that. As I said, the purpose of this particular report was to identify systems failures, cultural failures, decision-making failures. That was the point. So having individual case studies in relation to that were examples of those failures. I think what we're speaking about here is, an exercise of judgment as to whether we make mention or name names of that particular incident is one that we exercise. For what it's worth, there are a number of examples also mentioned there that would trigger the same line of questioning that you mentioned. And if we were to name names on each of those individual, let's call them triggers or catalysts, the report would probably just be far too long.
Well, it wouldn't increase the length of the report at all to use the name of the entity in each of the case studies, would it?
I think what we did, in fact, what I know we did, was exercise judgment as to what we thought was meaningful disclosure. You are making a case, which I can certainly understand, that we should be disclosing each and every reference to incidents and observations. That is a degree of professional judgment. I believe that the report was incredibly impactful and effective, and uses of examples and case studies are important. You make a good point. I see the point that you're trying to make, but what I'm trying to also say is that we're trying to exercise, let's call it editorial judgment, as to these types of reports moving forward.
Well, let me understand. What's against naming the entities that were picked out in the case studies?
Well, I think Commissioner Missor is referring to some of the references, such as two cases where the reference was to a distraction.
Well, my question is directed to the fact that there are at least 18 case studies set out in the report, probably more, but my scrolling's not quick enough. Each of them is simply described as an AFS licensee did this, did that, did the other.
Oh, I apologise.
What's the downside in naming the AFS licensee?
Oh,
What's the countervailing feature that forms this editorial judgment?
Apologies, Commissioner. I misunderstood the question. So I think we may have been speaking at cross purposes for quite some time, so I apologise for that.
I don't think you've been speaking at cross purposes. Just focus on my question for the moment. What's the downside in naming the AFSL holder?
As I understand, the naming of the AFSL would have just taken more time to actually go through the process of confirming the facts and situations, almost a right to be heard by the actual case. But I believe you make, Commissioner, a very good point about the naming in the particular case studies moving forward. Let me sort of explain where my thinking was when we made these decisions. We named names in the breach report in relation to relative bases, and I believe there's a series of graphs as to the relative performance of different financial institutions. I now understand that you're talking about the individual examples and case studies, and that is something we can certainly look at. I don't want to dispute the suggestion in that regard.
Perhaps it might assist you if I bring up an example
Please.
of that from the report. If we go to RCD 0003 0078 0001. And we turn within that report to 0033, we'll see at the bottom of that page, Case Study 6, Compliance Systems. An AFS licensee's external audit during the review period found it was not possible to conduct analysis of risk indicators such as customer complaints, operational issues and financial data, e.g. customers' refunds, to look for systemic compliance issues. The audit found that the present incident data was inadequate, incomplete and inaccurate, and as such would inhibit conducting such an analysis. In 2018, despite years attempting to improve the system, the licensee still had great difficulty searching their compliance system and therefore delivering reports of misconduct. Why did ASIC not identify the AFS licensee to whom this case study related?
My response would be, I certainly see the utility of disclosing the name of the licensee in this particular point in time. And I would also suggest, subject to any statutory limitations or fairness limitations, that this is something that we should be thinking about moving forward.
Well, what are the statutory limitations in your view,
well,
Mr. Shipton?
I would have to seek advice from my legal office, but I know that I'm informed that there could be some restrictions about usage in the public domain of material. I cannot opine on that because I'm not an expert on this area, but subject to there being clearance and an ability to do that, I believe that the suggestion that you are making is a good one. I would also quickly add that what we are doing is at a journey. We are starting, and we started with this, in at least my time at ASIC, we've started with naming more names than we've named before in relation to the relative performance. The next suggestion, which you are clearly making, is that we name names in case studies, and I think that has utility.
Yes, I want to be very clear, Mr. Shipton. I'm putting to you that you're not naming enough names.
Well, I think you made a good point, Miss Orr.
All right, I'll tender the breach report, report 594, Commissioner.
ASIC report 594. Review of selected financial services groups' compliance with the breach reporting obligation, RCD 0003 0078 0001 becomes Exhibit 7.65.
Mr Shipton, does ASIC discuss the findings in these sorts of reports with the entities involved before it releases the findings?
I believe in this particular case, in the interests of fairness, we informed the financial institutions, yes.
I want to understand that. So what do you mean in the interests of fairness? You've exercised your compulsory information gathering powers to bring this information in, you've analysed it, you've prepared a report. Why is it in the interests of fairness for you to discuss the results of the report with the entity before you make those results public?
I wouldn't say discuss, I would say notify as a matter of, as I said, fairness, so that they have an awareness that we are going to publish their names.
Why do you need to give your regulated entities awareness of these matters before you release them to the public?
As I said, I would regard it as a matter of fairness.
Well, I just want to try and understand this more and why you're concerned about fairness with your regulated population when you've brought in information that yields very disturbing results about the conduct of your regulated population. Why are you concerned at that point to be fair by giving them advance notice of your findings?
I do not believe that giving advance notice of our intent to publish their names in any way distracts from the importance and the impact of this particular report, and as an administrative body, as the administrator of an administrative body, I know my colleagues keep in mind, procedural fairness type concepts in the execution of our work. I do not believe that providing advance notification, that we are going to publish this in any way detracts from the impact and the importance of it.
Does this come back to the relationship that you're trying to cultivate and maintain with the entity, Mr. Shipton?
Absolutely not. Absolutely not. I see it as the exercise of professional judgment. I see it as ensuring that we are tough, we are resolute, we are strong, but we also apply principles of fairness and follow due process. I do not see that there is an inconsistency in those two concepts.
Has ASIC at times discussed the recommendations that it proposes to make in these reports with the entities involved in the review?
Not that I'm aware of.
Does ASIC invite at any time the entities involved in the reviews to comment on the findings in the review before finalisation of the report?
Not that I'm aware of.
All right. Could I ask you to look at ASIC 0081 0004 2852? Now, this is a document I believe would have been shown to you in preparation for your evidence, Mr. Shipton. It's an ASIC note about a meeting with a representative of BT Financial on the 1st of June this year. And if we bring up 2857 and 2858, these entities, we see on these pages references to an ASIC report in relation to advisor-operated accounts. Do you see that at the top of the left-hand side?
Yes. May I please see the front page of this?
Yes, Mr. Shipton. It was 2852.
Oh, so that's the front page. Pardon me. Thank you.
And if we go back to 2857 and 2858, we're partway through the paper now under the heading Other Issues, and we see a reference to an ASIC report about advisor-operated accounts. Do you see that?
Yes.
And ASIC is about to publish its report of key findings and recommendations.
Yes.
Do you see that?
Yes.
Following a review that we see under the table had been commenced in April 2017, which involved 5 banks, including Westpac. Do you see that information on the left-hand side of the page around And then over on the right-hand side of the page, I'm sorry, we don't have the right page. We need 2858. On the right-hand side of the screen. Now we see the two pages as they appear in the report, Mr. Shipton, and under ASIC's review and report, the second dot point, we see that DCI met with Westpac on the 18th of October 2017 to discuss the practices we observed across all banks in the review. Following the meeting, Westpac wrote to ASIC setting out its position on the findings and recommendations and rejected some of the recommendations. ASIC has not responded to this yet as we are finalising the report.
Yes.
You see that? So this was in June this year, engagement with one of the entities who was the subject of the review about the findings and recommendations, resulting in Westpac writing to ASIC with its view of those findings and recommendations prior to publication.
Yes.
Do you wish to comment on that? That appears to be inconsistent with the answer you gave earlier.
I don't think it's inconsistent. I'd point out that these are briefing notes of a meeting that I didn't attend.
Yes.
I'd point out that the conversation about that feedback was in October in 2017.
Yes.
And if there was a back and forth, I'm not aware of it, and I do not know what happened in relation to that correspondence or that interaction. I'd also point out that often is the time that it's very often the case that financial institutions put to us many things that we don't necessarily take on board.
But I asked you earlier if ASIC ever discusses the recommendations or findings in these reports with the entities prior to publication. Yeah. This shows that in this instance that sort of discussion did occur.
Let me emphasise the point. Not that I was aware of, and I was also talking about during the time in my tenure here at ASIC. So that is the context in which I was responding to your question earlier.
But did you review this document before you gave evidence, Mr. Shipton?
Yes, I did look at this document before I gave evidence, but I had to review thousands of pages of documents before I gave evidence. So it's difficult for me to have knowledge of each and every paragraph in each of those documents.
But now that you've seen these paragraphs in this document, do you agree that it appears that ASIC does at times discuss the recommendations and findings that it proposes to make in these reports with the entities who are the subject of the report prior to publication?
Well, can I raise this objection, Commissioner? My friend has put this a number of times. I don't want to help the witness, but it's not what the paragraph says. There's a degree of precision which would be appropriate for this line of questioning.
Yes, well, put the question again, Ms. Orr. Just wait before you answer it, would you, Mr. Shipton? What's the question, Ms. Orr?
I'm focusing, Mr. Shipton, on a particular line in the paragraph before you. Following the meeting, Westpac wrote to ASIC setting out its position on the findings and recommendations and rejected some of the recommendations. Now, having read that sentence, I'm asking you whether you wish to qualify the answer that you gave me to an earlier question about whether ASIC does at times discuss the recommendations that it proposes to make in reports with the entity the subject of the report prior to publication.
Just a moment, Mr. Shipton. Do you maintain the objection, Mr. Conson?
No.
No? Yes.
Well, the point, I use the expression notify. I'm not aware that this paragraph says that there is actually a two-way discussion or response from us in relation. That ASIC has not responded to this yet. So that was a matter that was, it seems from my reading, and again, I do not have context as to what happened in October 2017, but my reading of that is that we notified Westpac. They came back and we did not respond.
Well, you can see that there was a meeting with Westpac on the 18th of October 2017 to discuss the practices we observed across all banks in the review. And following that meeting, Westpac wrote setting out its position on the findings and recommendations. Do you say that that suggests that the findings and recommendations were not discussed at the meeting referred to in that paragraph?
Well, there was a discussion, but what I'm trying to make the point of is that often there is one-way discussions. Often a matter can be put to us which we reject. In fact, that happens to us in our existence on a very frequent matter. There are representations and submissions made to us. I cannot conclude with the documents before me that there was a back and forth discussion, a full connotation of a full back and forward discussion. That's why I wanted to be quite precise about the apparent one-way nature of this interaction.
All right. I'll tender that document, Commissioner.
ASIC note of meeting with BT Financial, dated, Ms. Orr?
Dated the 1st of June 2018.
1st June 18, ASIC 0081 0004 2852, Exhibit 7.66.
Yes. Mr. Shipton, I want to turn to another of the regulatory tools referred to in the government's statement of expectations, and that's enforcement action. And the government has been clear in the statement of expectations about what it expects on the role of enforcement action. Do you agree with that?
Yes, I do. It would be helpful if we could have that
back
up
on the screen.
please.
Yes, of
Thank
course.
you.
It's ASIC 0800 0016 3087. And perhaps if I could direct your attention to paragraph 8, the government expects ASIC to use its full regulatory toolkit and to direct a substantial proportion of its resources to surveillance and enforcement. Timely and effective enforcement strategies will deter misconduct and maintain confidence in the financial system. ASIC should clearly articulate publicly when it will and will not take certain enforcement action, so as to manage the public's expectations and to promote confidence in ASIC. Now, Mr. Shipton, can I ask you firstly, in the time that you have been with ASIC, do you consider that ASIC has used its full regulatory toolkit and directed a substantial proportion of its resources to surveillance and enforcement in the way contemplated by the Statement of Expectations?
The starting point is yes, but I do believe that there could be builds and improvements.
In what way, Mr. Shipton?
Well, I believe that we need to be using our enforcement tools more effectively and more on a more timely basis moving forward, amongst other things. And I also believe that we should be utilising new types of regulatory tools like supervision, on-site supervision, the close and continuous monitoring program that no doubt we will speak about later.
We will. What about considering that question based on your engagement with the matters highlighted by the Royal Commission? So I'm turning now to a period that includes prior to your time as Chair of ASIC. What observations do you have about whether ASIC has in the past used its full regulatory toolkit and undertaken timely and effective enforcement strategies?
I would say that there is certainly room for improvement as regards the timeliness of conducting and starting investigations and commencing legal proceedings. I would also hasten to add, though, that what we're talking about is essentially, because of the regulatory choices we have to make and the resource constraints in which we operate, in many respects, it's a binary choice. We can't do everything that we would like to do at a particular point in time. So I would comment in the past that decisions were made with that context in mind, but moving forward, I have certainly issued instructions that we should be utilising enforcement tools, particularly in relation to large financial institutions, more frequently and as quickly as possible. And that's why we've sought to accelerate our enforcement program.
You focused very heavily in that answer on the timely aspect of this statement. What about the requirement to engage in effective enforcement strategies? Do you have any observations to make about whether ASIC has engaged in effective enforcement strategies? And I want you to consider that question through the lens, in particular, of matters that you've seen in the Royal Commission this year.
So I think if I was looking at the word effective through that lens, I would anchor my response on deterrence, both specific and general. And I think, both through being informed by the work of the Royal Commission, but also in my observations returning to Australia, that the utilisation of tools with a particular and robust deterrent capability is something that needs to be utilised more frequently, more often, and as I said earlier, more quickly in relation to larger financial institutions as well as others.
In ASIC's submissions in response to the Commission's interim report, ASIC accepted that it needed to alter its enforcement priorities and practices within the financial sector, particularly for large financial institutions. Are the matters that you've just discussed the ways in which you believe that ASIC should alter its enforcement priorities and practices, or is there more to that?
Oh, well, there's a number of things to that. There's a number of areas that we are now actively working to accelerate our enforcement outcomes. Large financial institutions is one, but also in the wealth management space is another. And we have a range of areas that we believe there is demonstrable harm or threat of harm in the sector to consumers that we are working to prioritise.
So in what particular ways do you think that ASIC needs to alter its enforcement priorities and practices? Could you explain that?
We need to do more
Yes.
enforcement actions in relation to this misconduct.
So more of it. That's
More
the
of
answer?
it, more of it, and quicker, and more robust, utilising court-based tools, utilising court-based tools because that would be at the apex of the enforcement pyramid, as it were, and realising that in the case of a number of financial institutions or segments of the financial institution, that the previous tactics have not been as successful as we hope them to be, and therefore we need to up our ante and be more agile in the deployment of that enforcement tool.
So do I understand that answer to mean there needs to be more enforcement action taken by ASIC, it needs to be taken more quickly, and it needs to involve more court-based tools?
Yes, that's exactly right. The only limitation to that, of course, is resource constraints, but that is certainly our intent, and that was the intent behind some of the structural changes that we've put into place in and around enforcement and enforcement decision making. That was certainly the intent of the government and myself in bringing on board a deputy chair who has a leadership role in enforcement matters.
In the submissions that ASIC gave the Commission in response to the interim report, ASIC referred to a number of things that it's done already with a view to altering its enforcement priorities and practices. One of those was commissioning a review and analysis of your enforcement policies, processes and decision-making procedures, which you refer to in your statement as the internal enforcement review.
That's correct. That's one of the responses, yes.
And pending the outcome of that review, you've introduced a number of interim measures, which you refer to as the interim enforcement measures, which require decisions that might result in a matter not being litigated, where there is a prospect of litigation, being reported to a Deputy Commissioner.
To the Deputy Chair or another Commissioner, correct, yes.
And you also ASIC refers in those submissions to accelerating your enforcement activities through greater use of external expertise and resources. Does that include through ASIC's expanded wealth management project?
Yes, so there's a correlation between the deployment of that extra funding which we received in August,
yes,
and what is now termed the expanded wealth management program.
Now, I want to ask you a little more about the internal enforcement review.
Please.
You proposed to the other commissioners that an internal enforcement review be done on the 21st of September this year.
That's correct, yes.
And what made you make that suggestion on the 21st of September this year?
In part, some of the testimony that was being made at the Royal Commission, but also because it was an agenda item of mine from the very beginning of my tenure at ASIC to work with Mr. Crennan, the Deputy Chair, with enforcement oversight, to undertake a review. So this was always in the works, this was always an intent, this was always a plan of both Mr. Crennan and myself, but without a doubt that was catalysed into action because of to be honest, what I thought important testimony in the week leading up to that date.
So that proposal on the 21st of September was made a week after the conclusion of that 6th round of public hearings.
I believe my conversations, verbal conversations, were earlier than that, but it's around about that time.
And influenced, you say, by the evidence in those hearings?
I have been highly informed and influenced by the work of the Royal Commission throughout this last 9 months.
And it was also a week prior to the publication of the interim report. Was the impending interim report a factor in your proposal?
I can tell you honestly and sincerely, no.
Now, you suggested that Mr. Crennan, one of your Deputy Commissioners, lead the review.
Deputy Chairs, yes.
I'm sorry, your Deputy Chair. And on the 1st of October, which was the Monday after the Friday on which the interim report was published, you emailed Mr. Crennan about the review. Do you recall that?
Yes, I recall the email. I don't recall the exact date.
I'll bring it up onto the screen if it assists. It's ASIC 0079 0002 0029. So we see your email starting partway down the page on the 1st of October to Mr. Crennan.
Yes.
So the 1st of October, being that Monday after the release of the interim report, by the time you wrote this email, you had read the interim report?
Yes, I had. Yes, that weekend.
And you sent in this email to Mr. Crennan what you described as a first cut of the terms of reference for the review.
Yes, I thought that would be helpful for Mr. Crennan.
Now, at this time, what were your key objectives for the review?
The key objectives were, if I can sort of be prompted by my email, essentially to look at a root and branch review of how we made decisions in relation to about taking enforcement action or pursuing other alternatives, and making sure that we had the best possible decision-making processes and guidelines, and that we updated them to be what I hoped and I expect them to be the very best practice that we can apply.
So this is your first cut of the terms of reference. It then took a couple of weeks for the terms of reference to be finalised. Do you recall that?
Yes, I recall a number of discussions I had with Mr. Crennan and my fellow commissioners to finalise the terms of reference.
And they were finalised by the Commission, by ASIC, on the 17th of October 2018. Is that right?
That's right.
And that was after this Commission, the Royal Commission, had issued a notice to produce for the terms of reference for the review. Do you recall that?
Yes, I do recall that the notice to produce actually predated the finalisation, so that is correct, yes.
All right. Now, you've annexed a copy of the final terms of reference to your statement, and I'd like to take you to those, but first I'll tender this email, Commissioner.
Email Shipton to Crennan, 1 October 18, ASIC 0079 0002 0029, Exhibit 7.67.
The terms of reference are ASIC 0079 0007 0001. And we see, if we turn to 0002 in paragraph 2, that the review is forward-looking and designed to identify what changes should be made to the enforcement policies aligning with internal and external expectations of ASIC and ensuring ASIC obtains enforcement outcomes that are necessary for a fair, strong and efficient financial system for all Australians.
Yes.
And we see from paragraph 3 that there was to be an assessment of regulatory, supervisory and investigatory policies.
Yes.
Now, Mr. Shipton, what were the key changes between your first cut of the terms of reference and this final approved version?
I couldn't, off the top of my head, give you an analysis or document comparison between one or the other, except to emphasise that that first cut was written over a weekend with initial thoughts. It was a stream of consciousness, which I hope would inform Mr. Crennan, who had the pen on this particular terms of reference.
In your first cut of the terms of reference, you posed a broad question, which was, what are in practice the enforcement goals being pursued? Do you recall that from your email, Mr. Shipton?
Yes, that
I can
sounds
bring
right.
it back on the screen
Yes,
if that would assist
that
you.
would help, yeah.
Yes, back to ASIC 0079 0002 0029. And if we look at your paragraph 2B, you see your question, what are in practice the enforcement goals being pursued?
Yes.
Now, we don't see that sort of higher order question in the final terms of reference.
Yes.
Do you know why not? Why has that idea that you had about interrogating the enforcement goals that ASIC is pursuing not been incorporated into the terms of reference?
I cannot explain why that particular form of words is absent from the final terms of reference, but all I can say is that the spirit of the terms of reference is very much aligned with that sentiment.
I understand. What, Mr. Shipton, in practice, are the enforcement goals that you think ASIC should be pursuing?
Well, I have actually provided input to my colleagues on a range of different enforcement goals, and that input is presumably being processed. Well, not presumably. I know being processed and considered by my colleagues, which includes being more willing to take on enforcement actions, prioritising cases where I believe that there has been disregard or disdain by financial institutions to us or misleading conduct to us. I believe that we should be prioritising cases that should have will have meaningful, specific and general deterrence. I also believe that we should be looking very closely at cases where there is demonstrable conflict of issues that are at hand. I will pause there to make an observation because, of course, there is a crossover between enforcement goals being pursued, which is a strategic decision, and that strategic decision will be made by the Commission, and the terms of reference of the enforcement review, which is looking at an related adjunct to that, which is how do we have the processes and procedures to implement and give effect to those goals or strategies.
But do you accept that it's necessary to understand what those goals are before you can work out whether you have the tools to achieve those goals?
Absolutely, and that's why I have passed on to my colleagues what I believe are a number of goals. I have a whole range of different views on those goals, but equally, these procedures that we hope to adopt will endure as those goals will change, which of course they will over time. So what we're trying to do here by this exercise and related exercises, and that no doubt that we will come to, because this terms of reference is only in relation to the processes and procedures that apply to our enforcement and investigatory processes. Separate to that is changes afoot relating to the development of our overarching regulatory strategy, which includes enforcement goals.
Now, your goals as you've articulated them sound more like priorities that might shift at different points in time than enduring goals, such as to deter misconduct, to change behaviour. Is that right? Do I understand correctly? What you've articulated as goals are priorities?
Well, I think it's important to clarify that we're talking in this email. I was talking about essentially two things: best processes, structures, decision making on one hand, and secondly, priorities. Deterrence will always be a priority. Enforcing the law will always be a priority. But the tools that we approach and the tools that we apply to do that, and how we do that, how we deploy it, what resources we have at a particular point in time, will vary. So the processes will endure. The processes are designed to enable that change of strategy. But yes, of course, there are, as you allude, perennials in our world, and the perennial is the enforcement of the law. The perennial is the administration of the law. A perennial is to have deterrence, and a perennial is to make sure that we act against bad actions.
Now, ASIC has appointed a number of external people to assist in this task. Is that right?
That's correct.
You've appointed 3 barristers.
Yes, that's right.
An academic.
That's right.
And a Deputy Commissioner of the Australian Federal Police.
Correct.
And what is the role of that last person in this review, the Deputy Commissioner of the Australian Federal Police?
Well, we thought it would be very good to have an investigatory input into it and a law enforcement input, because we wanted to make sure that we had different angles, all of the angles covered. Because, of course, when one thinks about our enforcement processes, it includes an investigatory component to it, and we thought that there would be no better a person than a senior police officer to provide input and guidance on that.
Will the product, the product of the review be a report, Mr. Shipton?
The product of the review will be proposals to change our internal practices, guidelines and procedures, and if necessary, terms of reference of our enforcement committee, which is the principal decision-making forum for enforcement matters.
And when will those proposals to change practices be available to the Commission, our Commission?
This is of high importance to us. that we would like to get these changes and proposals to the Commission, your Commission, as soon as practicable. In fact, what we have done is accelerate the timing. The original timing was going to be in the new year, but because we believe that it's important that you, the Royal Commission, have sight of these, that we're bringing it forward to December time, hopefully before the holiday season.
What time in December are you anticipating being able to provide this to us, Mr. Shipton?
I believe that we're aiming for mid-December, but please be assured we are working as quickly as we possibly can to get it done as soon as possible.
Have those undertaking the review communicated any preliminary views to you?
No, they haven't communicated any preliminary views to me. I have nonetheless been speaking to Mr. Crennan about progress and his interactions, and I've nonetheless submitted my thoughts to Mr. Crennan and to my other commissioners as well, and no doubt I will be getting feedback very soon on that.
So has Mr. Crennan indicated any preliminary views on his part or of those assisting him to you?
Not preliminary views, no. It's been at this stage me providing inputs to them at this stage.
So have there been any preliminary concerns communicated to you about your existing policies and processes?
There has been a comment that we need to be mindful about entrenched conventions or practices that have come into existence, and ensure that those practices are practices that are rooted and grounded in a procedure that we want them to be. And I think that's a very astute finding and area to watch out for. And in fact, I had an early conversation with Mr. Crennan about this, that we also have to be mindful that practices and conventions build up in institutions, and that we have to test and challenge those practices to ensure that they are actually adhering to guidelines that we believe to be appropriate.
What sorts of entrenched conventions or practices were being referred to?
I haven't gone into that level of detail with Mr. Crennan, except to say that I understand that ways of doing things or default thinking often in any organisation because it is very common. And I've experienced that over working in the public and the private sector over many years, that because it's been done way in the last time that we had a matter like this, we'll do it the same way again. That was the type of thing that I asked Mr. Crennan to be mindful of, and Mr. Crennan has given me feedback essentially to say that is a very appropriate thing to be watching out for.
Mm-hmm. Has Mr. Crennan or those working with him signalled any changes that they're considering recommending?
Not to me. Again, I provided inputs to them, and I understand that they're working very hard, reviewing processes, sitting in on meetings, and investigating and interrogating and interacting with decision makers and people in the processes, including at sort of the very initial stage, the very end stage. And so at this point in time, given that degree of interrogation and deep diving is taking place, I'm leaving it to those professionals who I have every confidence in to do that research, and no doubt when that deep dive, that deep interrogation is finished, they'll come back to us as a commission.
I also mentioned the expanded wealth management project to you, Mr. Shipton, and I think you agreed that that was part of ASIC's acceleration of its enforcement activities. When was the wealth management project originally created?
I do not know the exact date, but I believe that it has been in existence for quite some time. I would imagine a number of years.
And it was created to focus on investigations and enforcement action concerning wealth management operations of the major banks AMP and Macquarie?
I believe that was a significant part of their original work, yes.
And historically it's been funded by the Enforcement Special Account, or the ESA?
That's correct, yes.
Can you explain what the enforcement special account is?
Yes, I can. The enforcement special account is a special funding reserve that is given to us, appropriated to us by the government to allow us to undertake significant enforcement matters, and it is, let's call it a sequestered funding arrangement so as to ensure the independence of our enforcement decisions from government. In other words, it is not tied to the appropriation. It is permanent funding and is our funding that we don't have to use or lose on an annual basis.
And in August this year, the government announced a package of additional funding for ASIC.
They certainly did, and that was in response to what I call a surge strategy that we came to in March, April of this year.
Can you explain what you mean by a surge strategy?
So early in my tenure, I determined within 3 or 4 months of arriving in the role that ASIC needed to pivot to new approaches. One of those approaches was that we needed to accelerate our enforcement outcomes. We needed more resources to get the case book through as quickly as possible. But in addition, I also identified and proposed to my fellow commissioners that we adopt new supervisory strategies and new approaches, amongst other things, with regulatory technology and a focus on corporate governance.
So the package included $26.2 million to accelerate and increase the intensity of ASIC's enforcement activities and enhance its capacity to pursue actions for serious misconduct against well-funded litigants through the enforcement special account.
Correct.
And has that funding been used to expand the wealth management project?
Yes, it has been used directly to expand that.
And the expanded wealth management project will investigate and address issues that have arisen from the Royal Commission?
Yes, amongst others, correct.
And an early suggestion by Mr Mullally, the Senior Executive Leader of Financial Services Enforcement at ASIC, was that the expanded wealth management project be called the Royal Commission Response Team. Are you aware of that?
Yes, I did see that proposal in an email correspondence, which was not directed to me, but that was a proposal, as I understand it, of a number of different names.
Because the expanded wealth management project is going to deal with matters raised by the Royal Commission which ASIC was not otherwise investigating.
I would put it a way that we have been investigating or aware or undertaking regulatory work on a range of different matters which were subject of the Royal Commission. The way I would describe it is that obviously we are informed by the Royal Commission and the matters at hand that have been raised at the Royal Commission are each individually being re-evaluated if an investigation is not already underway, or it's a matter of surveillance, or the investigation was suspended for whatever reason. We are undertaking a project to re-evaluate each and every case that has been mentioned at the Royal Commission to ensure that we are getting the right approach to it.
But there are a number of matters that have been raised by the Royal Commission which are going to be examined by the expanded wealth management project which ASIC was not investigating. Do you agree with that?
Yes, I believe there were some matters of that nature.
Yes. Now, in the documents that ASIC has provided to the Commission about the expanded wealth management project, there are suggestions that this project is going to do things differently. How is the expanded wealth management project going to do things differently, Mr Shipton?
There is a number of ways. I believe Mr Mullally and also I have provided inputs that we should be thinking about more novel solutions to particular matters. We should be thinking creatively in relation to utilisation of other provisions of the Act. But above all, what we are doing is also asking ourselves in each and every occasion, should we be pursuing court-based enforcement actions for these matters. We also have a particular intensity, and this is a broader goal of mine, a particular intensity in relation to breaches of Section 912D, the breach reporting provision. That is an area of particular focus, and rightly so. And we are also we're also recruiting, I believe, up to 40 staff to help on this project. We are also going to be utilising specialists like IT specialists, forensic accountants, and so on with this funding. And finally, I understand that what we are doing differently is briefing junior counsel, for instance, to undertake banning order actions which ordinarily would have been undertaken by ASIC staff, in other words, freeing up resources. So we are doing things differently from how we handle a matter from a work basis, but we're also applying new ideas, new methodologies. And the final point that I've said to Mr. Mullally on this, we should be thinking about sequencing the publication of our enforcement or going live with our enforcement matters. In other words, there has been a convention or a tradition or a business practice whereby everything in relation to a matter, in relation to an entity, is gathered up and all of the different component parts are gathered together. I've encouraged Mr. Mullally, and he agrees, that if there could be a component of the broader issue, that there could be an action or a court action that could be separated, that we wouldn't wait for those other component parts to be finished if that investigation was complete and we were good to go.
I want to ask you some questions about how ASIC decides what to do when it's formed the view that a financial services entity may have engaged in misconduct. Do you understand?
May have engaged.
Yes. Now, I'll come back to that and why I've used those words, but I want to start by understanding who the principal actors are within ASIC who deal with misconduct and how responsibility is divided across the different teams. You have stakeholder teams within ASIC?
Yes, we do.
And what do they do?
They're basically teams that are responsible for surveillance and supervision. They are best described as non-enforcement teams.
And what do your enforcement teams do?
Well, the enforcement teams conduct a number of things. They conduct investigations into potential breaches, and they pursue litigation, court-based litigation, administrative action, enforceable undertakings, and they run that let's call it legal process.
And the Enforcement Committee, which you've referred to in your evidence already, can you explain the function of the Enforcement Committee?
The Enforcement Committee is the main decision-making forum for significant or major enforcement matters.
And who is on the Enforcement Committee?
There are the commissioners and a number of SELs, senior executive leaders.
Now, I want to understand in a broad sense how these teams interact in respect of enforcement activities and how decisions are made at each stage of the process. And I want to do that by reference to ASIC's information sheet 151. I'll bring that up, and it's an exhibit to your statement, ASIC 0902 0001 0067. Now, this information sheet represents ASIC's current approach to enforcement.
Yes, current, and this information sheet is under review by the enforcement review at the moment.
Yes, but as of today, this document reflects your approach to enforcement?
Yes, but I would quickly add that the interim measures are an important addendum to this.
Yes, I understand. Now, I want to ask you to look at 0068, which contains a flowchart depicting ASIC's approach to enforcement. And this flowchart shows in summary form what happens after ASIC receives a report of misconduct.
Yes.
and it records a number of important decisions made at different points in the life of a matter. And the first is whether or not the potential misconduct that's been reported falls within your regulatory responsibility.
That's correct, and that really goes to a jurisdictional
Yes.
question.
And if it does, then ASIC proceeds to conduct an assessment of the matter by reference to the factors indicated in the first white box.
Correct.
Now, who undertakes that assessment? Is that the stakeholder team?
Well, it depends where this report comes from, and if you look at the very top line,
Yes.
there are different points of entry
Yes.
for these reports or complaints. They can be given to us by external parties, they can be given us by a breach report, or they could be discovered in our own work.
So a breach report. Who undertakes the assessment for a breach report matter?
A breach report would come into our breach reporting team.
Right, I see. So the type of report that carries the allegation of potential misconduct determines who it is who assesses the matter.
Yes, so if it comes in, the very initial response would be whoever is the ASIC team receiving that information. Again, it could be a report or it could be a discovery by ourselves.
Mm. And then the next decision that's made is whether a formal investigation should be held.
Correct.
And is that decision coextensive with the decision about whether the enforcement team will accept a referral from the stakeholder team or whichever team has conducted the assessment?
Yeah. So that really is a question. Well, firstly, there is an assessment by the team. Often with the breach reporting team, they will then hand off or liaise with the relevant stakeholder team. So there is an important coordination with the relevant party and the relevant entity or the relevant group. So decisions are not made in isolation. There is interaction and coordination, and then whether or not a decision to conduct a formal investigation is essentially the formal nature of that is the decision, the formal referral process. But as I said before, there is interaction and liaison with not only stakeholder groups, but often enforcement colleagues to get their advice and guidance, and often legal colleagues to get their inputs as to legal matters.
If a decision's made to hold a formal investigation, that's led by the enforcement team, is that right?
Correct. So there's a referral process, duly documented, and then an investigation will be conducted by the enforcement team.
And from what you've seen in your role so far, including through the evidence in the Royal Commission, do you think ASIC has failed to commence formal investigations against large financial institutions when it ought to have done so?
I wouldn't agree with the word fail. What I would make the observation is that we get approximately 2,000 breach reports a year. We get, I think, approximately 12,000 complaints a year. And we have approximately 240 staff in enforcement. So we have to make real-time decisions as to which matters we can investigate. I would not consider the very difficult real-time choices and very hard choices as a failure. And to put that number, I think it's important to give context, and this isn't a like for like, but when I say 240, without reference, that doesn't mean anything. So again, this is not a like for like reference, but we have less staff in enforcement of that 240 than there are sworn police officers in the Australian Capital Territory. In fact, there are nearly 3 times as many sworn police officers in the Australian Capital Territory than we have staff members in enforcement. Now, I just say that not because it's a like-for-like reference, but to give you a context of the volumes, the tens of thousands of complaints we receive, the number of resources that we have, which means we have to make very difficult choices. So I don't think that's a failure. What I do think, though, it is a very difficult process to make the right decisions, and that's why we are reviewing the processes around our decision making in this area.
What sort of proportion of the 2,000...
Reviewing them on the basis that whatever their outcome, it's not a failure. Is that the premise?
Not a failure.
From your answer, Mr. Shipton, and it's a very odd conclusion.
Commissioner, I would say that it's a restriction. Without a doubt, we have to make regulatory choices. I don't...
Understand that. I well understand that. Yeah. Yes.
The 2,000 breach reports that you said come in a year, what rough proportion of those come in from the major financial institutions?
I do not have that number at hand. Can I also highlight that we have had a nearly 40 to 50% increase in breach reports in the last couple of months?
Now, Mr. Shipton, prior to the evidence that was given by NAB in the first round of hearings in the Royal Commission in March, had ASIC contemplated investigating NAB for its conduct in overseeing its introducer program? I do not believe that was a decision to expand that investigation. That decision at that time, that decision was made, I believe, only in the last couple of months. In the last couple of months.
Yes.
So do I understand from your answer that ASIC had not contemplated investigating NAB for its conduct in overseeing the introducer program prior to the evidence?
Contemplation. Let me just sort of say a decision was made. So that it was contemplated, but a decision was made, as I understand it, to focus in on the wrongdoing of the individuals and to investigate the individuals, and that investigation is continuing.
Yes.
That investigation was expanded to include NAB in recent times. So yes, there was a contemplation, but there was a decision, again, with resource constraints in mind, also in mind that there was a number of other things going on at that time, and that's why I was talking about resource constraints and the regulatory decisions that we have to make. But I will most certainly say that we should have made that decision earlier.
Was that a failing, Mr. Shipton?
That was unfortunate, and that would have been a decision that I would believe should have been made otherwise. So that was highly regrettable.
You're reluctant to call it a failing.
I'm
Mr.
reluctant to call it a failing for the following reason. The reason why I'm reluctant is because it was a reasonable held view at that particular point in time to make that decision. A reasonable regulator would make that decision. That doesn't mean that I myself would have made the same decision, but what I am saying is that it was reasonable in the circumstances at the time, but it is not something that I would have decided myself, because I believe that we should be acting quicker when it comes to financial institutions. And that's why, and looking not just at the bad apple, but looking at whether the barrel is faulted itself.
I want to challenge that statement you've just made, Mr. Shipton, that a reasonable regulator would have made that decision. And I want to do that by referring to the material that was before ASIC when that decision was made. NAB had lodged breach reports notifying ASIC that multiple bank employees across multiple branches in the Greater Western Sydney area were accepting false documents in support of loan applications and were falsely attributing loans as having been referred by NAB introducers in order to obtain commissions.
Yes, that is correct. And I will reiterate that I would have made a different decision, but I do have received representations and explanations as to what was going on at the time, And it was not an unreasonable reliance to, at that particular point in time, that the team were relying on, I believe KPMG were undertaking a review of NAB. The fundamental point is, I would have done this differently. That's the fundamental point.
That's your fundamental point, Mr. Shipton. It's not mine, because you don't personally make each of these decisions. You oversee an organisation in which numerous people make these decisions. And you tell me that it was a reasonable decision, a reasonable regulator would have made that decision despite NAB having given you that information in its first breach report and then lodging a second breach report with ASIC on the 31st of August 2016, which made clear that the conduct was even more extensive than that covered by the first breach report.
I do not disagree with the facts, and I am disturbed and disappointed by the facts. That is why, you're right, I can't make every decision, but that is why processes and decision-making structures are so important. And that is why I was explaining to you the difference between processes and decision-making structures and strategy. ASIC needs to do a better job on both. That's my key point here. When I came and took up this role, that was a key part of my reform agenda, because I cannot make every single decision. So how can I look at a case study like this and do my level best to ensure that it doesn't happen again? And that level best is having improved processes and procedures, decision-making structures, that's the enforcement review and some other things that we're doing, but equally being very clear at a commission level that we have a strategy and the priorities clearly articulated so that when these decisions are being made, that type of decision wouldn't happen again.
Why is it that a decision was only made, did you say a couple of months ago? Is that what your evidence was before?
Yes, that's as I understand it.
Why was it that a decision was only made a couple of months ago, given the evidence that was given in March this year in the Royal Commission hearings, to commence an investigation into NAB for the introducer program conduct?
Because it was clear from the evidence that was put before the Royal Commission that this matter needed to be reviewed, and we made the right decision, and I will grant and I will concede that that decision was made too late. That to me speaks exactly to the point that I raised before. We need better decision-making structures and we need a better strategy.
Well, I want to show you an email chain from mid this year that explains the types of considerations that came into play when ASIC began to consider, after the hearings in March, whether it could take enforcement action against NAB. So I'll show you ASIC 0076 0006 0279. Now this is an email from Kevin Fu, the senior manager or a senior manager in the deposit takers, credit and insurers stakeholder team, to Mr Sadat and others within ASIC on the 16th of July this year. And Mr Fu says to Mr Sadat, further to the FSE catch-up on Thursday last week, the NAB loan fraud matters were before the Enforcement Committee today. The full commission was there, including Daniel Crennan. Although supposed to be an update on FSE's GWS, Greater Western Sydney banning actions, the discussion turned to the Royal Commission and what action we should or could take against NAB. The Enforcement Committee asked why we have not taken action against NAB. Comments from FSE, Peter Kell, and myself included. The matter was breach reported to ASIC in a fairly timely matter, although the Royal Commission suggested otherwise. NAB has taken the matter seriously. We're conducting a wider review, having their internal review tested by KPMG and developing a remediation program. These are the things DCI would have asked for if they were not already doing these. We have reviewed KPMG's review and are comfortable they have done a reasonable job, or not a bad job, to cause us concern. The conduct was viewed as particular employees defrauding the bank. FSE has taken action against the individuals. NAB is not the only bank that has a loan fraud problem. Although Peter suggested we be careful not to relay any message, the loan fraud is not a very small minority of behaviour. FSE has taken other action that has penalised loan fraud and banks' responsibilities, Asander ANZ. Kathy, the Enforcement Committee Chair, was of the view that we should seek an enforceable undertaking from NAB with a community benefit payment. What do we have to lose from doing this? James and John were supportive on taking some action against NAB to send the message that dealing with loan fraud is important. Peter wanted to test these ideas and tempered the discussion with comments that taking no further action might be the right decision. We just need the right narrative. That was the discussion between Mr. Sadat and a senior manager in your deposit takers, credit and insurers team and others in July this year.
Yes, that's correct.
Do you have any observations to make about what I've just read to you from that email, Mr. Shipton?
My observations was that there was a discussion around the next steps in this matter, and there was a range of different views in relation to this matter, and that the view to proceed with an investigation, whilst not on this document, ultimately prevailed.
Well, but what does it say to you, Mr. Shipton, the list of matters that were given in response to the question about why we have not taken action against NAB? Let's go through those. The first was that the matter was breach reported to ASIC. There was a legal obligation on the part of NAB to do that, was there not?
Yes, there is a legal obligation.
So should that have had any bearing on whether or not action should have been taken against NAB?
Of course it should.
Of course
it should have a bearing. It
should have a bearing.
Yes, because if there's a report of a breach, we should be looking at that breach.
Oh, I'm sorry, you've misunderstood my question. In deciding whether or not to take action against an entity, yes, is the fact that the entity complied with their legal obligation to tell you about the conduct a factor that bears either way on whether or not you should take the matter further?
Stepping out of this particular case study, a factor as to the helpfulness of a subject is a factor in consideration. That's part of our regulatory guide. But stepping back into this, I am of the view, and this is clearly reflected in this particular exchange, I'm clearly of the view that we need to be taking action against NAB. This was a view expressed by one person as it is minuted. I cannot speak for Mr. Fu and his interpretation, but this exchange is representative of exchange of different views which are being fleshed out. It was a conversation which I ultimately observe landed in the right place.
But the considerations that went into the decision that at this point did not land in the right place, Mr. Shipton, this was not the point at which a decision was made to pursue NAB. I'd like you to reflect on whether these are the matters that you want your people to be considering when making these decisions. And I want to pick up on something that you said, which was that the helpfulness of the organisation is a relevant matter in deciding what next step ASIC should take. That was what I understood you to say? Yes,
but I was stepping out of this case study and just referring back to, and that is one matter in our 151 regulatory guide.
Well, is providing ASIC with a breach report something that you would describe as a helpful thing that should be taken into account?
No, and that's why I was stepping outside of the case study.
So what do you say then to the fact that the fact the matter was breach reported was one of the considerations in what to do with NAB at this time?
I cannot speak for the person who said that.
No, I don't want you to speak for them. I want you to reflect on what we can see from this email were the considerations.
Well, again, all I can say is that that was not my view, and this note articulates that that was not my view, and I do not agree with that consideration. And I personally dismissed, and ultimately we dismissed that view.
But the bottom line is, literally the bottom line on the screen is, develop an options paper about what action we could take against NAB and the narrative for each.
That's correct, Commissioner, but I would also say that there was then decisions that were ultimately made that had this action being pursued by an investigation. So the right decision was landed upon. I think this case study is a good case study to make my broader point that we need to improve our decision-making processes and our criteria that goes into how we make these decisions. And that is the very purpose of our review, so that we can sharpen up, guide and direct, so that these types of what we would all agree would be extraneous, unnecessary considerations don't enter into the conversation.
Well, could I invite your attention to whether any of the following considerations appear in this report of the meeting? First, as to the conduct, is there any examination of the seriousness of the conduct?
Commissioner, I just want to highlight that this, as I remember correctly, this was not the main purpose of this particular meeting. This meeting was all about the investigation in relation to the individuals. The conversation then went more broadly to NAB, the organisation, and there was a conclusion that, as I remember, that came out of that, which was to look not just at the not just the individuals, but to look more broadly at NAB. And that happened, I concede, that happened too late in the process, but it is happening.
Well, when you come back to my question was, do we see in this record of the meeting any consideration of the seriousness of the conduct?
Not in this record of the meeting, but this is not an official record of the meeting, but I grant it is a record of the meeting. But there was, in my recollection of the meeting, an importance to consider and act against NAB to investigate the fact that their dealings and how they handled loan frauds was extremely important.
Do we see any consideration of the prevalence of the conduct?
Not on this particular conversation.
Do we see any consideration of the size of the actor involved, namely the size of NAB?
Not in this consideration, but Commissioner, again, this was not a formal decision point for this particular element. What happened as a consequence of this conversation were those decision points that you raised. Those issues that you rightly asked were addressed at a later point in time.
In the context of an options paper, which was to address specifically the option of doing nothing?
That was presumed. I don't recollect the option, but I do recollect and can confirm that we are doing something so that the ultimate decision was the right decision, and I agree with you that it happened too late, and we should have been discussing at a much earlier stage, in fact I would say years before this, the potential wrongdoing by NAB.
The document records, Mr. Shipton, that Kathy Armour, the chair of the Enforcement Committee, was of the view that we should seek an enforceable undertaking from NAB with a community benefit payment. You recall that?
I don't recall, but I don't recall that myself, but that is clearly Mr. Fu's recollection.
And was that an appropriate response?
Again, I can only say that a number of views were expressed, were thrown out in this discussion, which was not a formal decision-making point for this aspect of the investigation, but clearly catalysed the formal extension of the investigation to include NAB. I think that's very important. This was a discussion around that aspect that led to more formal expansion of the matter. This was a very initial and premature discussion, admittedly happening far too late in the broader process, and a number of options were clearly suggested according to the narrative in this email. Again, those options that ultimately were not pursued.
So it was an initial and premature discussion more than 2 years after the breach report was received, the first breach report.
I'm more than happy to say once again, this initial discussion happened far too late. The formal discussion and the formal decision making happened far too late.
And what do you say to the sentiment recorded in this email in response to the suggestion that an enforceable undertaking with a community benefit payment be sought? What do we have to lose from doing this? What do you say to that, Mr. Shipton?
Well, if that was said, and again, I don't recollect that being said, but if that was said, that does not align with my line of thinking, nor does it align with our current practice that we have in place, which is to ask ourselves the question, why not litigate these types of situations? And in my view, and I expressed this when this conversation was happening, we should be pursuing much harder, much tougher action, and we ultimately did.
It's the antithesis of that, isn't it, Mr. Shipton? The view that's expressed here, let's not investigate further, let's just ask NAB for an enforceable undertaking with a community benefit payment. We've got nothing to lose from doing that, and we'll then be seen to have publicly responded to the evidence in the Royal Commission.
Well, that was a view that may have been a view expressed. Again, I cannot respond with absolute confidence as to what was said. All I can say is that there were, from my recollection and from what Mr. Fu writes, a range of different views which were thrown around, views which were explored and tested, but ultimately we decided to pursue an investigation, and an investigation has commenced in this matter.
Well, the view that I've directed you to was the view of the chair of your enforcement committee. Does that concern you, Mr. Shipton?
It is a view that I do not agree with. It is a view that clearly that I suggested an alternative approach. All I can say is that this was that's why I use the expression premature, because there was not, before the committee at that particular time, a broader, more thought out, more thoughtful and more structured discussion in relation to NAB itself. That came later. It came too late, but it came later. I think we should just put an element of caution of reading too much into this discussion, which was at a, albeit late occurrence in the timetable, but nonetheless was not a fully informed one, and that ultimately, when an informed discussion took place, the right decision was made, and that was to pursue an investigation and not to pursue an enforceable undertaking.
Well, I want to return to enforceable undertakings and Ms. Armour, the chair of your enforcement committee's role in enforceable undertakings tomorrow. For now, I'll tender this document, Commissioner.
Email July 18 from Mr. Fu of ASIC concerning NAB lawn fraud matters, ASIC 0076 0006 0279, Exhibit 7.68.
I apologise, Commissioner. I see we've run quite late. It may be useful to start earlier tomorrow. A 9:30 start would be helpful.
Yes, is it possible for you to be here at 9:30, Mr. Shipton?
Of course, Commissioner.
9:30 tomorrow then. Yes, Ms. Hall.
Mr. Shipton, at the end of yesterday, I was asking you questions about ASIC's approach to investigations. And I had asked you questions about the investigation of NAB in relation to the introducer program. I want to ask you now about ASIC's handling of another matter, which was CBA's mis-selling of consumer credit insurance. You know that there was mis-selling to tens of thousands of customers by CBA?
Yes, I'm aware of that.
And prior to the evidence that was given by CBA about those matters in the first round of public hearings in the Commission, had ASIC taken any enforcement action against CBA for those matters?
No.
As at today's date, has ASIC taken any enforcement action against CBA in respect of those matters?
Not as today's date, no.
When did ASIC first commence an investigation into those matters for the purposes of considering whether to take any enforcement action?
I believe that a referral was made in October of this year.
So it was, according to your statement, about a month ago on the 22nd of October, nearly 2.5 years after the notification by CBA and months after the matter was examined in the public hearings in the Royal Commission, that your enforcement team accepted that referral.
That's correct.
And that investigation will consider now whether any enforcement action should be taken against CBA?
Yes, that's right. And may I add that we were waiting for a review that was being undertaken into that business, which finished, as I remember, in September. So following that independent review by an independent firm, that review came in September, and then the referral went through in October. And as I understand it, that independent review will form part of the evidence as a part of the investigation.
Why were you waiting for that review, Mr. Shipton?
I understand that we were waiting for that review because that review was going to be important to the body of evidence.
Important to the body of evidence brought together as part of the investigation. Is that right?
Could you please repeat the question, please?
I just want to distinguish between the decision to commence the investigation, which was not made until the 22nd of October this year. I want to distinguish between that and the evidence gathering process within the investigation once it's commenced. Why not commence the investigation much earlier?
Well, I would certainly agree with you that it was a mistake not to commence the investigation much earlier.
When should it have been commenced, Mr. Shipton?
It is difficult for me to say with absolute precision, except to say that I think we should have been commencing an investigation along the same timeline as we were working, as I understand it, very hard on a remediation program.
So the notification of these matters by CBA to ASIC was in May 2015. Should ASIC have commenced an investigation into those matters following that notification?
I believe that it was a mistake not to give thought, let me rephrase that, it was a mistake not to give enough consideration to commencing an investigation at a commensurate time to the notifications and the awareness of the issue, and to run an investigation in parallel with the remediation program. And if I may add, that if this matter or those facts were to present themselves today, then the processes and the questions that would apply would most likely trigger the commencement of an investigation.
And why didn't they in 2015, Mr. Shipton? You've been asked to reflect on this matter for the purpose of preparing your witness statement. Why didn't that happen in 2015?
Well, I understand that I've been, and this is what I've been told by the team because I wasn't involved in the matter at the time, I've been informed that there was a focus on the remediation of CBA. I'm also informed that this was an industry-wide challenge, that we were dealing with industry-wide issues. And if I remember correctly, we're dealing in the CBA matter with approximately 156,000 customers who are literally out of pocket because of this concern, and that this was a systemic issue across the entire industry. And as I understand it, at that time, there was a focus on industry-wide reaction. And as I also understand it, there was a focus on trying to advance the remediation, advance industry change, get independent reviews on 11 financial institutions involved. But I most certainly agree that the investigation component should have started much earlier. And my last observation is, when you're dealing with industry-wide, arguably systemic misconducts and systemic mistakes and failures of the financial institutions, we only have about 80 personnel in the team that handles that issue. So the context is that this was an overwhelming amount of work being dealt with by a team which is only staffed to 80 people.
None of the things that you've just referred to in your answer to my question, Mr. Shipton, precluded you from commencing an investigation into CBA for the purposes of considering enforcement action, did they?
Correct. And I have already conceded the point to the earlier question, if I remember correctly, that I've said that it was a mistake not to commence that investigation at that time.
Yes, and I'm just trying to understand why that mistake occurred. That's why I'm asking you these questions, Mr. Shipton. Do you agree that the matters that you referred to, the fact that this was an industry-wide challenge, the fact that 156,000 customers were out of pocket, the fact that this was a systemic issue, were all matters that reinforce the need for you to take strong action and commence an investigation?
Most definitely, and I believe I've been saying that throughout all of my responses. So I'm in most definite agreement that it was a mistake not to commence an investigation at that point in time.
What confidence can we have that those same matters arising today would not have the same result, would not lead to a focus on remediation to the exclusion of enforcement action?
Well, and if I may, I would like to reflect upon the NAB case study and this CCI case study in answering that question. Because we have today processes that would mean that we are asking the teams very different questions than they were asked at that particular point in time. We now have processes today that have been instituted that did not were not in effect or in place at that particular time in both NAB and in relation to the CBA matter.
I want to be very clear about
Yes.
the point in time that you're referring to in your answer, Mr. Shipton, because the point in time in relation to CCI was May 2015. The
Yes.
point in time that I took you to in the NAB case yesterday was July this year.
Yes, and so I'm referring to the interim measures that we've put in place very recently, I think within the last 3 or 4 weeks.
I see.
And so today, these matters would be handled very differently. And I'm deliberately using the word mistake because I believe that there were mistakes made in relation to the NAB introducer. I believe that there were mistakes made in relation to this CCI matter. And I use the word mistake deliberately because mistake, in effect, constitutes a misguided decision, because there was, and this is answering your direct question on why you should have confidence that it's different today, because we now have issued guidance that would mean that a decision like the one in CCI, or the discussion that you were referring to in relation to NAB yesterday, would have a very different starting point. The starting point today would be to ask the question and turn our minds to why not litigate this demonstrable breach. That is the clear guidance today that stands today.
And that's as of a few weeks ago.
That is of 2 or 3 weeks ago, yes.
Yes, I see. All right. Now, I want to come back to information sheet 151 and the flow chart of the process followed within ASIC in relation to enforcement action. So if we could go back to ASIC 0902 0001 0067, I had paused in taking you through this flowchart to ask you questions about investigations. But if we continue through the flowchart, we see that if a formal investigation is conducted and ASIC does not find suspected misconduct, ASIC then considers whether non-enforcement regulatory tools such as surveillance or stakeholder engagement might be more effective.
That's correct.
And if the result is that the investigation does find suspected misconduct, then ASIC moves to assess what the appropriate remedy will be.
So you're now looking at the yes flow.
Yes.
Yes.
Having found suspected misconduct, you're directed to the white box towards the bottom of the page, which requires an assessment of the appropriate remedy.
Yes.
So, is it only at the point that ASIC has completed its investigation into potential misconduct that it moves to assess the appropriate remedy?
Well, that would be a point in time in which it is assessed, but there would be, in practice, a continuum and an assessment and a formulation of thinking around what would be the appropriate approach. I think that you would add, it would be best to add the words investigate different contraventions as well as remedy. I would add that. This chart is drafted, as I understand it, for brevity and for simplification, but it is remedy and also an investigation or assessment as to the potential contraventions and breaches.
I'm sorry, where would you add the words investigate different contraventions in the flowchart?
Well, all the way through, but you're asking me about assessment of appropriate remedy.
Yes, I am.
And what I'm saying is that is coexistent with the alleged or potential contraventions.
But is the appropriate time to assess the appropriate remedy at the conclusion of your investigation?
Yes, it is, and that's why I think that's why I was referring to it being a continuum and an ongoing assessment. Again, this flowchart is a very simplified version of the process and is drafted, as I said, for brevity.
I understand that. I'm just asking you to assist me to understand what the point is at which that assessment of the appropriate remedy should be made. And I understand you to say it's appropriate to do that at the conclusion of the investigation.
Yes, and I also understand from reviewing files and also discussing with team members that at the point of referral, then there is discussion, there is reference made to not just the appropriate remedy or course of action or potential, let me say potential course of action, but that is coexistent, as I said before, with the contraventions, the potential contraventions that we're looking at. And I'd also add that these processes aren't rigid. The teams have to exercise professional judgment throughout, and that throughout the course of an investigation, and then throughout the flow of the entire matter, professional judgment needs to be exercised and assessments can change, new evidence can be obtained, and new courses of action can be followed.
The project team that assesses the appropriate remedy makes a recommendation about that. Is that correct?
Yes, that's correct.
And the ultimate decision about the action or outcome or remedy is made by either a senior executive, a commissioner, or the enforcement committee.
That's correct, depending on the classification of the case.
So what sorts of matters are significant enough to require decision by a commissioner?
Well, it would be preferable, and this is now the case, that significant matters should be channeled towards the enforcement committee, and we are also moving away from commissioners making executive decisions in relation to these matters. But returning to this particular case study and the the procedures that existed before this change that we're transitioning, serious matters, major matters, are the ones that are escalated to a commissioner, commissioners, or the enforcement committee.
Now, the final row on the page, on the flowchart, tells us that the appropriate remedy will depend upon the purpose sought to be achieved, whether that be a punitive purpose, a protective purpose, a preservative purpose, a corrective purpose, or a compensatory purpose. Is that right?
That is how it's drafted at the moment. And again, I'll just quickly add that this draft and this entire document is under intense review with our internal review.
I understand that, but this is the current system. I understand it's under review, but I want to work with what your system is presently, and the appropriate remedies are assessed depending on which of those purposes is to be achieved.
Again, this is a summary for brevity, written in part for public understanding.
Yes.
But that is how it is demonstrated on this particular slide. But if I remember correctly, from the broader document, it goes into much greater detail. And I believe, if I remember correctly, other matters like deterrent effect is also considered.
Yes, within these categories. That's how the document approaches it, within punitive, protective, preservative, corrective, and compensation.
Yes.
All right. Now, I want to ask you about these sorts of remedies listed in the line at the bottom of this page. But before I do that, I want to ask you a bigger picture question. ASIC's required to publish an annual corporate plan.
That's right.
And in the most recent corporate plan that you've published for the 2018 to 2022 years, ASIC has explained that it has a performance evaluation framework that sets out how it's going to measure and evaluate its performance. Is that right?
That's right, and that framework, as I understand it, was developed after the capability review.
And ASIC uses, according to that corporate plan, both qualitative and quantitative measures to evaluate its performance.
Yes, that's right.
And what measures does ASIC use to evaluate its performance in relation to enforcement?
That is a matter that I have already identified that is, I don't think, prevalent enough in that particular document. And I have already issued guidance to the team that when we develop this plan next year, that we should give more thought to the enforcement aspects of that report. So I agree with the premise of your question that there is an insufficiency of detail as regards our enforcement actions. If you wanted my observation on that corporate plan, from what I remember, implicit in the reporting is enforcement outcomes, but I most certainly am of the view that it should be explicit moving forward.
So, do you currently evaluate your performance in relation to enforcement with qualitative and quantitative measures, as the corporate plan suggests that you do?
Yeah, we do. That corporate plan is a plan that is produced specifically for the public domain.
Yes.
And what we are now doing is working on, and this is a body of work which will take some time because it does require, I think, some degree of engineering, is to develop a performance framework, not just for enforcement, but for our entire regulatory activities, that will better assess the performance of our enforcement teams, our regulatory teams, and every other team, because I do not think right now we have sufficient frameworks in place for that type of measurement and assessment.
So can I ask you to address my question about how you currently measure your performance in relation to enforcement with quantitative and qualitative measures?
Yes.
I understand you've got work to do and plans about what it might look like. How do you currently do that?
Currently, we have metrics which are produced on, I think, both publicly and internally about our enforcement outcomes. That is our clear sort of quantitative assessment. And then we have an annual review as a part of our strategy planning, whereby we do have feedback as the last stage of our annual planning cycle, our strategic planning cycle, where each team, including the enforcement teams, will have to provide feedback on their qualitative performance from the previous year. I will stop there, but I will say that I have some comments on how those processes could be improved.
Well, what are the quantitative metrics that you currently use in relation to your enforcement?
As I mentioned before, the quantitative metrics are detailed delineations of the types of different proceedings that we pursue, and those metrics were the metrics that I was updating for the Royal Commission yesterday and amending in my witness statement.
Okay, I just want to understand this in very simple terms, Mr. Shipton. Do you have targets for the number of each type of enforcement outcome that you want to take or pursue in a year? Is that what happens?
No, and this is the difficulty. It would be, I think, unwise to have targets in relation to enforcement outcomes, but those quantitative assessments are very informative as a guide over time as to where we are deploying our resources and our capabilities. And I think that is an important metric. I think another metric that we do, which is an internal on resourcing and staffing or activity, we monitor the amount of activity that we undertake in the enforcement space versus other parts of our organisation.
I'm sorry, Mr. Shipton, I'm still struggling to understand. Are the quantitative metrics measures of the number of types of enforcement action that you take each year? Is that what you measure presently?
Yes, once again, we measure year on year the number of cases, whether it's a criminal case, civil matter, infringement notice, banning order. We measure that on a case-by-case notice, and that is...
I understand, Mr. Shipton, you record what you've done. Let's go beyond the fact that you record what you've done during the period. How do you use the record of what you've done during the period?
That record then is assessed to reflect upon the usage of different types of tools, and I believe that that is a good metric to reflect upon, you know, the types of activity or the utilisation of, let's say, an enforceable undertaking versus a civil penalty. That is a retrospective guide for us to determine the future, and I think that's a very good benchmark. There are no targets. It is also a useful...
I just don't understand what you've told me, Mr. Shipton. I really do not understand what you have told me.
Well, I apologise for any confusion. We measure year on year the different types of...
You record what you have done.
Yes.
I'm with you so far. What do you do with the record of what you have done? You look at it, you assess it, you reflect on it. I understand all of that. But
yes.
What do you draw from the fact that this year the numbers are so? And if we go back, as this chart does, back to 2011-12, we see how they go through each of the years. What do we then do? What do you then do with the data that is assembled in that way?
Well, as I said, that, as I understand it, informs the team as to what has been allocated in previous years and in the past But I will also add, and I know this wasn't part of the question, but it's important to understand, I don't think we do enough with those metrics, and that is why I have asked the team to do more thought and give more consideration to how we can better utilize statistics and metrics like this.
What is it that you should be measuring to evaluate your approach to enforcement, Mr. Shipton?
Well, I think it starts with evaluation at the very start, and this is why, with apologies to the Commission, it's a complicated subject. Measurement of regulatory performance is a complicated area that every single regulator, in my experience, globally has struggled with. And that is why I want our organisation to give advanced, world-leading thinking to what sort of assessment and measurement frameworks should be applied. Very quickly, because I know I need to be brief, we should be starting with how the financial system is improving and performing as regards fairness and equity towards customers and adherence to the law. Once we develop those metrics, and assessments, both quantitative and qualitative, that will be a measure of our performance. Because if we are using the tools that we're applying, we are helping that improvement in the overall financial system, that would indicate our regulatory work, our enforcement work is helping. If that is not taking place, then that would be indicating that it is not working, and new ideas and methods and deployment of tools needs to be applied. This is a core part of what I'm trying to do with the reform agenda that I'm trying to take place, because I agree with your line of questioning that we do not have, at this point in time, sufficient quantitative and qualitative methodologies to assess our overall and individual performance, and that is something I am very committed to addressing.
Mr. Shipton, I want to turn to the remedies that you can pursue, again by reference to the items we see in the last line on this flowchart. The last item in that last line is a negotiated resolution.
Yes.
Now, one form of negotiated resolution that we've heard a bit about in the course of the year, and which you and I have already discussed, is an enforceable undertaking. And I want to come back and ask you some questions about that particular form of negotiated resolution. But other negotiated resolutions don't involve an enforceable undertaking. They instead involve an agreement between ASIC and the entity that the entity will take certain steps and that ASIC will not take any further action if the entity takes those steps.
Yes, they are from time to time, on a small number of occasions, entered into, yes.
A negotiated resolution is treated separately in this document from each of the purposes listed in the bottom line. It doesn't appear to be considered to be punitive, protective, preservative, corrective, or compensation. What is the purpose of a negotiated resolution?
I would say that if that is the impression from this brief flowchart document, then that's not the correct impression, because a negotiated resolution is designed, and procedures, our internal procedures reflect this, to have one or a number of those elements embedded in it.
So broadly, in what circumstances do you say a negotiated resolution is appropriate?
Well, a negotiated resolution right now would only be appropriate if there is a demonstrable if there is not a clear need to pursue court-based enforcement outcomes. Because as I've said, we now, as of today, have a process that we will first look at a matter and say, why not litigate? It's difficult for me to say, because this is all case specific, in what particular circumstances we would be addressing a negotiated outcome. It's very difficult for me to generalize.
I understand.
But I will say that there is a place for these types of arrangements. But I will also say that I have observed that we have overutilized and over-relied on these types of outcomes, and that is exactly why we have different guidance now in relation to our enforcement procedures.
Under a negotiated resolution, an entity might agree to create a remediation program. Is that right?
Most certainly, that is something that is a very common part of the arrangement.
And you tell us in your statement that since the 1st of July 2011, ASIC has negotiated a customer remediation program on 20 occasions.
Yes, I believe that's correct.
And you also say in your statement, you explain the lack of stronger enforcement action by ASIC in a number of specific matters that you dealt with in your statement by reference to the fact that ASIC's focus had been on remediation. You make that observation in relation to the mis-selling of the credit card insurance, in relation to Clearview's mis-selling of life insurance, and in relation to the NAB introducer program.
That's correct.
And in your view, has ASIC sometimes been too focused on customer remediation to the exclusion of enforcement action?
In some cases, yes. In some cases, I clearly am of the view that we should have tried to and worked towards running both the remediation program and the enforcement investigation at the same time in parallel.
Now, something that a financial services entity might also agree to as part of a negotiated resolution is to pay a community benefit payment.
That's correct.
And that's most commonly done, it seems, as part of an enforceable undertaking. Is that a fair statement?
Yes, that's a fair statement, yes.
And what is the purpose of getting a financial services entity to make a community benefit payment?
The purpose, essentially, is to ameliorate the wrongdoing and to provide a benefit to the community. It is, as I understand it, analogous to a community benefit order that we have under our legislation, and it is also a point that I personally believe provides some form of deterrent effect, because we are in effect making the organisation pay something that they otherwise would not have paid.
In exchange for not taking further action against the entity?
I would not describe it as an exchange, because that would connote that it's somehow a contract. What it is an arrangement whereby a body of different responses, remediation is one, community benefit payments is another, but a tremendously important part of the vast majority of enforceable undertakings is compliance programs and compliance improvement programs. So taken together, that is not an exchange, but that is the consequence of entering into a enforceable undertaking, because it does and is designed to have a consequence.
A different consequence from taking the entity to court.
Most definitely, and that's why right now we have a guidance and a process whereby we believe we should be asking ourselves whether or not we should be taking financial institutions to court, and we are minded to use the enforceable undertaking tool less and court enforcement action more.
You tell us in your statement that since the 1st of July 2011, ASIC has negotiated a community benefit payment on 30 occasions.
Yes.
And the highest number in any one year was last year, when ASIC negotiated 10 community benefit payments.
I believe that to be the case, yes.
And who are the community benefit payments generally made to, Mr. Shipton?
Generally, they are made to non-government institutions such as financial counsellors and advocates. So I believe in relation to some superannuation related matters, we funded a superannuation consumer organisation. So these payments again go to ameliorating the misconduct and go directly to a body, or are designed to go to a body that would somehow ameliorate the misconduct and help in the future prevent and deter these types of activities again. May I just quickly add that I have also instructed the team that we need to look very carefully at the methodology and the processes around community benefit payments, and that forms part of our internal review.
In what way do you say that the payment of a community benefit payment ameliorates the misconduct?
I would say it because essentially we are trying to take the superannuation case. As I understand it, there was, and I can't remember the exact details of the party, but there was misconduct in the superannuation space. A community benefit payment was made to a superannuation consumer organisation. So since the misconduct took place in relation to superannuation, to try and make the entire superannuation sector better, making a payment to support an organisation that we believe will help improve the superannuation sector and consumer engagement in that sector, that is what I would describe as an amelioration.
But you haven't always chosen an entity to receive the community benefit payment that has a direct link with the sort of conduct involved, have you?
That is correct. Sometimes it's more industry-wide. The enforceable undertakings in relation to the BBSW case is funding a wider financial capability and financial literacy arrangement. But again, I'll emphasise that I believe we need to look very closely at our processes and procedures around community benefit payments, and we need to be taking financial institutions to court more often.
Do you know the average size of community benefit payments that have been sought by ASIC in recent years?
No, I do not know the average size, but they can range from memory from hundreds of thousands or thousands to millions.
You've exhibited to your statement a pilot study by academics at the University of New South Wales that was recently commissioned by ASIC, and that study provides some detail about ASIC's practices in respect of enforceable undertakings. But in the course of the study, the authors interviewed a number of participants in the financial services industry about topics connected with enforceable undertakings, including community benefit payments. Are you aware of that?
Yes, I remember reading that paper.
And one respondent in that study expressed the view that community benefit payments provided the recipient with a more palatable way to acknowledge non-compliance than through a fine. And another respondent said that community benefit payments might be seen as a goodwill contribution to demonstrate an entity's goodwill towards fixing the problem. Do those sorts of observations concern you, Mr. Shipton?
Yes, they would not be. They would not be the way that I would describe a community benefit payment.
But what if that is the way they are perceived by your regulated population?
And I agree, and that's why it has triggered a review and an instruction by me to look very carefully and closely at community benefit payments, and also look very carefully and closely at the utilisation of enforceable undertakings. So yes, it is something we need to look at.
In the sixth round of public hearings in the Royal Commission, the Commission examined a case study in which ASIC accepted a community benefit payment without an enforceable undertaking from ComInsure. That's one of the cases that we asked you to reflect on in your statement. The community benefit was part of a negotiated outcome from December last year, in response to advertising that misled customers about the circumstances in which a policyholder would be entitled to cover under a life insurance policy if they suffered a heart attack.
Yes.
And ASIC considered initially using infringement notices to deal with that conduct.
Yes, and if I remember correctly, we were timed out because of a 12-month limit.
Yes, so it was worked out within ASIC that that option was not available because you were out of time to issue an infringement notice.
Yes.
But before that, there'd been some discussions with ComInsure about draft wording for an infringement notice before you appreciated that you were out of time.
I understand that to be the case.
And why was there discussion with ComInsure about the wording of an infringement notice to be issued by ASIC?
I do not know, and I do not have that detail at hand, but I will make the observation that an infringement notice is it has to be voluntarily accepted by the entity. It is not something that attaches unilaterally to an entity. It has to be accepted. If it's not accepted, then that triggers enforcement action. But the way that an infringement notice is structured, as I understand it, it has to be accepted by an entity.
I want to understand what you mean by that an infringement notice has to be voluntarily accepted by the entity. An infringement notice imposes a penalty, an infringement penalty on an entity, and if the entity does not pay that penalty, they can be prosecuted for failing to pay that sum.
Correct.
So in what way does an infringement notice have to be voluntarily accepted by the entity?
Well, apologies if I put it clumsily, my understanding is that the way we operate with a infringement notice is that we want to get an indication as to whether or not they will accept and pay the infringement notice so as to be sure that that course of action is the right course of action. And that is why, as I understand it, generally, I don't have the specifics in this case, generally our practice is to ascertain whether or not there will be an acceptance by that entity of the imposition of an infringement notice. And that is what I meant by, and I retract the word voluntary, but that is what I meant by that process.
Why do you do that, Mr. Shipton? Why do you need to get an indication as to whether they will accept and pay it? The parking inspector doesn't seek an indication from the person he's giving a parking fine to as to whether they will accept and pay it. He just does it. Why don't you just do that?
My understanding from the team is that if there is an unwillingness to accept an infringement notice, we would just go straight to court. In other words, what it is trying to be as efficient as possible as we can with our limited resources. And so it is a matter that we apply given the limitations that we have on our resources. But I can absolutely assure you, if there is not an indication in that discussion, and again, I don't want this to give the impression, and I fear there may be an impression that somehow we are sort of negotiating in a cosy fashion these enforceable undertakings. Infringement notices. What we are doing is seeking an indication whether or not this is an efficient use of our time and resources, because once we issue an issuance of an enforceable undertaking, not only takes up the time of our enforcement teams, it then has to go to an internal delegate, and so there's a whole flow of procedure and resource usage that we need to ensure is appropriately and efficiently applied.
What would you do if you wanted to issue an infringement notice and you said that to the entity and they said, we won't accept it and we won't pay it?
I have asked that question of the team, and they have said that they would pursue civil court enforcement issues. That's my understanding, and that is certainly my instruction to the team, that if that happens, then if that situation is said back to us, then that would be the consequence.
I see. But the practice going forward will be to continue to seek an indication from the entity to whom you want to direct an infringement notice that they will accept it and pay it.
Yes, I would also add that right now there is an additional procedure in relation or coming from our interim measures that we will have to check at the Commission level, particularly by our Deputy Chair for Enforcement. We will check before any infringement notice remedy or action is pursued, and again asking the question before that process is embarked upon, why shouldn't we be going straight to court and not utilising the infringement notice process?
Now, I want to correct part of this discussion between you and I, Mr. Shipton. The statutory consequence of not paying an infringement notice is that ASIC can litigate the contravention. That's the statutory consequence of non-payment, not prosecuting for failing to pay the amount. Is that what you understand?
That's what I understood. So, and with that, thank you for that clarification. With that in mind, you can now hopefully better understand that what we're trying to apply is whether we just jump to that next step. Jump to that next step, which is the civil action.
Mm-hmm. And what are the cases, what are the criteria for identifying the cases where it's appropriate to take that first step and see if the entity will accept and pay the infringement notice?
Well, they should be, and we're tightening up the process. They should be minor matters, matters that where there are mitigating circumstances. Again, this is very case specific, but put it generally, it should be a less serious matter.
All right.
Well,
now,
the reason for that being the simple one that the infringement notice penalty is fixed, is it not?
I understand it to be so.
And I would have thought the critical question was whether the fixed penalty was an appropriate penalty for the contravention that was in issue.
That is one of the considerations, as I understand.
Well, what other considerations would there be other than whether the penalty to be fixed is appropriate?
Well, I think it's also to do with the whether the frequency, the willingness to respond and amend processes, the helpfulness and timeliness of the response of the entity involved, and mitigating factors like that that go to in collection to determine whether or not it would be appropriate. I will quickly add that I do believe that we need to, and we have, sharpened up our process and got tougher on our internal processes of when we apply infringement notices. And I've said in my witness statement, we will be using that tool less often, particularly in relation to large financial institutions.
So coming back to the ComInsure case, after you worked out that you couldn't use an infringement notice because you were out of time, ASIC then had to reconsider its approach to dealing with that misconduct, and it decided to negotiate a resolution with ComInsure. And that resolution involved the payment of a community benefit payment.
That's correct.
Now, can I show you two internal ASIC email chains that show how this decision unfolded? Could we go to ASIC 0076 0006 5270? Now, at 5270, we see that in an email dated the 21st of September 2017, partway down the page, after it had become clear that you were out of time to use an infringement notice, Mr. Mullally, your senior executive leader of Financial Services Enforcement, said to Mr. Sadat, you may have seen that from the email chain above, Mr. Sadat being the Senior Executive Leader of Deposit Takers, Credit and Insurers, Mr. Mullally said, we either resolve by way of an enforceable agreement with a community benefit payment of $250,000, or we push for a community benefit payment of $300,000. You see that?
Yes, I do.
And further up the page, we see Mr. Sadat's response. Do you see in the middle of the page? Yes, I think we start with 300,000.
Yes, I do.
And then above that, up the top of the page, Mr. Mullally said, "Dear all, I spoke with James Myerscough yesterday and advised that we were generally in agreement with the proposed resolution. However, we could not issue infringement notices as we do not consider it is legally possible. I suggested that they should consider increasing the community benefit payment to take into account the lack of infringement notices. He was concerned that there was no hook upon which to found any agreement or resolution if there were no infringement notices."
I'm afraid my screen has gone
Yes,
blank.
and mine, Mr. Shipton. Don't worry, just put it back up.
Normal services resumed.
I advised that the hook would be potential civil penalty action. Do you see that? I'll take you back to that last paragraph. He was concerned that there was no hook upon which to found any agreement or resolution if there were no infringement notices. I advised that the hook would be potential civil penalty action.
Yes.
So we see from that email that ComInsure was concerned that there would be no infringement notice.
That would, on the face of it, appear to be the case. That would, yes.
But they agreed to consider whether to pay a higher community benefit payment to take into account that there was no infringement notice.
I was not part of this conversation, but that is what is said on this email.
Do you have any observations about what we see from this email about the communications, Mr. Shipton?
The observation that I understand is a broader context of another email chain and I believe at least one telephone call between NAB and Mr. Mullally, which was trying to ascertain...
I think you may mean CMLA or
ComInsure.
ComInsure.
I thank you for that correction. Yes. That there was a telephone conversation which was trying to ascertain what was the foundation or the grounding. I think that is reflected in the word hook as to what would be the rationale or the grounding, the jurisdiction, as it were, in relation to the payment of the community benefit payment.
Because ComInsure was uncomfortable with just making a community benefit payment without a hook, without an infringement notice or some form of action. They were concerned about the perception of just making a payment to ASIC to make this go away.
I understand. I do not have the level of detail as to what was in the mind of ComInsure, but I do understand that they were trying to ascertain the jurisdictional hook in the absence of both an infringement notice and, as I understand from a telephone conversation, the absence of an enforceable undertaking, what would be the foundation or the hook, which is the term used for that payment. That's what I understand to be the context of this exchange.
Well, I'll take you to another email that makes ComInsure's concern clearer. First, if I could tender this email chain.
Emails of September 17 concerning CMLA advertising ASIC 0076 0006 5270 Exhibit 7.69.
If we could bring up ASIC 0076 0004 6951, we see an email from Mr. Mullally to Penny Beck at ASIC a few weeks later on the 16th of October 2017. You see that, Mr.
Yes.
Shipton?
Yes, I can.
And at the top of the page we see that Mr. Mullally refers to an earlier conversation that he had had with James Myerscough. Now, James Myerscough is the Chief Risk Officer of Wealth Management within CBA, is that right?
I do not know his title, but I understand him to be a senior executive there.
The nature of ComInsure's concern about paying a community benefit payment without an infringement notice becomes very clear from this email. As you will recall, James Myerscough was concerned that by just paying a community benefit payment and not having any regulatory outcome, it looks like they are paying off ASIC to avoid action. He was hoping to see something from us about how this would be messaged. I intend to send him the following tomorrow morning to advance the matter. Now, how do you respond to that concern expressed by one of your regulated population that by making a community benefit payment, CBA would look as though it was paying off ASIC to avoid action?
Extremely concerning.
Well, what does that say to you about the way community benefit payments are perceived by your regulated population?
That is concerning, and that is why I have instructed that we need to be very disciplined moving forward about the utilisation of community benefit payments and non-court related agreements.
Attend to that email, Commissioner.
Email concern ComInsure advertising, October 18, ASIC 007 004 6951, Exhibit 7.70.
In your statement, Mr. Shipton, you say that having observed the evidence that was given during round 6 of the Commission, it's apparent to you that ASIC should have considered whether a more robust approach was necessary with ComInsure in order to ensure an appropriate level of deterrence and public censure prior to agreeing to negotiate an outcome or as part of the negotiated outcome. You recall that from your statement?
Yes, most definitely.
Why did the evidence in the 6th round of hearings change your views on this?
Because it is demonstrably clear to me, having not lived with this case, that this case was one that required, I believe, a more robust public denunciation of the overarching conduct. And it also triggered, as the NAB case study yesterday, it's a very good example of why we need to, and we are, improving our guidance and processes around our enforcement decision making.
Was there any evidence adduced in that case study in the 6th round of hearings that ASIC didn't already know about?
I cannot comment with any certainty on that because I haven't asked that question, but I would imagine that the gravity of the situation was known to us, and that is why, as I've said before, it was a mistake not to act quicker, swifter, and earlier.
You say in your statement that ASIC should have sought a stronger public admission of wrongdoing from CBA. Do you recall that?
Yes, I do.
And what do you mean by that? An admission that ASIC could have referred to in a media release?
Yes, both in a media release and more generally. I think a public denunciation has a tremendous deterrent effect because it impacts upon the reputation of the institution, and that is something that we should have done in a more robust fashion.
And what if ComInsure wasn't prepared to give you that public admission of wrongdoing, as the evidence suggested they were not at that time prepared to do?
Well, let me answer that question as of today. If this situation came to us today, I would be asking the team, why are we not just going to court with very robust responses in relation to this? And if we decide not to, then we need to have very strong, very clear admissions of wrongdoing and responsibility in relation to these matters. And this is another point of instruction and guidance to the team, that if we are to enter into any agreements or enforceable undertakings, then we need, as a starting point, to have a clear admission of wrongdoing and/or responsibility moving forward.
Do you intend to continue to try and resolve matters going forward on the basis of a community benefit payment?
I've asked the team to look very seriously at the utility of community benefit payments, but more broadly, what I've asked the team to look at is the utility and the appropriateness of enforceable undertaking and similar arrangements given the fact that it's very clear to me that we need to be more agile, willing, and faster in applying court-based enforcement actions.
Does that answer mean, Mr. Shipton, that you don't know if you're going to continue to try and resolve matters on the basis of a community benefit payment?
That means that it is under review right now. It also means that I have asked for more discipline, structure, and rigour around community benefit payments. But when one is reviewing a community benefit payments, it's not just in isolation. It is, as I've mentioned before, in relation to these enforceable undertaking arrangements, it is a combination of different matters that are included in that arrangement. As I said, remediation, compliance improvements, community benefits, payments. What we are doing is looking at that together, separately, and collectively. So yes, we are looking at community benefit payments. I am disturbed and worried about some of the descriptions of that you've referred to of a community benefit payments. That is very disturbing to hear. But I also refer to that University of New South Wales study that also points, if I remember correctly, to the fact that taken as a whole, that there is early indications, or at least some indication, that the entire enforceable undertaking arrangement does have a deterrent effect, as I said, taken as a whole. And I think it's important to look at both a community benefit payment process in isolation, which we're doing, but also in combination.
ASIC issued a media release about the negotiated outcome with CommInsure, didn't it?
They did, yes, we did, yes.
And when ASIC reaches a negotiated resolution with a financial services entity, does it tend to issue a media release about that outcome?
Yes, that is the usual protocol.
And why? What is the purpose of that, Mr. Shipton?
The purpose, in part, is deterrence, denunciation, and indication as to the matter at hand and our reaction to it.
So those purposes of deterrence and denunciation will only be served if what it is that you're publicising is something that is perceived by the public to have a deterrent effect and to involve denunciation for the conduct. Do you agree with that?
I most certainly agree with that.
And you tell us in your statement that since the 1st of July 2011, ASIC has issued 1,222 media releases in the course of or as a result of a formal investigation conducted by an enforcement team.
Yes, that's right.
And the number of those media releases, according to the table in your statement, has tended to be between about 140 and 180 a year.
Yes, I believe that's correct.
Now, when the media release is announcing that ASIC has negotiated a resolution which the entity has agreed to, do you say that that achieves denunciation of the conduct?
I believe that in some occasions it does, but we need more robust procedures around enforceable undertakings to ensure that we are clearer and more forthright in our denunciation of the wrongdoing, because there are, from my understanding of the processes, and the history, that the denunciation hasn't been strong enough and has not been forthright enough.
Well, what do you say to the proposition that the message that is being sent is that if another entity engages in that sort of conduct, they too will be able to negotiate an outcome with ASIC?
Well, that's not the message that we want to send, and again, that is why we are applying procedures that are now in effect that we hope will arrest that problem.
In the case study involving CommInsure that I've been asking you questions about, the terms of the media release, your media release, were the subject of negotiation with CommInsure.
That was a mistake, but I also understand that, and there are many lessons to be learned in this particular case study. I understand in that case study what happened was there was a conflation of documenting the arrangement with what the media release would look like. In other words, instead of an understanding memo or a drafting of an engagement memo, which should have happened, instead the focus point for determining what the arrangement would look like was through the prism and through the medium of the media release. That was inappropriate, that was wrong, that should not have happened, and again we now have processes and procedures that won't happen again.
You tell us in your statement that ASIC generally communicates with the affected party its intention to issue a media release in relation to the outcome of an investigation before issuing the release.
Correct.
Why do you do that?
We do that now because we want to ensure that anything in the media release is factually correct. Please do not conflate the case study that you've just referred to with current practice. Current practice is very different, radically different to that unfortunate case study. All we do now is check for factual accuracy. Often the times that is motivated again by just fairness and being a model litigant, as it were, or a model agency, but also in relation to listed corporations, factual inaccuracies of media releases relating to enforcement outcomes or enforceable undertaking could have market consequences, market movement consequences. So it is very important that we be factually correct.
So since when has it been the practice to only discuss the content of the media release for the purposes of confirming factual accuracy? When did that start, Mr. Shipton?
Well, that should have started, from what I understand, the guidance a number of years ago. But that is a very clear instruction that I have had throughout my 9 months at ASIC, that we do not negotiate the terms of a media release. We do not negotiate the terms of media release. We will check the factual accuracy of a media release, nothing more than that.
So that's something that you say has become the practice, the position in your time. Is that right? Because to the extent that there was guidance before, it was clearly not effective.
In this particular case, I grant that there was a conflation, and that shouldn't have happened. There should have been a different process applied. The people involved in this case do recognise and realise that. I can't speak to if there are any other examples. I'm not aware that there are any other examples. All I can speak to is the rigour, the discipline that I have impressed upon the team, that we will not negotiate media releases.
All right, so that's a change in practice.
And that, if I may, when you speak about change in practice, it highlights the point that this is an important time in ASIC's existence to have a rigorous look at not just the procedures, but the practice, to make sure that our practices are first class.
And this was not a first-class practice. Do you agree, Mr. Shipton?
As I've said, this was a mistake. This was not first class, and I believe, and the team believes, that there are very valuable lessons to be learnt from this case study and the NAB case study, and no doubt other case studies that you'll bring me to. And I am very motivated, very committed, and very dedicated to learning those lessons.
I just wonder whether this reference to factual accuracy and checking factual accuracy may not benefit from a little unpacking, Mr. Shipton. When you're making a media release about the outcome of a resolution of a regulatory matter, do you not begin from what it is that ASIC alleged?
Pardon me, Commissioner, I don't quite follow the question.
There are not only, is there anything more than 2 or 3 things that are going to form the basis of a media release recording the final resolution of a regulatory matter? What ASIC alleges, what the entity admits, and what the outcome is.
There's also background. there's background in a note. There's often a background to the note of the media release that talks about dates and times of what happened, when it happened. We're also checking, for instance, making sure that we've got the legal names right, and that sort of factual accuracy. There is not, for the avoidance of any doubt, there is not checking of the factual accuracy of the misconduct, the contravention, or the denunciation. What I'm talking about is dates, names, dates, and times.
Exactly, and those are matters which are at the core of what ASIC alleges.
Correct.
And ASIC should know what it alleges. Is that right?
Correct.
And it should know what the entity admits. Is that right?
Yes.
And there should be no controversy about either what is alleged or what is admitted. Is that right?
Correct.
And there should be no controversy, therefore, about what you describe as, quote, background. Would you agree with that?
There shouldn't be, but we want to make sure that we are applying a final check, as it were, as to that accuracy.
Yes.
And again, I want to just emphasize, Commissioner, if I may, that this is all about ensuring the factual accuracy about what we're saying. And in my observation, in my time, there has not been any amendments made, and you're absolutely right, we have been accurate about what we do. The background to this, if I may, is an unfortunate story coming out of the United Kingdom involving the FCA, where there was, as I understand it, factual inaccuracies. And as a consequence of that, many regulators, ASIC included, and I remember when I was in Hong Kong, was having a look at that case study to just put robust procedures in place to ensure that accuracy.
Mr. Shipton, I want to talk now about enforceable undertakings, a particular species of negotiated resolutions. And could we start by you explaining what the purpose of an enforceable undertaking is?
The purpose of an enforceable undertaking is an alternative to court-based enforcement actions to, I use the expression, package up a range of different possible resolutions, remediation, compliance improvement programs. We've discussed community benefit payments before. Package that up into an undertaking in the interests of timeliness, swiftness, and efficiency in trying to get all of those aspects and other aspects and behavioural change in one document, in one fell swoop, as it were.
What sort of misconduct do you say is appropriately dealt with by an enforceable undertaking?
Well, it's difficult, again, to generalise, because an enforceable undertaking, like other aspects, is case specific.
Could I ask you about, on a spectrum of seriousness of the conduct, at what end of the spectrum, from very serious to not very serious, is it appropriate to use an enforceable undertaking?
Well, to generalise, and of course it's always dangerous to generalise, it would be somewhere in the middle.
Somewhere in the middle of the spectrum.
Middle to serious nature of the spectrum, because of course we have a very broad spectrum in relation to the tools that we can apply and use.
Again, you give us some statistics in your statement. You tell us that since the 1st of July 2011, ASIC has negotiated 121 enforceable undertakings after formal investigations conducted by your enforcement people. Do you enter into enforceable undertakings other than following a formal investigation by an enforcement team?
Yes, I understand that there can be enforceable undertakings entered into by the surveillance team. May I just sort of amend that generalisation before? Because of course there are exceptions. There's been some enforceable undertakings which have been part of a broader court settlement in relation to matters which are very serious. So I think of the BBSW case, for example, or the BBSW cases, where there was a package of very serious matters, and one part of that settlement, that court settlement, were enforceable undertakings. So I just qualify my generalisation with that statement.
In your statement, you refer to enforceable undertakings as representing relatively timely and proportionate regulatory outcomes in respect of less serious conduct.
Yes.
So which is it? Is it less serious end of the spectrum or middle to serious end of the spectrum?
At middle to serious, as I said, there was a qualification to the generalisation. As I said, in relation to my first response, the spectrum is very wide.
Yes.
And so I think my spectrum generalisation, again qualified by some exceptions which I pointed out, stands.
So why did you refer to them as being used for less serious conduct? What were you intending to convey by that in your statement?
I was intending to convey that it's not the most serious of conduct, nor is it the least serious of conduct.
I see. Now, the pilot study that you've exhibited to your statement, which I asked you some questions about earlier, gives an overview of the types of potential contraventions that have most frequently been the subject of an enforceable undertaking.
Yes, I recollect that.
And the time period examined by that study was different to the period that we asked you to address in your statement. And the study wasn't explicitly confined to enforceable undertakings following a formal investigation, but do you agree that otherwise the parameters were broadly the same?
Could you elaborate on that statement?
Well, I want to compare the information that you've provided about enforceable undertakings in your statement with the information in that study. And I'm asking you whether or not you accept that the parameters of what we asked you to explain and what you asked the academics to explain were broadly the same.
Would it be possible to quickly glance at that study? Because
Of course.
I'd like to comment with certainty.
Yes, ASIC 0800 0016 0317. The part that I want to take you to, and perhaps you could consider my question in light of these pages, is 0322 to 0323. We see there that the study indicated in 323, I'm sorry, we've just lost the numbers from the top of the screen. On the right-hand side, I think I need to take you, I'm sorry, one page further in to 0324. Yes, that was the page I was looking for. That the study indicated that about 58% of enforceable undertakings obtained by ASIC related to conduct in financial services. I'm sorry, if you see that from 323 firstly, and then I'll take you to the table on 324. Do you see that figure up the top of 323? 57.6% relate to conduct in financial services.
Yes.
And about 15% related to conduct in consumer credit.
Yes.
Bringing the combined figure of financial services and consumer credit enforceable undertakings to about 73% of all enforceable undertakings.
Yes.
Now, of the enforceable undertakings given in respect of financial services and credit activities, I want to put to you that 0324 shows us that many related to serious conduct.
It's difficult to extract from that table.
Let's do it step by step, Mr. Shipton. We see from this table that about 36% related to providing inappropriate advice and or deficiencies in an organisation's systems to train or supervise representatives. Serious matters.
Serious matters, but we are providing a headline here because, of course, even though there could be, and I don't know the details of this study, so I can't speak with great expertise of the underlying matters in this study. But what I can speak to about is that yes, on the face of the column that you're referring to, yes, they are serious matters. But of course, there is the underlying case. There, of course, is a spectrum of seriousness in relation to the underlying cases that make up this study, which I don't have knowledge of.
No, and nor do we, Mr. Shipton. This is a study that you put forward in your statement. Neither of us have the underlying data, but we have the results. And you would not suggest, would you, that providing inappropriate advice or having deficient training or supervision systems of representatives was a not serious matter? Of
course I would not say it's a not serious matter.
And we see that about 16% of enforceable undertakings related to breaches of Section 912A of the Corporations Act, excluding the supervision deficiencies.
Yes, that's right. And if I may make an observation in relation to 912A, the utilisation of enforceable undertakings is utilised to a great deal in relation to 912A matters, because 912A currently does not have a penalty that attaches to it, and so therefore there is great utility in applying an enforceable undertaking approach to provide some form of better redress that the current penalty regime does not have, but soon will have. And because there soon will be meaningful penalties to 912A, I expect that there will be a decline in the utilisation of enforceable undertakings in relation to 912A matters.
But you accept that a breach of 912A is a serious matter?
As a starting point, I agree with that, yes.
And 8% related to providing consumer credit without a licence, another serious matter?
Correct.
And about 10% related to not making reasonable inquiries when entering into consumer credit contracts, and deficiencies in training on supervision systems. Do you see that?
Yes, they're all serious matters.
Well, about 7% related to misleading or deceptive conduct, another serious matter.
Yes.
So in your view, is it appropriate, and I heard what you said about the 912A penalty, so if we could leave that to one side for now, is it appropriate for enforceable undertakings to be used by ASIC for contraventions of this nature?
Well, assuming, for the purposes of your discussion and our discussion, that these serious matters also have serious underlying facts and serious underlying circumstances, I would agree with the premise of your question that we should be we should not be relying on enforceable undertakings, and that's exactly what the processes and procedures we now have in place to capture this concern that you raise.
I want to ask you about a particular enforceable undertaking, Mr. Shipton, that ASIC obtained from NAB at the end of 2016. This is one of the matters that we asked you to reflect on in your statement. Could I take you to RCD 000600160022, which is a copy of a media release in relation to this matter? We see from this media release that in late 2016, ASIC accepted an enforceable undertaking from NAB in relation to its wholesale spot foreign exchange business.
Yes.
And an enforceable undertaking in relation to similar matters was accepted from CBA on the same day.
Yes, it would appear so from that press release, yes.
And the conduct that underpinned the enforceable undertaking is set out in the 3 dot points under the heading NAB, about halfway down the page. If we could blow those up, we see that on several occasions a NAB employee on an offshore spot foreign exchange desk, acting together with an employee of another Australian bank, shared confidential information and entered offers into the trading platform without any apparent legitimate commercial reason for placing the offers. And on a number of occasions, NAB employees disclosed specific confidential details of pending client orders to external market participants, including identification of the client through the use of code names, and on several occasions NAB employees on an offshore spot foreign exchange desk inappropriately exchanged confidential and potentially material information about the bank's client flow or proprietary positions. You see that?
Yes, I do.
And underneath this, we see that having identified this conduct, ASIC was concerned, if we could blow that up, concerned that NAB did not ensure that its systems, controls and supervision were adequate to prevent, detect and respond to such conduct, which had the potential to undermine confidence in the proper functioning of the market.
Yes.
Now, in your statement, you make some observations about the process by which ASIC decided to enter into this enforceable undertaking with NAB. Now, I want to go to that. I'll tender this media release first.
ASIC Media Release 16-455 MR, Exhibit 7.71. It's ASIC 000600160022.
You tell us in your statement that the NAB foreign exchange matter was led by ASIC's market enforcement team from the commencement of initial inquiries through to formal commencement of the investigation and the acceptance of the enforceable undertaking. That's paragraph 266 of your statement, Mr. Shipton.
Yes.
And you say that the investigation team, in conjunction with the senior executive leader for market enforcement and one of the commissioners, recommended to the enforcement committee that ASIC enter into an enforceable undertaking with NAB.
Correct.
And the relevant commissioner was Ms. Armour, and she had, in your words, ultimate responsibility for the conduct of the matter.
Correct.
Now, while Ms. Armour was responsible for the conduct of the matter within ASIC, did she discuss the matter with senior representatives of NAB?
I'm not aware.
From the documents that you reviewed in reflecting on this matter for the purposes of your statement, did you see any documents recording discussions between Ms. Armour and senior representatives of NAB?
Not that I can recall.
You don't recall seeing any documents recording discussions between Ms. Armour and Mr. Gall, who was then the Chief Risk Officer of NAB?
Oh, yes. I'm now recalling. Thank you for that prompt. Yes.
All right.
Thank you for that prompt. Yes.
Could I take you to an email from Ms. Armour to others within ASIC that summarises a conversation that she had with Mr. Gall during the investigative phase of this matter in August 2016, ASIC 0089 0004 1051. Now we see that this was an email from Ms. Armour to a number of people within ASIC, and Ms. Armour says, David Gall and I had a telephone conversation this morning. David asked that the conversation be on a without prejudice basis, with which I agreed. David explained that he was interested in just confirming the basis on which ASIC may entertain a proposal from NAB to settle the matter. Apparently, the FX investigation has had a degree of attention internally at NAB, including at its board level. David said that the bank team understood from the 18 May meeting and subsequent conversations that ASIC was inviting NAB to put a proposal to it for an administrative outcome. He wanted to confirm that this was correct. Now, just pausing there for a moment, was it common to your knowledge for commissioners to discuss enforcement proposals directly with senior representatives of banks during an investigation in this way?
At that time, yes.
Do you have any observations to make on that practice, Mr. Shipton?
Well, that practice is changing because I believe that the commissioners should be stepping out of this would be a day-to-day operational matter in relation to enforcement, and I believe that the commissioners should be stepping out of these discussions and leaving them to the executive responsible.
And why do you believe the commissioners should be stepping out of these discussions?
Because I believe that the commissioners should be providing a strategic direction and guidance role, and we've discussed some of the case studies where I believe that was lacking. And I also believe that the commissioners should have a role of providing a objective checking and challenge of decisions being made by the executive team. The conflation of strategic decision making, oversight, and direct operational matters, I think is not optimal, and that is why we're changing our structure.
What do you mean the conflation is not optimal, Mr. Shipton?
In my experience, if I could step out of this case study, in my experience, having had a role previously in a previous role as a regulator, I saw and observed that when you have commission-like positions with executive responsibility, there was a degree where objectivity was lost because of closeness to the matter at hand. What I believe is best practice for a regulatory agency is to have distance between the strategic oversight, the strategic direction, that being separated and distinct from the operational day-to-day management of matters. This, I understand, is consistent and aligned with the capability review. So stepping back into this case study, this type of scenario moving forward would not happen.
I see. Well, stepping back into...
Wouldn't happen at that level.
It wouldn't happen at that level. There would be engagement.
But the officer having primary responsibility for carriage of the matter and initial decision rights would be the person who would have a discussion of this kind. Is that what I'm to take from your evidence?
It would be more appropriate for that person to have that discussion, yes.
So we're not debating whether the discussion should have happened, we're debating who should have it.
You will hear some comments about the case study in a moment, no doubt, from Ms. All's questioning. But stepping out of the case study for a moment, as regards those discussions, general discussions by a senior executive leader or what we are now constituting an executive director, that should be done with absolute professionalism and highest professional standards in mind, and also pursuant to guidelines and guidance that we are issuing and plan to issue in relation to how matters like this are conducted, particularly when it comes to enforceable undertakings.
I want to direct you to some other parts of the email, Mr. Shipton, and ask you to consider whether the problem here is a lack of professionalism or whether there are different problems that appear from this email, because Ms. Armour goes on to say, my response to David was that the proposal and its nature was a matter for NAB, but I thought we would be willing to consider a proposal along those lines depending on its content. I did say to him that given the relatively early stage of the investigation, we would be willing to consider a proposal that did not involve a court outcome, if it otherwise met our key regulatory outcomes. I did urge him, though, to put a proposal to us shortly. I explained that the longer investigations go, the more prospect of us developing case theories more definitely, and there can be a risk of there being entrenched positions which would limit our flexibility on outcomes. Now, can I ask you to reflect on whether anything about that response by Ms. Armour, a Commissioner of ASIC, to Mr. Gall, is problematic beyond a lack of professionalism?
I just want to be absolutely clear that I firmly believe in Ms. Armour's professionalism at all times, and that shouldn't be in any doubt in this case study.
Ask a question, Mr. Shipton, be good enough to answer it.
Yes, of course. I just wanted to clarify. I will, sir. Can I give you, from what I understand to be the background in relation?
Can you put the question again, Ms. Orr?
Well, I was asking you to reflect, Mr. Shipton, on whether the communication by Ms. Armour in response to the approach from Mr. Gall reflected far greater problems than concerns about professionalism.
No, and the background and context is important, because the background and context to this discussion, as I understand from Ms. Armour, is that at that particular point in time, there was not a great degree of confidence that outside 912A actions, that there was sufficient evidence or legal hook, as it were, to pursue the other matters. And that is the background and context. Yes, as I understand it from Ms. Armour, we were prepared and willing to continue with the investigation, but at that point in time, and I might add, at that point in time, we had spent millions of dollars looking at not just the FX issue, but also the BBSW issue, because it's the same business, same happening at the same time. And we, as I understand it from the team and Ms. Armour, we went out and got a whole range of legal advice, and there was not the degree at that point in time of sufficient confidence. And therefore, what Ms. Armour was doing was exploring how we could come to an arrangement in relation to this matter by way of an enforceable undertaking.
Well, Mr. Shipton, what Ms. Armour went on to say here was that she said to Mr. Gall, and I'm reading 3 paragraphs from the bottom now, I said that we will continue our investigation and there would be a risk of us developing more information and forming views on different outcomes in the meantime. So encourage David to have his team come back to us as soon as they could with a proposal. He asked me to let him know if we had an issue beyond the warning I had given him on investigation risk with the early September timetable. Now, the Commissioner was telling NAB's Chief Risk Officer that if the investigation progressed, there was a chance that ASIC would uncover evidence of serious misconduct, which would render a weaker remedial outcome inappropriate. That is what she was referring to when she referred to investigation risk. What do you say to that, Mr. Shipton?
Well, she's referring to more information and forming different views on outcomes. She doesn't use your expression, which is the word serious. And again, I do think the background and context was that there was a very clear willingness to continue the investigation, which could, as I understand it from the team, could have formed views of different outcomes. But at that particular point in time, given the resource constraints, given the very large BBSW case at hand, a decision was made, and I think it's the right one, on the back of not just one counsel, senior counsel, but a whole series of senior counsel, that at the time of this email, that there wasn't a high degree of confidence that further investigation would lead to different outcomes, even though there was a willingness and a possibility to do so. So that is the context in which that discussion was had.
Well, what Ms. Armour said to Mr. Gall, as recorded in this email, was that if Mr. Gall wanted to make an offer, he better do it quickly, because otherwise the investigation might progress to a point where misconduct was uncovered to an extent that a deal of this nature could no longer be done with Mr. Gall.
We're reading a lot into that paragraph. And again, I wasn't part of the conversation, but my understanding of this conversation between Ms. Armour and Mr. Gall, and again, this is all hearsay because I'm only receiving it secondhand, was that there was a clear willingness on our part to continue with the investigation, but equally what we clearly didn't say, or Ms. Armour didn't say to Mr. Gall at that particular point in time, was that there wasn't overwhelming confidence that the continuation of the investigation would come up with anything, and therefore she put the matter to Mr. Gall in strident terms.
Well, I want to suggest to you that the appropriate way to handle this situation would be to complete your investigation, form your views about what an appropriate outcome is on the basis of the completed investigation, and then use whatever measures are available to you to pursue that outcome. That is not what happened here, is it?
The investigation, as I understand it, and of course investigations can continue and can continue and can continue, the investigation was plateauing at this particular point in time. And I take your point.
Plateauing when it's described as the relatively early stage of the investigation. That's what appears at line 3 on the screen, a relatively early stage of the investigation.
Could I have a look at that? Because my understanding...
Line 3 of the screen. No.
Because my understanding, and I can't speak to that line, my understanding is that the issue was plateauing, and there wasn't a high degree of confidence as regards what else would be found. I cannot explain that line.
Commissioner, I'll tender that email.
Email concerning NABFX, 10 August 16, ASIC 0089 0004 1051, Exhibit 7.72.
Commissioner, I wonder if it might be an appropriate time to
Just
have...
before we do, can we go back, please, to ASIC 0006 0016 0022, the media release. Triple 006 0016 0022. The answer to my question is no. We can't. The 3 bullet points underneath ASIC identified the following conduct. Do those 3 bullet points, as you understand it, represent reasonably accurately the state of ASIC's knowledge at the time of the issue of the press release?
To my knowledge, yes.
The press release was issued on what date?
I can't see it on my screen, Commissioner.
If we pan back, we can see the date above the heading Wednesday,
21 December.
21 December.
And the email from Ms. Armour was 10 August 16. Is that right?
I believe so.
Thus ASIC knew at or about the time of Ms. Armour's conversation with the representative of NAB that the conduct being examined was of a kind described in the 3 bullet points. Would you accept that?
Yes, I would.
Yes. Thank you. Ms. Orr?
Perhaps if we could have a brief adjournment, given that this is a long session for Mr. Shipton in the witness box.
I come back at 11:20.
Thank you, Commissioner. Now,
Yes, Ms. Orr.
the email that we were just discussing, Mr. Shipton, took place, recorded conversations from August 2016. You'll recall that the media release was from December 2016. We know from your statement that the Enforcement Committee considered the NAB foreign exchange matter on the 14th of November 2016. We see that from paragraph 268 of your statement.
Yes.
And the Enforcement Committee decided to accept a recommendation to resolve the matter with NAB by entering into an enforceable undertaking.
Yes.
And in your statement, you say that ASIC's acceptance of the enforceable undertaking in this case was not unreasonable.
Yes.
And is that as high as you would put it, not unreasonable?
That would be as high as I would put it, yes.
You would not say it was reasonable?
I was using the expression yesterday that there is a spectrum of reasonableness, and it is on the spectrum of reasonableness.
Sorry, it's on the spectrum of reasonableness.
Yes.
You might have to explain that to me.
Well,
Mr. Shipton.
what I'm saying is that under at the time and the circumstances of the case, remembering that we were spending at that stage millions of dollars on the investigation. By way of background, we ended up spending $45 million on the BBSW investigation and action. So this was sort of a part. It was an expensive part. It was international. It was multi-jurisdictional. It was expensive. It was intense. BBSW was taking place at the same time. So I would agree that, and again, I was not there at the time, so it's difficult for me to put myself in that position then, and therefore I need to qualify my observation as to the decision, because as I said, I just wasn't there at the time. I would hasten to add again, the processes and procedures that we have right now are very different to what existed in 2016.
I want to show you the enforceable undertaking that ASIC entered into, Mr. Shipton. It's ASIC 0089 0004 1062. Now, if we turn to 1067, we see at paragraph 2.15 that the enforceable undertaking set out ASIC's concerns. Do you see that?
Yes, I do see that.
That NAB had failed to comply with its obligations under section 912A1A of the Corporations Act by failing to ensure that its systems, controls, training, guidance and framework for monitoring and supervision of employees in its spot foreign exchange business were adequate to respond to various forms of misconduct.
Yes, that's right.
And at 2.18 over the page at 1068, we see at 2.18 that NAB acknowledged ASIC's concerns and that they are reasonably held and offered an enforceable undertaking in the terms set out below as a resolution of ASIC's concerns. You see that, Mr. Shipton?
Yes, I do.
And if we turn to 1069, and we bring up 3.5, we see that by the enforceable undertaking, NAB undertook to do various things, including to develop a program of changes. We'll need to pan back. If we could just have the entirety of 3.5 brought up, to develop a program of changes to its existing systems, controls, monitoring and supervision of employees within its foreign exchange business to prevent, detect and respond to particular types of problematic conduct. And that program was to be developed and provided to ASIC and an independent expert by the 30th of June 2017.
Yes.
And if we turn to 3.7 at page 1071, we see in 3.7 that the independent expert was then to assess the effectiveness of the program that NAB was required to develop, assess the effectiveness of that program to prevent, detect and respond to the particular types of problematic conduct, and the independent expert was to provide a written report about any deficiencies in the program to NAB and to ASIC.
Yes.
The independent expert was to be appointed by ASIC.
Yes.
And if we turn to 1073, we see at paragraph 3.17 that NAB was also required to make a community benefit payment of $2.5 million to Financial Literacy Australia to fund the advancement of financial literacy in the aged care sector, including by providing assistance for aged care financial consumers with cognitive difficulties and the promotion of ethical behaviour in Australian financial markets. How did that come to be the place to which the $2.5 million community benefit was directed, Mr. Shipton?
I do not know the exact rationale for the choice of Financial Literacy Australia, which is, of course, a fine organisation, but as regards its choice, I'm not aware of, and I'm aware of the concern that is the premise of your question, and I'm doing my level best to address it.
And what do you understand the concern to be that is the premise of my question, Mr. Shipton?
With apologies, I'm jumping ahead of myself. The determination of what organisation receives the community benefit payment.
Yes, well, you referred earlier to community benefit payments having a purpose of ameliorating the particular misconduct being addressed. Was this a community benefit payment that ameliorated the misconduct in NAB's spot foreign exchange business?
May I step out of the case study for a moment?
I'd be grateful if you could answer that question in relation to the case study first, Mr. Shipton.
It's difficult for me. It's difficult for me to comment on the because I do not know what other agencies or organisations were out there, and this is why I wanted to step out of the case study, because I do understand that as the procedures apply, probably applied at that time, that absent a direct or referable organisation for the misconduct, then another suitable or another alternative would be found. I can only imagine, and this is now conjecture, but knowing the spot FX market and knowing that it is indirect to the consumer, as in the retail consumer, that the thinking was, and this is only conjecture, the thinking was to find an alternative or a proxy, but that is pure conjecture, and that's why I requested to step out of the case study.
So you're unable to explain why the community benefit payment in this enforceable undertaking was directed towards the advancement of financial literacy in the aged care sector?
I'm unaware. I can only observe that I can imagine that it would be difficult to find a equivalent organisation that is referable to the spot FX market, which is very wholesale, very international, and very institutional.
And therefore, Mr. Shipton, very difficult to use a community benefit payment to ameliorate this particular misconduct.
I agree with you, and that is exactly why we're looking exactly at these types of issues.
Now, the independent expert who was to receive the program to be developed by NAB and assess the effectiveness of that program was Promontory, is that right?
Yes, I believe so, yes.
And NAB provided its program for assessment by the independent expert in November 2017.
Yes, I understand that.
And at the end of March 2018, Promontory provided its independent expert report on phase 1 of the program that NAB had developed pursuant to its undertaking under the enforceable undertaking.
Correct, on that phase 1 program, yes.
And that report identified significant deficiencies and explained that NAB had not yet designed items to be included in the program, so its effectiveness was not even able to be assessed.
Yes, there were, as I understand it, deficiencies in that program, which is the remediation program, as in the improvement program, and the design of that improvement program.
I want to take you to a presentation that Promontory gave to ASIC and NAB in April, but first I'll tender the enforceable undertaking, Commissioner.
Enforceable undertaking then would be ASIC 0089 004 1062, Exhibit 7.73.
And if we could now bring up ASIC 0089 0002 2242, we will see the presentation that Promontory provided to NAB and ASIC. And I want to show you two slides which contain the key findings. If we could go to 0005. We see that the independent expert reported that progress in developing the program has been slow. The program appears to have evolved iteratively during 2017 rather than through a well-designed process. There appears to have been no comprehensive risk assessment across NAB's spot foreign exchange business against the enforceable undertaking requirements and relevant regulatory standards and guidance. Some key stakeholders have had limited engagement in the program to date. NAB's independent risk and assurance functions have had limited involvement, and the human resources function has also had limited engagement. In combination, these have led to gaps in the program and a lack of detail in the action plans. And if we could then go to 0015. We see here the assessment of NAB's FX program design. We are unable to assess the overall effectiveness of the program or of any program work streams to prevent, detect and respond to the enforceable undertaking conduct types. We found action planning has progressed but not completed in any of the assessment areas. Further down, little progress has been made in the detailed design of the action plans. And further down, the action plans are relatively high level and lack sufficient detail to enable us to evaluate the effectiveness of their design to address the concerns raised in the enforceable undertaking. Now, Mr. Shipton, these are troubling findings from the independent expert tasked with assessing the effectiveness of the program that the enforceable undertaking required NAB to develop.
They are indeed very troubling.
The program had not been developed to a point where its effectiveness could be assessed.
That is correct.
But the enforceable undertaking required NAB to develop a program of changes that was capable of assessment by the independent expert.
The enforceable undertaking required the development of a plan. This is my understanding. The enforceable undertaking required the development of a plan, and the plan was clearly deficient.
Well, it required the development of a program to prevent, detect and deal with the sorts of misconduct that was the subject of ASIC's concerns. Do you agree with that?
I agree with the fact that it was there was need, the term, and I think there is and it would be helpful actually to refer to, I think it's about 3.7 in the enforceable undertaking.
We could bring that back up.
Yes, because I think that's a key provision as I understand it.
I'll tender this document first, Commissioner.
Promontory presentation concerning NAB FXEU program ASIC 0089 0002 2242 exhibit 7.74.
And the enforceable undertaking is ASIC 0089 0004 1062. And you had referred to 3.7, I think, Mr. Shipton?
Around 3.7,
3.7.
I'm going from memory. There is basically a key provision in the enforceable undertaking as regards the deliverable.
3.7 is at 1071. This is one of the deliverables, which is that the independent expert was to conduct an assessment of the effectiveness of the program. Do you see that?
Yes.
And another deliverable appears at 3.5, which I took you to earlier. That's at 1069. That other deliverable was the provision by NAB to ASIC and the independent expert of a program of the nature described there. Do you see that?
Yes.
Now, that program had to be in a form that enabled the independent expert to conduct an assessment of its effectiveness.
My understanding, and this is what I've been told by the team, because they looked at they looked at this at the time, as I understand. They looked at these provisions, and there may be other relevant provisions, and there were certainly concerns as to the efficiency of the program itself, but there was not a conclusion at that point in time. There was not a clear conclusion, as I understand it from the team, that there was a breach of these provisions.
And in your view, based on what I just showed you, Mr. Shipton, was there a breach of these provisions by NAB?
It's difficult for me to come to a conclusion as to that, because I understand that the point of uncertainty and it's a very difficult situation for me to opine on. But the point of doubt was whether or not there is a quality or sufficient quality sort of provision built into this. The conclusion was, and I think it's a reasonable conclusion, that there was doubt, at the very least doubt, as to whether or not there was a breach of the EU at that particular point in time.
Well, Mr. Shipton, what is the point of having, in your words, a deliverable like this if NAB could produce a program that was so deficient that it was incapable of being assessed by your independent expert?
I totally agree that there is room for improvement, and there are certainly lessons to be learned as regards, and I've certainly learned a lesson from going over this case study as to the robustness of agreeing and documenting, particularly documenting enforceable undertakings, because my observation is that the documentation should have gone further to make sure and make it very clear, to avoid any doubt that I referred to earlier as to the sufficiency and the quality, as it were, of the deliverable. And that is a key lesson for me from this case study.
Right. Well, Mr. Shipton, about a week after the presentation that Promontory gave, the market supervision team discussed how to proceed in light of that presentation with Commissioner Armour. Have you seen the documents about that?
I have seen some of the documents, yes.
Can I take you to ASIC 0089 0002 0560? Perhaps if we could have the second page on the screen as well, which will enable you to see that the primary email in this chain on the 20th of April at 6:43 p.m. is an email from Mr. Grantley Brown, Senior Manager Market Supervision, to Kathy Armour and Greg Yanko. You see that?
Yes, I can.
And in this email, Mr. Brown recommended to Commissioner Armour that the enforceable undertaking be amended to allow NAB to have another go at developing a program that was capable of being assessed by the independent expert.
Yes, that's right.
Mr. Brown said that he recommended tell NAB they have 3 months to deliver a credible, reviewable FX program and then have Promontory review it. Do you see that?
Yes, I do.
And further down, 2 paragraphs down, he said that this would require a revision to the EU, the expert contract and a new Section 23 memo, but we think this is the best way forward. Of course, this revision to the EU and the reasons why it has been amended will have to be made public.
Yes, that's right.
And at the top of the page, we see Commissioner Armour's response. She said that this was fine with her.
Yes.
And did ASIC then propose to NAB that the enforceable undertaking be varied?
I imagine that to be so from my briefing on the facts.
And NAB agreed to that variation?
Yes, they did, and I also understand that there were very forthright discussions from our team as to our disappointment.
Well, under the varied enforceable undertaking, NAB gave some additional undertakings to prepare an updated program that was capable of assessment by the independent expert. Is that right?
That's right.
And in your statement, you say that ASIC's acceptance of the variation of the enforceable undertaking was not unreasonable.
That's right.
Was it reasonable, Mr. Shipton?
I think it's reasonable. It's reasonably held. Yes.
Why didn't you say it was reasonable in your statement?
At the time of the statement, I was given a very short period of time for drafting the statement, and there has been time for me to reflect since the drafting of the statement. I was travelling overseas, and unfortunately, I was also very ill at the time, and that would be the explanation as to the evolution of my thinking on this.
Well, you were given a matter of weeks to prepare your statement, weren't you, Mr. Shipton?
I was, but I believe, if I remember correctly, this particular case study came a little bit later, and as I said, as I got further into these cases, my views have evolved in relation to some of those case studies.
So you now say that this was a reasonable decision, not just a decision that was not unreasonable. Is that right?
Yes, I think that this is a reasonable decision.
Was it an appropriate decision, Mr. Shipton?
Yeah, I can. In the broader circumstances, I believe that it was an appropriate decision.
The upshot of accepting the variation of the enforceable undertaking without any additional action was that NAB did not face any negative consequence for its failure to adhere to the letter or the spirit of the enforceable undertaking.
May I just, before we go on, may I just sort of add the context in which I said not unreasonable? Because I also think that there could have been better escalation of this matter and involvement of either the Enforcement Committee or more broadly the Commission. And so I do believe that there could have been procedural improvements. And again, right now, this matter would be handled very differently to what it was at the time. So pardon me, would you please repeat the question given that supplement?
I put to you, Mr. Shipton, that the upshot of accepting the variation of the enforceable undertaking without taking any additional action was that NAB did not face any negative consequences for failing to comply with the letter or at the least the spirit of the enforceable undertaking.
Except to say that we did, in our public media release on this, express publicly our disappointment in relation to the matter at hand.
Those are the negative consequences that in a media release you expressed disappointment.
This was a difficult regulatory choice. This was a very difficult regulatory choice. As I was mentioning before, our resources are not limitless. There was uncertainty as regards the alternative, because the alternative, which I imagine that you're alluding to, is going to court. There was not any degree of certainty in relation to going to court to enforce this matter. There was also a consideration, which I think is entirely appropriate, as to get a speedy resolution to get this issue back on track. So with those considerations in mind, that broader context in mind, and also keeping in context that we had spent millions of dollars already on this and related issues, that was the broader context in which this decision, this difficult decision, was made.
In that broader context, Mr. Shipton, NAB was not punished for failing to adhere to the enforceable undertaking.
Again, it was not clear whether there had been a legal breach of the enforceable undertaking. I agree with your sentiment and your concern and your disappointment, of which I totally agree, but I am advised that there was no certainty that there could have been a resolution or a court-based referral which would have given credence to that degree of punishment.
Well, the consequence of the approach that ASIC took to this situation was that ASIC was not seen by those that it regulates and the broader community that it serves to be taking action where a major financial services entity failed to adhere, and I'll put to you again, to, if not the letter, the spirit of the enforceable undertaking.
I can see your sentiments without a shadow of a doubt, and I do agree with your sentiments, but from what I understand, at that time, by the team, we had very limited options. We also were pursuing, at the time, and a large number of other complex matters. That's the difficult regulatory choice we took. There was no clear-cut, quick way of getting to that degree of punishment. That is why I firmly agree with the sentiment of your questioning that we need to sharpen the documentation of any enforceable undertaking so that it is absolutely crystal clear that should a circumstance like this arise where the spirit, as you refer to, is in breach, then we do have a clear path, an efficient path to that degree of punishment and denunciation that you are alluding to.
Do you think that your approach sent the right message to NAB?
Our approach, we wish our approach was stronger, but we sent the strongest message we could have, which was a public expression of disappointment and also a private expression of disappointment.
That is the strongest message you could have sent, Mr. Shipton.
That is what I have been advised.
A media release which read, ASIC is disappointed with the delay in the development and assessment of a remediation program to address the conduct outlined in the EU. However, we are pleased that the process has been sufficiently robust to ensure any ongoing deficiencies have been identified and are being addressed with oversight by an independent expert. That was the condemnation of NAB?
Well, that is factually accurate, because I also understand that from the team, that there was a very quick, a very efficient redress in that 3-month period. But I certainly agree, and this is part of my direction, that we need to be clearer and more forthright in our public denunciations. And you asked me whether or not it's appropriate. I agree it's appropriate. And that's why, I oscillated between the expressions reasonable or not unreasonable. But I agree, moving forward, and this is part of the direction moving forward, we need to be very firm, very clear, very forthright on our public statements of denunciation.
How many times has ASIC taken action against an entity for breaching an enforceable undertaking in the last 10 years, Mr. Shipton?
A handful of times.
Twice, is that right?
I believe twice, yes.
I'll tender that document, Commissioner.
Emails concerning NABFX EU 20 April 18 and ASIC 0089 002 0560 Exhibit 7.75.
In your statement, Mr. Shipton, you tell us that the use of enforceable undertakings for larger financial institutions is going to decrease going forward.
It is, yes.
And do you accept that in recent years ASIC has overused enforceable undertakings in response to misconduct by larger financial institutions?
May I respond by saying I think there has been an undue reliance, yes, and one of the reasons why there has been a reliance in the past and why there will be less of reliance in the future is that we will have a more effective penalty regime for that fundamentally important provision 912A. That is also part of the forward projection here, and also, and I think, an important consideration when one looks back in time over the usage of an EU.
And enforceable undertakings have tended to proceed on the basis not of an admission of contravention, and we see this from the one I just took you to, the NAB one, not on the basis of an admission of contravention, but on the basis that the entity acknowledges that ASIC holds particular concerns. Are you changing that practice moving forward?
Yes, I believe I've referred to that change of practice and my desire to change that practice moving forward. I believe I mentioned maybe yesterday that the starting presumption should be a stronger, forthright and robust admission of wrongdoing and responsibility.
Now, I want to move from enforceable undertakings, Mr. Shipton, to civil proceedings. What sorts of civil proceedings can ASIC commence against financial services entities?
A range of civil proceedings, misconduct, 912A, investor protection, consumer protection. There's a range of different remedies, civil actions available to us.
So you tell us in your statement that since the 1st of July 2011, ASIC has commenced civil proceedings on 169 occasions following formal investigations by enforcement teams. How many of those civil proceedings were commenced against the major banks?
Can you direct me to remind me which paragraph?
151, Mr. Shipton.
I do not have the breakdown of the large financial institutions in front of me.
What proportion of the 169 do you think were brought against the major banks?
Let me respond by saying not enough, not a high enough proportion.
In the statement that Mr. Mullally gave the Commission in advance of the third round of the Commission's hearings, Mr. Mullally indicated that since the 1st of January 2008, ASIC had commenced 10 proceedings against the major banks, the Bank of Queensland and Suncorp. Do you recall that?
I recall that. What was the date again that Mr. Mullally was referring to?
Since the 1st of January 2008, so further back in time than the period that you've dealt with in your statement.
Yes, and if I remember correctly, also you break out the statistics in the interim report, which is also a good indication of and support to my earlier comment that we need to do more.
How many of the 167 proceedings that you refer to in your statement were civil penalty proceedings?
Sorry, can you just take me back? There's a lot of numbers flying around.
Sorry, 169. That was a number that you amended in your statement. It's now 169. It was originally 167. This is of civil proceedings in the table at paragraph 151.
Yes.
So what I'm asking you is, of those 169 civil proceedings, how many were civil penalty proceedings?
I do not have that to hand, but I would hazard a guess that, and this is only a guess, a reasonably significant amount, but that would only be a guess.
I'm sorry, I missed
a reasonably significant amount.
Reasonably significant amount.
But I'm only hazard guessing because
you don't know, Mr. Shipton?
I haven't had a breakdown of these figures.
And
no.
what's the purpose of a civil penalty proceeding commenced by ASIC?
Well, the purpose of a civil penalty proceeding is to punish and deter both general and specifically the wrongdoing, and it should be applied in serious cases and also to get redress in relation to the wrongdoing.
Now, in ASIC's submissions in response to the interim report, ASIC said that it accepted that it needs to make changes to its approach to court-based enforcement and initiating litigation. Now,
Yes, we most certainly do.
And you gave some evidence about this yesterday. More proceedings brought more quickly. And there was a third aspect to it that I now can't recall. You might remember that, Mr. Shipton.
More quickly, and then amongst other things, we were going to compartmentalise or sequence out our undertakings. I also think I mentioned use of novel and creative ideas And one thing that I failed to mention, but since you prompt me now, is that I think we should be looking at trying to commence civil actions in relation to the individual decision makers, because my view of deterrence in relation to the corporate field, given that the academic literature shows that it is difficult to establish deterrence of a corporation, my personal and professional observation is that we should be looking at deterrent effect on the decision makers and the individuals themselves, and that is also a core priority of ASIC moving forward.
In those submissions by ASIC in response to the interim report, ASIC accepted that the proper starting point of enforcing compliance with the law is litigation. Do you recall that?
Yes, I recall the expression which I drafted, that we should be turning our minds in relation to breaches to ask ourselves the question why we should not be proceeding using court-based litigation actions.
And the only circumstances in which litigation should not be pursued are where there is insufficient evidence or it is contrary to the public interest. Is that right?
They are considerations, but I will also add a practical observation, is that we are resource constrained, and there may be cases, there very well may be cases, in fact I expect there to be cases, that we are constrained either by budget or by personnel as to our ability to pursue. So our keenness, our willingness and our resolve, unfortunately, is tempered by the practical reality of resource and budget constraints. But that should not be an excuse or any way limit our first question of, and this is procedural, why not litigate? And that is why the guidance, the decision-making structures that I refer to throughout the case studies, in my belief, are so fundamentally important moving forward.
So resourcing, I understand, you've referred to that and the impact that that might have on things, but the two matters that ASIC, it seems from its interim report submissions, needs to be satisfied of before commencing litigation are sufficiency of evidence and that it's not contrary to the public interest to bring the proceeding, borrowing heavily from the Commonwealth DPP's prosecution policy. Is that right?
Yes, so I refer, I believe, on paragraph 45, we should satisfy ourselves of two things: that there's sufficient evidence, and the evidence of the facts of the case and all of the surrounding circumstances that the prosecution would be in the public interest. And we go on, as you say, to say that that is consistent with the DPP.
And I just want to ask some questions about each of those points of satisfaction. What is the standard that ASIC applies in determining whether it has sufficient evidence to commence litigation?
Well, that would be on a case-by-case basis. And my understanding of the process is that there is an assessment by the enforcement teams. There is also input from our Chief Legal Office as to the prospects and the sufficiency of evidence. And oftentimes we also go out to external counsel. And in the case of criminal matters, we would liaise with the DPP. And that is the process, but again, I must emphasise it's on a case-by-case basis.
Well, of course, the application of the standard is done on a case-by-case basis, but I want to understand what the standard is that is applied. What basis are you looking for sufficiency of evidence? Are you looking for a proper basis to bring the proceeding? Are you looking for it being more likely than not that you will win the proceeding? What is the standard that you are looking for?
I see. The standard is the standard that should apply, and this is a part of the enforcement review right now, because we also want to look at, as I said, more novel cases and cases that test the law, would be a proper basis. But again, that's the starting point, and of course, case-specific matters are very important to that broader to that base consideration.
And can you give any content to that? How do the people assessing the sufficiency of evidence know when they've got to the point where there is a proper basis to bring the proceeding?
Well, that would be very difficult for me to generalise, because that relies on the professional judgment of the case officer, the separated legal officer, and often is the case in complex matters, external counsel, and in relation to criminal matters, it would relate to the professional judgment of the CDPP.
So accepting that professional judgment is involved in that, is there any guidance given to them about what to look for to be satisfied that there is a proper basis?
I'm not personally aware of any guidance, but these are exactly the types of matters that we are looking into as a part of our enforcement review. I defer to the leadership of that review to a leading silk, Mr. Crennan, because these types of questions that you rightly ask are appropriately led by a person like Mr. Crennan, who has knowledge and experience of those types of questions and procedures that you ask about.
So turning from sufficiency of evidence to the proceeding not being contrary to the public interest, the second limb, Mr. Shipton, ASIC says in its response to the interim submissions that it must be evident from the facts of the case and all of the surrounding circumstances that the prosecution would be in the public interest. Do you see that in paragraph 45 of those submissions that I
Yes.
think you are looking at now? What does ASIC mean by that?
Well, my understanding is that there is a test which is applied in relation to taking a matter to court to determine whether or not it's in the public interest to do so. And in my experience and understanding, that most, if not every case, or the vast majority of cases, are in the public interest to proceed with.
Did you say most, if not all?
That's my experience, at least. Again, I do not practice and do not have expertise in the determination of these matters. This is not an area that I have practiced over my professional career. And from what I understand, it is a matter which is very case specific. And from what I understand, again, it depends on the circumstances and the considerations at the time. And I also understand, but I'm not an expert in, that there's a body of case law and a body of jurisprudence, as it were, around this topic. But again, I do not profess expertise in it.
Well, can I ask you about 4 matters that ASIC articulated in its submissions in response to the interim report might militate against bringing a proceeding in the public interest? The first of those was that litigation can be expensive and resource intensive, both in its preparation and its outcome. You referred to that in paragraph 48A of the interim report submissions, Mr. Shipton.
Yes.
Now, that is not an issue unique to civil litigation, is it?
Pardon me?
That is not an issue that is unique to civil litigation. It is a necessary corollary of taking any enforcement action that there will be a cost involved in doing that.
That's right, and usually, and oftentimes a very expensive cost. And this, my reference, and this is what I was talking about when I was mentioning about the resource constraints.
But a number of other enforcement outcomes can be expensive and resource intensive, such as enforceable undertakings that can require ongoing supervision by ASIC, such as the issues that we've seen in relation to the NAB-FX enforceable undertaking.
That is right, although in my observation, I find that civil litigation can be extremely expensive. And I would point out again that the BBSW experience for us, which was court-based enforcement, cost us $45 million. If we had lost, Ms. Dorr, if we had lost and had orders against us, that means we would have been looking at an expense of over $100 million. So these are the types of factors that we are alluding to in this paragraph.
So going to court also presents ASIC with opportunities to potentially recoup costs, doesn't it?
Exactly right, but there is no certainty. You're absolutely right, but there is no certainty.
Well, if you litigate and you're successful, then as a matter of course you'll ordinarily be entitled to your costs.
That is absolutely right.
And if you litigate and you're successful, then you have a specific power to make an order that the unsuccessful party pay the costs of your investigation under Section 91 of the ASIC Act.
And we are very proactively utilising that section, that provision. We did in BBSW.
But the power to recover the cost of a formal investigation in that way is contingent upon you litigating and succeeding. Is that right?
Correct.
And you've also got similar powers under Section 319 of the National Consumer Credit Protection Act?
It would appear so, yes, I believe.
But you can't make an order to cover the costs of a formal investigation if you use other sorts of enforcement outcomes.
I believe that to be the case.
So is that a factor that you take into account when you're assessing the potential cost of going to court?
Pardon me, would you be most kind to repeat the question?
The fact that you can, if successful, not only recoup your costs, but also make an order under Section 91 of the ASIC Act to recoup the costs of the investigation, is that a factor that you take into account when you're assessing the potential costs of litigation?
Yes, it would be.
Now, the second public interest factor that ASIC describes as potentially militating against litigating is that it can be time-consuming to prepare and conduct litigation.
That is correct, yes.
I want to suggest to you, Mr. Shipton, that that's not really a public interest factor. It's inherent in the nature of litigation that matters take some time to be prepared, heard and decided.
Yes, that is exactly right, and that is why in my earlier comments I was somewhat departing or adding to public interest and adding the resource considerations which we're now going across. I see the distinction, and that's why I was alluding to that distinction earlier.
I see. And the third public interest factor that ASIC says might militate against litigating is that civil litigation is uncertain in outcome.
That is certainly my experience in life, yes.
But there's no certainty that a court will find a contravention.
That is my experience, yes.
And there's no certainty that if a contravention is found as to the penalty that will be imposed by the court.
Correct, and I am minded by the BBSW experience of recent time, whereby our enforceable undertakings got a payment of 50 million in 2 cases, 25 million in 1 case, and when we went to court, we only got 3.3 in costs.
Well, Mr. Shipton, I don't want to comment, and I'm not going to ask you to comment on the specifics of particular cases in the courts, yes. But I do want to discuss this with you at a level of generality. Do you accept that when ASIC goes to court, it needs to have a very clear idea of the case that it is presenting for adjudication?
Absolutely, yes.
It needs to have a clear understanding of its interpretation of the law.
Absolutely.
And of the application of the law to the particular facts of that case.
Absolutely.
And it then presents that for the court to rule on.
It does.
And ASIC would not expect to win every case that it takes to court.
No, we don't.
And even with a very strong case, there are uncertainties that are inherent in litigation.
Correct.
There may be cases where ASIC loses a case on the facts, perhaps because a witness changed their account from prior to trial to during trial.
Huge amounts of variables, you're absolutely right.
And there might be cases where the court doesn't agree with ASIC's view of the law.
I certainly have experience of that, yes.
But in that situation, the court makes a pronouncement on what the law requires.
It certainly does.
and ASIC can use that pronouncement as a basis to consider whether it ought to press government to change the law.
It certainly does.
There are also uncertainties in other remedial outcomes, aren't there, Mr. Shipton? You don't know, unless you ask them, whether an entity who's been served with an infringement notice will accept it and pay it. You don't know whether an entity that's agreed to an enforceable undertaking will abide by that undertaking. There is a level of uncertainty in many of your remedial outcomes, is there not?
There's many uncertainties in everything that we do. I totally agree, although I would make the observation that that degree of uncertainty is resolved at an earlier, arguably less expensive point in time in the system than court-based enforcement actions. I am not saying for 1 second that we are reticent about moving forward, and I will highlight that the points that we went through in our interim response was merely what are militating factors. I want to make it crystal clear, we will be undertaking more court-based actions. We will be more adventurous, as it were, in pushing points of law. We will be taking more, let's call it risks, because we now have, through my direct engagement with the government, more funding to do exactly that.
What about the public interest in bringing proceedings? Mr. Shipton, you agree that there is one?
Totally, and that's why I just reinforced my commitment to bringing more actions, because I firmly believe that there is a public interest in using court-based admonishment and deterrence and punishment, particularly with larger financial institutions who have disappointed us and disappointed Australia so much.
ASIC intends to conduct more test litigation moving forward. Is that the impost of what you've just said and ASIC's interim report submissions?
Yes, my observation is that we should be testing the limits of the law more, because the case that is made in the interim report of the Royal Commission is a very strong one, that if we do hit at the end of a court process a roadblock, then that is a very clear, very strong argument to go to the government and say that we do not have the penalties and powers that we need to. Because my observation in the 9 months that I've been in this role is that we don't have right now, sufficient penalties. We don't have right now sufficient powers. And what we need to do is have those sufficient powers, have those sufficient penalties, and if there's any doubt or any weakness as regards our powers or penalties, then a very good place to display and realise that deficiency is a court judgment.
When you say you don't have sufficient powers, Mr. Shipton, what powers do you not have that are not pending?
Not pending. Maybe we can get onto this later, but I am a very strong advocate of the BEAR regime being extended across to our areas of responsibility and jurisdiction. I mentioned earlier that I believe that we should be having far more deterrent effect on business leaders in financial institutions, and to better enable the efficiency of that deterrent effect, having a BEAR regime that would apply to them would make a direct linkage and make that wish more effective.
Do you accept that there needs to be a fundamental change of mindset at ASIC towards the pursuit of court-based outcomes?
I believe there needs to be a very strong change in approach, procedures, and guidance. I used the expression, and deliberately used the expression, we made mistakes in relation to the case studies that you have raised today and yesterday. I like the word mistake because it includes the concept of being misguided. We could and will be doing a better job at providing guidance and direction to our people so that their mindset, their approach, their starting point, their starting proposition will be very different. We have a program of change and program of reform that I fundamentally believe in. And in fact, I remember saying when I first accepted this role, coming back from Cambridge, Massachusetts for a couple of days, I made public comments about the need for strategic change at ASIC. I had that belief in October of last year. I have that belief when I arrived on the 1st of February, and I firmly believe in its implementation right now.
Can I ask you about criminal proceedings, Mr. Shipton? What do you see, what does ASIC see as the purpose of criminal court-based outcomes?
Well, that is again going up the using the scale analogy, going to the most serious of extremes. I've been alluding to the enforcement pyramid of Professor Ayres and Braithwaite. To use that analogy, the criminal action is at very much towards the apex of that. For the most serious of matters, the most egregious of matters, and reacting and responding accordingly.
So do you accept that ASIC should pursue criminal action against larger financial institutions more frequently than it has?
Most definitely.
And how would you characterise ASIC's major failings in respect of pursuit of criminal court outcomes?
At the risk of getting into a debate about failings, I prefer mistakes. Again, I use the expression mistakes because failings, to me at least, this is my own understanding of the word, means that there's been no success, that there's been no functioning, which in my understanding of the word means that we haven't been doing it at all, and we have. So yes, we have made mistakes. Yes, there are case studies that you may want to take me to where, in my view, we should have, if the case was before us today, pursued criminal sanctions. And so in answer to your question, yes, we need to do it more often, and now we have a process and procedure and a program of change that I am expecting that mindset, that approach will be embedded.
ASIC has not given sufficient attention to whether it should pursue criminal proceedings, has it?
We could have done much better.
I want to ask you a few questions about this by reference to the Clearview life insurance case study that was dealt with in the 6th round of public hearings. You've also dealt with it in your statement. You know that ASIC engaged with Clearview about 2 distinct issues: breaches of the anti-hawking provision in the Corporations Act and concerns about mis-selling.
Yes, that's right.
And breach of the anti-hawking provision is a criminal offence?
It is, yes.
And the evidence in the Commission's hearings was that ASIC and Clearview began engaging about potential breaches of the anti-hawking provision in April 2016.
Yes.
And early on, ASIC formed the view that the matter was unlikely to, in the words used in the documents, go criminal. Have you seen those references, Mr. Shipton?
I don't recollect seeing those references at this point in time, but it is consistent with my understanding of the facts.
But over time, ASIC received further information about the potential criminal breaches and built up a picture of their significant scale. Do you agree with that?
Yes.
And by early May 2017, Clearview had told ASIC that it may have breached the anti-hawking provision up to 303,000 times over a 3-year period.
I understand that to be the case, but I want to be clear in this. I'm not sure whether Clearview have been so direct in their admission, but there certainly was a strong indication of that.
And despite that strong indication, ASIC did not seriously revisit its view that it had earlier formed that this was not a criminal matter.
That's right, that was a mistake.
And why was that mistake made?
I understand, and again, I wasn't involved, and my response, and I want to be very clear, my response now is just to give you context of what was going on at the time. The focus was to stop the pressure tactics, which were regarded, and I do have empathy with this view, as being egregious. There was also industry-wide concerns as regards pressure sales tactics. Clearview was not the only firm that was engaging in pressure sales. I understand that there were two other cases at that particular point in time, Select being one, Freedom being another one, which were far more egregious by terms of volume of pressure sales, and also that pressure selling was continuing. Given that we have in limited resources, I've mentioned the limitations of both and the size of resources of our enforcement team, which is about 240 people. The other team involved in this is our DCI team, that only has 80 people. So given that context, given what was going on, that is why a decision was made to focus in on stopping the pressure sales, stop this this misconduct, focus in our enforcement attention on more egregious pressure selling at Freedom and Select. And this is unfortunate, and I think it was a mistake not to pursue the anti-hawking aspects of this matter.
Isn't the purpose of the anti-hawking provision to try to eliminate situations where customers are subjected to sales processes, whether they involve poor sales practices or otherwise, without particular statutory requirements being met?
I personally agree with that assessment, yes.
So non-compliance with that provision is a very serious matter.
It is, yes.
And that's reflected in Parliament's decision to make breach of the anti-hawking provision a criminal offence.
I certainly agree with that, and I've made that point to the team. The fact that the Parliament of Australia has determined this to be a criminal matter means that we need to give it, any criminal matter, extremely serious weight and attention. I agree with that.
So you now accept that ASIC should have given consideration to criminal action against Clearview?
Absolutely, yes.
And it should have escalated the matter to the Enforcement Committee?
Most definitely, yes.
But neither of those things happened.
No, they did not.
Now,
that was a mistake.
Was there anything new about the evidence that was given in the 6th round of public hearings?
I'm not aware of anything being new, no.
But ASIC has, in light of those public hearings, reconsidered whether or not it will take criminal action against Clearview. Is that right?
Yes, I want to be very careful because there is, I want to be very careful here because there is a criminal investigation, and I need to be careful in my responses, so I'll be as helpful as I can.
Well before the hearings, ASIC had agreed terms with Clearview by which it resolved its concerns, hadn't it?
It did.
So ASIC has had to consider the effect of that agreement on its ability to pursue a criminal outcome now against Clearview.
Can I raise this? It's really up to the Commission, Your Honour, but it's ASIC's position that for the Chair to answer that question is potentially unhelpful to the prospect of those criminal proceedings.
I just don't follow, Mr. Collinson. You'll need to take me more slowly through the proposition you're putting.
Well, if I were to unpack it, which I can, I think I'll probably expose it too much, but perhaps I better just say it briefly. more that is said might expose and assist an argument by potentially charged parties that the initiation of criminal proceedings might involve an abusive process because of prior events.
Well, if there were an abusive process, and of course I simply don't know, but if there were an abusive process, that would be reason, would it not, to in fact expose the difficulty rather than to keep it private. isn't aren't you on the horns of a dilemma? The dilemma being this. There's consideration of whether or not to prosecute someone criminally. There may or may not be a bar or difficulty lying in the way of that prosecution. The difficulty or bar in the way of prosecution concerns the conduct of a public agency in its dealings with that person who may be the subject of prosecution. I must say my immediate reaction is to think that those factors point towards exposure than they point towards keeping confidential the considerations that bear upon whether prosecution can or cannot go ahead. But that's the problem.
Admissions might be made that would assist a person under investigation presently. And the question for the Commission is whether it needs to explore at this level of particularity in order to complete its work, and that should overpower the prospect of that criminal investigation going forward.
Ms. Orr, what do you say?
All I had asked, and all I wished to hear an answer to, was whether ASIC had to consider the effect of the agreement on its ability to pursue criminal action. I was not proposing to explore conclusions based on that consideration. So I don't know if that assists my friend.
If it's confined in that way.
Yeah, no difficulty. Very well. So put the question again, please.
So my
Mr. Hayne, why are you concealing the greatest fraud in this country, which is variable interest rate loans?
I ask you to
Variable
sit down,
interest rate
sir?
loans render a contract void for uncertainty.
Would you
And
give
yet
enough, please,
as
sir, to
dangerous
sit
fraud in
down?
this country, there was conspiring of the banks to
I'm
conceal
sorry,
this
sir.
great
I think that
fraud.
you are interfering
And
with the
I
work
put
of
in
the
a
Commission.
submission to this Commission, which included a transcript of the High Court showing the corruption of the judiciary in concealing this fraud. Variable interest rates render a contract void. I've got the name. Void for uncertainty.
Yes, Ms. Orr.
Mr. Shipton, my question was whether ASIC has had to consider the effect of that agreement on its ability to now pursue criminal action against Clearview.
I'm going to respond with one word, yes.
Thank you. And do you think it was appropriate for ASIC to resolve the matter with Clearview on the terms that it did?
No, I do not.
Thank you. Now, what does the Clearview case say to you about ASIC's attitude to and pursuit of criminal action against larger financial entities?
May I respond by saying what it says at that particular point in time about the decisions was that it was a mistake not to pursue a action of this seriousness in relation to a financial institution. That is yesterday's mindset. That is not the mindset that exists today of the ASIC of today.
Mr. Shipton, I want to turn now away from your enforcement measures towards other initiatives at ASIC, and I'd like to ask you some questions about what's been referred to as the CCM program.
Please.
Now, earlier this year, ASIC announced that it was going to begin putting ASIC staff on site at 5 financial institutions: ANZ, CBA, NAB, Westpac and AMP.
Yes, that's right.
And that is the Close and Continuous Monitoring Program, or the CCM program.
That is that program, yes.
So I want to ask you some questions about the aims of that program and how it's going to work in practice. Now, in your second statement, you said that in your experience in Hong Kong, you saw how extended on-site supervision approaches applied to individual institutions worked to identify and address the risk of harm from misconduct.
That's correct. And in fact, I believe I referenced some of the work that we did, or I did, my team did in Hong Kong, whereby we were able to, or the SFC team was able to identify thousands of breaches through, I think, 1,500 breaches through 300 on-site inspections. So that speaks statistically to these types of programs. I can also speak to being a regulated person, being the subject of both on-site supervision in Hong Kong and being subject of the American equivalent through the New York Federal Reserve. So I can speak to this subject matter both as a regulator but also as a regulated person.
When you arrived back in Australia earlier this year to take up your position at ASIC, were you surprised that ASIC didn't already have a similar program?
Yes, I was, and I understand that one of the reasons being was resource constraints. I will quickly add that my colleague Commissioner Armour has been utilising this very effective tool in the market space during her tenure as a Commissioner.
Did you think when you got to ASIC that ASIC was doing enough to proactively address the causes or drivers of misconduct as opposed to responding to misconduct that had occurred?
I think we could have done better, and the sequencing of my thinking was after a number of months in the role and after a number of months of returning back to Australia, I realised essentially two things that we needed to do very quickly, and that was accelerate our enforcement outcomes and embark upon new supervisory approaches, including but not limited to the CCM, and that is a conversation that I had with the government and then resulted in August for funding for those two programs amongst others.
So that funding, which we referred to earlier in your evidence, was given after Treasury invited ASIC to submit a funding proposal for new strategic initiatives. Is that right?
Correct. There'd been some correspondence before that invitation. There had also been representations by me to the very most senior members of the government on these matters.
And the CCM program was one of the strategic initiatives that ASIC proposed in response to that invitation?
Yes, that's right. I think I referred to yesterday as this being a surge approach or a mid-year approach or out-of-cycle approach. It was not only an out-of-cycle approach for us, but to give context to the government, it was also an out-of-cycle funding for them.
Could I take you to the letter that you wrote to the Treasurer and the Minister for Revenue and Financial Services when submitting your funding proposal, ASIC 0076 0001 4411? We see in the last paragraph of that page, this is your letter, I'm sorry, Mr. Shipton?
Yes, I recognise this letter, yes.
Yes, from the 28th of May this year to the Treasurer and the Minister for Revenue and Financial Services. We see in the last paragraph on this first page that you explained that you wanted to make significant changes to the direction of ASIC and the way it does its regulatory work, and that your key changes were accelerating and expanding enforcement activities and embedding new supervisory approaches, which involve more dedicated and intensive supervision for our most important financial institutions.
Yes.
And then if we turn to 4415 in this letter, we see some more detail at the bottom of the page about the CCM program. You said that ASIC has traditionally taken a risk-based approach to surveillance, This means the surveillances are focused on a specific incident or transaction or involve reviewing a thematic systemic issues across multiple institutions. This contrasts with risk-based supervision, which involves ongoing monitoring of an institution.
Yes, that's right.
And over the page at 4416, you referred to the new approach that you considered was required, this is in the first paragraph, involving dedicated staff assigned to supervision or close and continuous monitoring of the entities. You see that?
Yes, I do.
Now, you didn't give any information in this letter about the type of supervision you wanted your staff to conduct or provide further details about how you thought the program would work. And I want to come to that later, but at this point, those details were not provided.
That's correct. This was a framework or an outline of the ideas, of course, pending funding and pending support to enable that, yes.
And we see in the third paragraph on this page that you describe this as one of a number of initiatives that would require coordination with APRA. Do you see that?
Yes, most definitely.
And APRA has conducted prudential supervision of ANZ, CBA, NAB, Westpac and AMP for many years, hasn't it?
That's right. Their prudential supervisory team has been operating for quite some time. Their supervisory approach, as I understand it, is slightly different, and of course their focus, being prudential, is distinct from our role.
What do you hope the CCM program can achieve that is different to what the APRA supervisory work does?
Well, the starting point for APRA is the safety and soundness of financial institutions, and that is an absolutely fundamentally important role. Our starting point is the good conduct, the good conduct of financial institutions, the adherence to the laws and regulations of the land, and what we think should be better outcomes and better awareness of the fact that there are consumers involved, consumer conduct in matters involved when it comes to financial institutions. So that is the different starting points. There is degrees of overlap and coordination necessary, but we both, under the Twin Peaks model, come from different ends of the Twin Peaks spectrum.
And did you consult with APRA before you put this proposal to Treasury?
Yes, I made Chairman Byers aware of this approach and sought his support and understanding that we'd be working together. Chairman Byers and I have a number of initiatives that we'd like to do more of, including, and it's not included in these documents, the greater utilisation of supervisory colleges for the larger financial institutions, so that we look at large financial institutions from different angles, from the prudential angle, the conduct angle, and we would include other regulators as well.
And what was APRA's view of ASIC conducting supervisory work alongside APRA's supervisory work?
I remember Chairman Byers being extremely supportive and encouraging.
Could I tender this document, Commissioner?
A letter from the Chair of ASIC to the Treasurer, 28 May 18, ASIC 0076 001 4411, Exhibit 7.76.
So in August of this year, Mr Shipton, the money came through and ASIC was given about $8 million in funding for the CCM program.
That's right, I think it was 7.8 million to be exact,
yes.
Over 2 years.
And the first on-site supervision began at the end of October when a team of ASIC staff went to CBA's offices in Sydney.
That's right, and that is what I would call a rapid response.
Yes, ASIC had about 3 months between finding out that this program would be funded and deploying its staff to the first entity.
Correct, not only deploying staff to the first entity, but, and this is crucial to, I think, the effectiveness of the role, securing senior staff members to lead these teams. We're calling these senior staff members senior supervisory officers because we needed to have senior people who could have direct, robust and frank conversations and provide feedback to the senior most officers of a financial institution. So part of the difficulty in getting the rapid response is to take two people, two very fine professionals, out of existing important roles and transition them across to the SSO role, the Senior Supervisory Officer roles.
So ASIC didn't hire new staff with experience in supervising financial services entities for the program?
It's very different. In my observation, as being a regulator over different jurisdictions, it is very difficult to find people with direct, demonstrable regulatory and supervisory experience. We would have to, in my quick observation, and I did think about this, but unfortunately it was discounted as impractical. I thought about the possibility of bringing in people from overseas, particularly the United States or Hong Kong, who I knew, but that was impractical. And I have faith in the team that we have now sort of assigned to these roles.
So instead you redeployed existing staff at ASIC, and do they have experience in on-site supervision of financial services entities?
One of them has, I believe, yes, one of them certainly does. And both of them, though, I will quickly add, both of them have many years of what I think are very important leadership roles in regulation and supervisory type functionality, and I have every faith and confidence in the two leaders of this project and the men and women who work with them.
My questions were not just directed to the leaders, Mr. Shipton. As I understand it, those two people, the two chief supervisory officers, have two teams of people working under them. So do the people working in those teams have experience in on-site supervision of financial services entities?
They wouldn't have, not many of them would have that much direct experience yes, because just of the nature of the work that has been conducted at ASIC over many years. So that was part of the challenge, and there's undoubtedly challenges to this, of building a team and responding rapidly in those few months that we had.
Will the teams be assigned to particular entities, or are they going to rotate between the entities?
Ultimately, they'll rotate between the entities. There will be, we've got some guidelines. I believe I've attached them to my witness statement, some protocols around professional behaviour and on-site professional behaviour during the conduct of these on-site supervisory functions, and that there will be a program of rotation, which is important, I think, for best practice, but also important for benchmarking and comparison, and it's good regulatory practice.
Why is it best practice to rotate them?
In part, as I said, so that there is a greater degree of benchmarking, so that a supervisory officer will understand across the spectrum of financial institutions, as opposed to only seeing a small number of them. That is one operational advantage. The other issue that we are very highly attuned to is the risk of regulatory capture. And there has been some case studies out of the United States that we have used for training purposes, so that the supervisory officers involved are attuned to some of those regulatory capture risks before they start their work.
Now, you said earlier that the first team went to CBA's offices at the end of October, and Mr. Common gave evidence earlier this week that CBA had volunteered to go first in the CCM program. Was that taken into account by ASIC?
That was not taken into account, but their readiness was acknowledged.
And has there been any feedback from your team at CBA about how they're progressing?
There has been some very clear feedback from our team as to the system structure of CBA, and there will be more feedback. And from what I understand from the Chief Supervisory Officer involved in CBA, that feedback will be very powerful, very important, and this goes to the ultimate aim of the CCM and on-site supervisory project will improve, we think, the systems, processes and mindset of that particular institution and hopefully the other institutions very soon and very quickly.
So did I hear correctly, you said you had had feedback as to the system structure? Was that what you said?
Yes, so what we have started to do, and this is, let's call it an entry point, we have started the entry point into these 5 financial institutions is to start by looking at their breach reporting processes and procedures. This builds on the body of work that you and I discussed yesterday on our breach reporting compliance report. We have a body of information that is a baseline and a starting point to be applied and reviewed by the team. And the feedback, as I understand it, as this has been interrogated and explored, even though only over a short period of time, is very powerful. And being able to have a Chief Supervisory Officer give direct feedback on some of the system failings inside the financial institutions, in this case, in relation to breach reporting, is very powerful. And if I may quickly add, one of the concerns that we have found is that we worry about the raw, real message getting through to the senior-most leaders of an organisation, the CEO and the boards of directors. We worry that the message is being filtered as it goes up that hierarchical chain. Chief Supervisory Officers will disintermediate that filtering and give raw, frank, blunt, but very real feedback to the people who need to hear it.
You've mentioned a number of times in that answer that this is powerful. What is powerful about it? What is it that is being described to you as powerful from the feedback so far?
The fact that the reason why it's powerful is motivated not only from my feedback and my understanding of the very short weeks of the operation of this role, of this initiative with CBA, but it's also a personal experience. And starting with my own personal experience, I was working at a financial institution before it had on-site supervisory oversight by the New York Federal Reserve. And then over a weekend during the financial crisis, it had on-site supervisory oversight by the Federal Reserve. And even though I was sitting in Hong Kong, half a world away from these supervisors, I sensed a change in approach by the leaders of the financial services firm that I was working for. I also was the subject matter, and this is quite paradoxical, I was also a business leader subject of an on-site supervision by the Hong Kong Securities and Futures Commission when I worked in a business called the Prime Brokerage business. And I remember my mindset changing when I had my own interaction, probably for the first time as a regulated person, with a regulator. My mindset and the mindset of my senior colleagues beside me changed, because even though we were middle management, as it were, we had for the first time direct engagement and interaction with a regulator. That changed my mindset, that changed my colleagues' mindset. So I took these personal experiences, which are very, in my mind, powerful, and then I'm seeing it play out through the prism of the interactions between the Chief Supervisory Officer and Mr. Common, and I am seeing very clearly the same feedback that my colleagues and I had when I was subject of these types of supervisory approaches. Hearing the message in terms which aren't couched, hearing something directly in detail from a regulator is very powerful and very meaningful. And I think that it will have a big impact over time if we can expand it.
Well, I want to understand a bit more about the CBA experience, Mr. Shipton. What is the message that CBA is hearing from those conducting the CCM at CBA?
Well, it's very short because we've only been in there for a very short period of time. But the initial feedback is that we are not confident that the messages that we're seeing when we look at individual case studies, the concerns as to the way those case studies were handled, how they are escalated, we are not confident that that raw message, that clear, important message, is being escalated in direct and frank and clear terms to the senior-most leaders.
I want to make sure I'm understanding this answer. I'm asking you about the message being conveyed by those who are conducting the close and continuous monitoring.
Yes.
What is the message that they are conveying to CBA?
Oh, well, you mean more broadly?
No. What are they doing there, Mr. Shipton?
They are, as I said, they are looking at the processing, the systems, the reporting, the escalation, the dealing with of breach reports. We have a body of cases which we became aware of through the breach reporting compliance project that you and I discussed yesterday. So we have a starting baseline, we have a body of knowledge.
Yes.
What we are now doing is a deeper dive into some of those case studies. And by doing a deeper dive into some of those case studies, we are diagnosing these issues and concerns. In other words, we're getting to a level of detail and passing on that detailed message to a CEO and potentially to the board that they probably haven't heard before. And that level of raw detail is important.
So I want to understand more about how that works. They're conducting a deeper dive into those issues, those systems and reporting issues, based on a number of cases that you identified in the work that was the subject of Report 594. Is that right?
That's right.
So what do? Do they get their call for documents about those cases and read those documents?
Yes, they're looking at those documents. They're now speaking directly to the business leaders who are involved in those case studies and the legal and compliance officers who are directly involved in these case studies, as opposed to, which is a more traditional approach, things being filtered through the General Office of Compliance or the General Office of Reform. We're going directly to the people involved in those case studies.
You are sitting in the premises of that entity. You are reviewing documents which you could pull into your own premises under your compulsory information gathering powers, but you are reviewing those documents at the premises of the entity, and you are then having conversations at those premises with representatives of the entity about what you are seeing in those documents. Is that right?
Yes, there is. I will add that probably a large part of the document review would be taking place at our offices.
I see.
A large part of that.
So what exactly happens at the offices of CBA?
We will be doing a tremendous amount. We will be reviewing documents there, and we do review documents because we will ask for a document, and that document will, if a document comes, it is apparent that a document would be useful to have a look at, we will ask for that document, and it's entirely possible that that document could be produced on-site and reviewed on-site.
Right.
We will also be asking and spending time. In the case of CBA, we've been assigned a meeting room, which is for our dedicated use, which is sequestered in a way so that we can keep our own material confidential. But we will be interrogating and speaking and discussing and asking questions and finding out more information with those individuals who were involved in these particular case studies. On-site supervision is essentially, in my experience, both as a recipient of it and as an executor of it, it is a matter of sitting in a room and starting to ask questions, getting to know the business, drilling down into detail, following leads, being inquisitive, asking questions, and really delving into a particular matter so that we can diagnose the issue and the problem very precisely.
So you have your meeting room within CBA and you have the documents you've called for, which you can read in that meeting room, and can you then invite people in and ask them questions in that meeting room about what you've seen?
Yes, and that's my experience. And again, we've only been in CBA for a short period of time, so we only have a handful of days of operation to work from. What I'm now describing is my intention and my experience of how it has worked, having run programs of this nature before, how it works. So yes, we will be calling in, we will be asking. It seems as if it would be useful if we could speak to person X, because person X seems to be referenced in this document or in this process. So to better understand what person X does, we will ask to speak to him or her.
And apart from inviting people into your meeting room to speak with them there, is it intended that your representatives will sit in on meetings that are going on within CBA and observe those meetings?
Possible, although we are cognizant and aware that trying to be a fly on the wall is extremely difficult because, of course, behaviours will change. There's an experience. This is an experience from overseas, so I doubt there will be much effectiveness of doing that. What I do think, though, is very powerful, and again, I've had this on both sides, is having long, detailed question and answer sessions with middle management business leaders. That is incredibly powerful. And may I also talk about a secondary derivative of this, which actually is a very powerful one. The more people we interact with in the body of the organisation, the more the message gets out as to what our real motivators and drivers are. People's attitude inside a financial institution can, will, and do change once they have been interrogated and interacted with a regulator. That is a very powerful tool because, as I said, we are now speaking to people who have probably never been spoken to by a regulator in their career in an environment which is not a formal investigation but is a supervisory one in nature, which better allows what I think an understanding of the broader business and how a business is conducted with a mindset of good governance, adherence to the law, and ultimately good conduct for consumers.
So, Mr. Shipton, how many people are you sending in to occupy the meeting room at CBA?
We would, at the moment, I think our teams are very limited because we're resource constrained. I think our teams are probably half a dozen or so.
How long will they be there for?
They will be coming and going, hopefully forever, but we only have funding for 2 years.
And coming and going with what sort of frequency?
We hope that they'll be coming and going with at least bi-weekly frequency, But we must remember we're only funded to about 16 to 20 headcount. We're covering 5 institutions. These institutions are all over the country. So this is just a starting point. This is a launching pad. And those folks in our supervisory team, they will be expected, as they rotate and move around, to be spending as much time as possible on site gathering information as they can. As I said, there's going to be back and forth. I think that's very good practice. I don't think being embedded or being permanently on site is good practice, but by having frequent on-site physical presence, in my experience and observations over the globe, is a very good regulatory tool.
And what is the work product, from your point of view, that the people in the meeting room will produce? At the end of intervals, do they produce some sort of report that they bring back to ASIC about CBA, containing recommendations or proposals that will be passed back to CBA? What happens? Yeah,
so there will be. So this body of work in relation to breach reporting will ultimately end up with a series of ongoing reports to CBA on what we believe are the system faults, the system failings, where we believe there could be improvements, where we believe there are deficiencies. That feedback will take place. Equally, the other output is that this feedback will be given to other members of our own team and indeed to APRA, so that other members of our team who interface with CBA in this case will have knowledge and understanding of what we're finding inside that institution. And then broadening it out, and I mentioned this before, we want to utilise what's called supervisory colleges more often, which is working with APRA, working perhaps with the New Zealand regulators, and sharing all of these knowledges, presentations, feedback amongst our regulatory peers, so that all of us in Australia, New Zealand, prudential conduct regulators have a much better understanding of an organisation like CBA. That means that we can better supervise and regulate. And another byproduct is, and this is my experience in Hong Kong, I expect that we will often come across misconduct. And that misconduct will then be escalated and referred to the enforcement teams as appropriate.
The ongoing reports that you're going to provide to CBA, will they be made publicly available?
We would consider making them publicly available, but we can consider that. I haven't turned my mind to that particular question. My observation of seeing this in practice in the United States and seeing this in practice in Hong Kong is that the most powerful, a very powerful weapon is that direct feedback. I've personally been involved when I was in Hong Kong of providing direct feedback to senior-most leaders of financial institutions at the end of our project, and that is very powerful. I think we would reserve the rights, again, subject to the protocols that I understand we have in place about the making public of information, because I do understand that there are protocols and restrictions on information that we can make public. But subject to that, that is certainly something we would keep in mind.
And do you anticipate that those reports will contain recommendations to CBA about changes that they ought to make?
Yes, I mean we can certainly highlight, but I do want to clarify. This is not an on-site compliance department. This is not an on-site strategic guidance firm. What we will be doing is making observations in relation to what we believe are deficiencies or areas for improvement. Our role is not to be their compliance department. Our role is not to be their strategy department. Our role is to give frank, honest, blunt, and very important feedback as to where we see potential deficiencies, where we see room for improvement, and where we see that the leadership, system, structure, and importantly, culture of financial institutions can improve.
That's a convenient time, Commissioner.
Yes, just before we adjourn, Ms. Orr, you may step down, Mr. Shipton. The solicitor for the Commission has received the following communication from Gilbert and Tobin, solicitors for Westpac. Westpac wishes to clarify a matter that arose during Mr. Hartz's oral testimony yesterday morning. From around transcript 6850, line 30, Mr. Hodge asked Mr. Hartzer questions in relation to arrangements concerning BTGL authorised representatives and the issuing of fee disclosure statements, FDSs, and opt-in arrangements for ongoing advice services. By way of clarification, BTGL authorised representatives are not required to provide opt-in notices from pre-FOFA clients on a biennial basis. By way of further detail, we note the following. BTFA employed advisors. Renewal notices, referred to as opt-in notices, are required to be issued biennially for all ongoing advice customers. FDSs are required to be issued annually for all ongoing advice customers. BTGL authorised representatives. Opt-in notices are required biennially for all post-FOFA ongoing advice customers. Opt-in notices are not required for any pre-FOFA ongoing advice customers remaining. FDSs are required to be issued annually for all ongoing advice customers. Westpac apologises to the Commission for any inconvenience caused. That letter having been received this morning, I thought it right that I should read it publicly so that there should be no doubt about what has been communicated to us about those matters.
Thank you, Commissioner.
Now, Ms Orr, 2 p.m.
Yes, thank you, Commissioner.
Yeah. Yes, Ms Orr.
Mr Shipton, you mentioned earlier BEAR, the Banking Executive Accountability Regime. Now, I want to ask you some questions about that, but I want to summarise a few propositions first. BEAR currently applies to the largest banks in Australia.
Yes.
And it imposes a series of obligations on those banks. There are the notification obligations, which require the bank to identify the accountable persons who are responsible for the bank's operations.
Yes.
And there are the key personnel obligations, which require the bank to make sure that the responsibilities of the accountable persons cover all the operations of the bank.
Yes.
And there are the deferred remuneration obligations, which require the bank to defer a particular proportion of the variable remuneration of accountable persons for 4 years.
Yes.
And the accountability obligations. Each accountable person has 3 accountability obligations. Do you agree?
Yes.
They need to conduct the responsibilities of their position as an accountable person, firstly by acting with honesty and integrity and with due skill, care and diligence. Secondly, by dealing with APRA in an open, constructive and cooperative way. And thirdly, by taking reasonable steps in conducting those responsibilities to prevent matters from arising that would adversely affect the prudential standing or prudential reputation of the bank.
Yes.
And the bank itself, as well as the accountable persons, has similar accountability obligations.
Yes.
But in the case of the individual accountable persons and in the case of the bank, the obligation to take reasonable steps to prevent matters from arising relates to matters affecting the prudential standing or reputation of the bank.
Yes.
And that is why BEAR, in its current form, is administered by APRA.
Correct.
Now, the BEAR is based on a similar regime in the UK called the Senior Managers Regime.
Yes.
And are you familiar with the Senior Managers Regime, Mr Shipton?
I am familiar, yes.
It's broader than BEAR in a number of ways. It firstly applies to a broader range of entities, do you agree?
Yes.
Not just to banks, but also to insurers and other financial services firms.
Yes, that's my understanding.
And in the UK, the Senior Managers Regime is jointly administered by the Conduct Regulator, which is the Financial Conduct Authority, and the Prudential Regulator, the Prudential Regulation Authority.
Yes.
And the obligations that the Senior Managers Regime imposes on individuals, this is the other aspect of the greater breadth, aren't limited to matters affecting the prudential standing or reputation of the firm.
Yes.
They extend to the conduct of individuals more broadly.
Yes.
Now, there are 2 sets of conduct obligations imposed on individuals by the Senior Managers Regime. Could I ask you to look at RCD 0006 0016 0746? Now, this is a document produced by the Financial Conduct Authority about the Senior Managers Regime. And could we turn to 0789, where we see the 2 tiers of conduct rules under the Senior Managers Regime? Do you see in the table, if we could perhaps, thank you, the first tier, the individual conduct rules, apply to almost all employees of financial services firms. Is that right?
Pardon me?
The first tier, the individual conduct rules, are you aware that they apply to almost all employees of financial services firms?
Yes, I am. I believe that there is a pyramid of, as it were, of different degrees of application, but yes.
And the first tier is the tier that applies to most of the employees.
That's my understanding, yes.
And so the conduct rules for those employees are: you must act with integrity, you must act with due care, skill and diligence, you must be open and cooperative with the FCA, the PRA and other regulators, you must pay due regard to the interests of customers and treat them fairly, and you must observe proper standards of market conduct.
Yes.
And the second tier of conduct rules apply to senior managers of financial services firms. And they require senior managers to take reasonable steps to ensure that the business of the firm for which you are responsible is controlled effectively, to take reasonable steps to ensure that the business of the firm for which you are responsible complies with the relevant requirements and standards of the regulatory system, take reasonable steps to ensure that any delegation of your responsibilities is to an appropriate person and you oversee the discharge of the delegated responsibility effectively, and you must disclose appropriately any information of which the FCR or PRA would reasonably expect notice.
Yes,
Now,
the FCA, yes.
That's right. Now, what I want to ask you, Mr. Shipton, is whether ASIC supports expanding the BEAR so that it is administered by ASIC in relation to conduct, as well as APRA in relation to prudential issues.
We support the extension wholeheartedly of the BEAR regime to cover conduct, and we would propose to work collaboratively with the APRA, who would continue to have oversight on the prudential aspects.
So you don't think that you should move to joint administration of the regime? You would leave administration of the regime with APRA?
That is something that we are open to. I understand from the UK regime that there is joint administration. I'm not ruling it out. My earlier response was just to say that I wholeheartedly support the current regime, whereby APRA has ownership and carriage of the oversight in relation to prudential matters. I will quickly make an observation, as I understand it, with the UK regime is slightly different. Their Twin Peaks is slightly different because the FCA does have, in certain cases, prudential oversight responsibilities.
So you said that you supported the extension to cover conduct. Do you think that the accountability obligations imposed by BEAR should mirror the sorts of conduct obligations that are imposed by the senior managers regime?
Most definitely, yes. And if I remember correctly, there is quite a long list of conduct-related responsibilities under the UK regime, including more detail as to these conduct responsibilities. And I believe that is a very good starting point for us to consider here in Australia.
We see from the explanatory memorandum for the BEAR amendments that one of the reasons why the BEAR was restricted to matters affecting the prudential standing and reputation of banks was to avoid potential confusion of regulatory roles. Do you have any comments about that?
My only comment to be made would be that in my observations in different jurisdictions, we need, regulatory agencies need to be working very collaboratively, cooperatively across a range of issues, and that requires management leadership attention, and it is an ongoing challenge, but I do not see it as an impediment for the extension of a BEAR-type regime here in Australia.
Mm. And if the BEAR obligations were extended to the sorts of conduct rules that are on the screen at the moment, then in what kinds of circumstances would you envisage ASIC commencing enforcement action against an accountable person for failing to comply with those obligations? It's
difficult to respond in the abstract, but I was alluding to this earlier, these types of structures provide a direct linkage and a direct responsibility so that it can be clearly established in the event of a failure to adhere this, that person X was responsible for the oversight of that particular area, and if there's a failure in that particular area, then enforcement actions could ensue. So I think these types of regimes and models are very important for enforcement accountability, but equally, and I was involved in the formulation of a similar regime in Hong Kong, which is called the manager in charge regime. And my practical observation was that one of the first steps was just merely mapping out who is accountable for conduct oversight is incredibly important and powerful.
Can you give an example of how ASIC might have dealt differently with one of the matters that I've asked you questions about in your evidence if you had had additional powers under an expanded BEAR regime?
Well, again, it's difficult for me. It's difficult for me to generalise, and it's difficult for me to answer that question in relation to the case studies because I do not know the responsibility map or the accountability map that would exist in a scenario if it were to occur under this type of regime. But each and probably every one of the case studies that we have discussed today would clearly point to, as a part of that responsibility map, that part of that accountability map. And in the UK, they have responsibility statements which clearly articulate what type of responsibilities each individual manager and leader has. Then you could clearly delineate which person, which senior manager was responsible for the conduct and the conduct failures. So you could likely, in most if not all cases, draw a direct line between the misconduct and who was responsible in the leadership and management of that financial institution for that not to happen.
I tender that document, Commissioner.
Senior managers and certification regime, RCD 000600160746, Exhibit 7.77.
Now, Mr Shipton, I'd like to take you to another document about the senior managers regime published by the Financial Conduct Authority, RCD 000600160032. Now, this is a document published this year by the FCA about the senior managers regime, and if I could direct your attention to 0034, which contains the foreword from the chair of the FCA. We see in the second paragraph of the first column, the chair says, speaking of FCA's responsibility for ensuring that financial markets work well by protecting consumers, protecting and enhancing the integrity of the financial system and promoting effective competition, he says, these important responsibilities are supported by a robust framework of accountability and transparency. We are accountable to the Treasury and to Parliament with detailed public scrutiny exercised by the Treasury Select Committee. We are open and accountable to the public through the publication of our annual report and our annual public meeting. We are subject to examination and certification by the National Audit Office. Now, that accountability framework is broadly analogous to ASIC, save that the parliamentary committee here is the Parliamentary Joint Committee on Financial Services.
We also have additional parliamentary committees,
Yes.
House of Representatives and Senate Economics, but broadly similar, yes.
Yes. Now, moving to the second column in the second paragraph, the chair says, we want all those involved in financial services to be able to trust that their regulator and the firms it regulates have their best interests at heart. That is why we believe our senior management should meet standards of professional conduct as exacting as those we require from regulated firms. He then speaks about the senior managers regime in the last column, describing it as a formal expression of the common sense good governance practice that any organisation should adhere to. It was created against the backdrop of a clear and shared understanding that a culture of personal responsibility must be embedded at the heart of financial services. This is true of firms and regulators alike. We are not formally subject to the regime, but we uphold the highest professional values, and our stakeholders, including Parliament and the Treasury Select Committee, rightly expect us to do so. In line with this, we have decided to apply the fundamental principles of the regime to our senior staff. You see that?
Yes, I do.
Now, does ASIC propose to apply the principles of BEAR to its senior staff, as the FCA has done with the senior managers regime?
I think it's an excellent suggestion, and I have looked at this paper in reasonable detail, and I think it provides a good governance framework for regulatory agencies. As I was mentioning before, in my own personal experience in designing a similar regime in Hong Kong, I found that that first step of that accountability map was just plain good practice of good governance. I've looked at this, and I am minded to apply this form of rigour to our own organisation, because I also have, and this has been an agenda throughout my time, because as a part of my reform agenda, I'm very mindful of what I call hypocritical risks of a regulator. If we expect something of the regulated community, we must be holding that standard to ourselves. And I have asked our team well before I came here today to undertake what is a review across our organisation of making sure that we are holding ourselves to the highest standard of account, using as a benchmark the standards we expect of others.
So do I take from that answer, Mr Shipton, that you do propose to apply the principles of BEAR to your senior staff?
Yes, as I said, I am minded to it. I would like to have more. I'd like to get into this in more detail. I'd like to share this idea more broadly with my commissioners, but I am going to propose it to my fellow commissioners, and we are at the moment embarking upon a transition of our structure whereby we are delineating new roles and responsibilities, and I think the model that is provided by this document is an excellent model.
And if obligations analogous to those in BEAR were to be applied to ASIC, do you think that should be done by ASIC publicly undertaking to be bound by those obligations in the way the FCA has done, or by a separate statutory accountability regime established either specifically for ASIC or for regulators?
Well, we're getting into a lot of sort of potential detail, but I think the starting point is, as I mentioned before, to propose to my fellow commissioners that we should be holding ourselves to this account and should be presenting to Parliament and the public what I think an excellent model here.
And you don't have any views at present about how, if that proposal is accepted, you ought then execute that?
Well, I think, again, I haven't had time or the ability to workshop this idea with experts. I would, for instance, like to speak to my peers and colleagues in the FCA, who I know very well, about their experience and what works and what their experience are in relation to this. But I'm certainly very open-minded about ways that we can better ensure our accountability by using different frameworks. And I mentioned in my witness statement, and I believe this is also in the interim response to the interim report, we want to work with parliamentary committees about better assessment frameworks of what we do, and I see this as an excellent example of such a framework.
I tender that document, Commissioner.
Senior Management Regime, RCD 0006 0016 0032, Exhibit 7.78.
Now, Mr Shipton, I want to turn to ASIC's organisational structure. As you indicated in answer to one of my questions earlier, ASIC's current members are you as the chair, 2 deputy chairs and 4 commissioners.
Yes, that's right.
So ASIC's governing body is comprised entirely of executive members.
Currently we are structured as executive commissioners, or commissioners with executive responsibilities is probably the best way of putting it.
Well, there are no non-executive members of your governing body, are there?
Sorry, that's exactly right. We do not have non-executive members of our commission.
And that's in contrast to the Financial Conduct Authority, which we've just been speaking of. That entity has both executive and non-executive members of its governing body.
It's in contrast to the FCA and also in contrast to the Securities and Futures Commission in Hong Kong, of which I was an executive director and board member of, or commission member of.
And in contrast to the ACCC and the Competition and Markets Authority in the UK and the Reserve Bank.
Yes, in contrast to those, or as I understand it, yes.
So do you think there are risks in ASIC having a governing body, unlike all of those organisations, that is comprised entirely of executive members?
There are concerns that I have when I look at the current operational framework and operational responsibilities of the ASIC Commission, and that is why I'm of the firm belief that our current structure should move to one whereby commissioners of ASIC do not have day-to-day executive responsibility, and that executive responsibility, that day-to-day executive operational responsibility, should be moved to another class or strata of leaders and managers. And I believe that that is the optimal structure. I will quickly observe that in the last 3 or 4 years, both as a regulator in Hong Kong under one structure, and then spending some time thinking about this when I was at Harvard University, I actually believe that the optimal model is full-time commissioners with relevant experience providing strategic oversight, strategic challenge, and strategic direction, because that, I think, is the optimal model for a regulatory agency.
It would be regarded as poor governance practice for a large listed entity to have a board comprised entirely of executive directors, wouldn't it?
It would be, yes.
Why wouldn't the inclusion of eminent non-executive members on ASIC's governing body assist in the good governance of ASIC?
I'm not ruling that out. What I am saying is that I believe, and my own observations, having thought about this for a number of years from a number of different angles, and having looked very closely actually at the models in the United States, at the SEC and the CFTC, that the optimal model is full-time commissioners who do not have executive responsibilities, but are providing full-time strategic oversight, strategic direction, strategic guidance, and challenge to the executive group.
In 2015, Mr. Shipton, a capability review of ASIC was undertaken by an expert panel, wasn't it?
It was.
And that review resulted in a report being provided to government in December 2015.
Yes.
And you've annexed a copy of that report to your statement. The expert panel made a large number of recommendations, and they included recommendations in relation to internal governance.
Yes, they did.
And one recommendation was that ASIC realign internal governance arrangements by elevating the current commission role to that of a full-time non-executive function with a commensurate strategic focus and external accountability free from executive line management responsibilities. These are the sorts of things you've just been raising with me.
Yes, and I remember reading that at my desk in Hong Kong in 2016, and it resonating then, and it resonates with me now.
The expert panel also recommended that a new role of head of office be established with delegated responsibility and accountability for executive line management functions. Do you recall that?
Yes, I do.
And both those recommendations flowed from the expert panel's view of the dual roles of the Commissioner. Do you agree?
I understand that to be the case.
And the panel said that it believed that a dual governance and executive line management role inherently undermined accountability.
I believe that was words to that effect, yes.
And it also referred to this as creating insufficient bandwidth for strategic decision making.
Yes, I remember that line.
And the panel concluded that there would be a number of significant benefits from the governance model that it proposed, including clearer lines of accountability and oversight, and allowing the commissioners to focus on strategy matters.
Yes, I'm clearly influenced by those sentiments.
But ASIC responded to the capability review in April 2016 and did not embrace those proposals.
I understand that to be the case.
And ASIC expressed the view that the new model would tend to undermine rather than enhance its strategic focus and accountability. Have you seen that?
I have seen that, yes.
And what observations do you make about that response by ASIC?
I would take a different view to that response at that particular point in time.
You've spoken publicly about the capability review.
Yes, I think I've spoken very publicly about how I wish to embrace it.
And in your assessment, was ASIC's response to the internal governance recommendations capable of addressing the issues identified by the panel?
I think we needed to go further, and we are going further.
In your statement, you identify a number of changes arising from the capability review that ASIC has made since you took over as chair.
Yes, they have been my first order of priority in the 9 months that I've been here.
And they include a very recent step of creating a new level of senior management known as executive directors.
That's correct, yes.
And the Commission approved on the 5th of November, so a very short time ago, that commencing on the 1st of January next year, your commissioners would cease to have day-to-day operational and executive responsibilities, and they would adopt a strategic oversight, review and external engagement role, with the 10 executive director roles established to sit between the Commission and the senior executive leaders.
Correct. And I would only add that there will be additional senior executive leaders to add increased bandwidth at the operational and executive level as well.
And this resulted from a reconsideration of the recommendations of the capability review?
Well, at least in my part, yes, and by my fellow commissioners as well, yes.
And which responsibilities will the executive directors take over from the members of the Commission?
Well, that is essentially all of the executive responsibilities currently undertaken, day-to-day executive responsibilities of a commissioner will transition away from a commissioner to the executive director. We've seen in a number of case studies, by way of example, the engagement by a commissioner. That type of engagement will cease.
Why did you choose to respond to the capability review findings and recommendations by creating an entirely new layer of senior managers rather than adopting their suggestion of appointing a head of office who would in effect act as the CEO of ASIC?
Because of my own personal experience having been a regulator and reflecting for over 2 or 3 years on what I personally believe is the optimal structure for a financial regulatory agency. And I believe that the structure that we're proposing, which is not dissimilar to the US SEC's, is the optimal model. Let me be also very quick, I don't think the US SEC, with due respect to them, is a perfect model, but I do believe that model has highly influenced me in my thinking over many years as to what I believe is the optimal model. I'm not ruling out and have not ruled out some form of head of office functionality. I will also quickly supplement that in addition to the executive director, we are creating a chief of staff role to the Commission, which will in part form some of the functionality which is envisioned by the head of office role in the capability review. So there is a partial acceptance of that idea without a full acceptance of that for the reasons I've just stated.
What functions will the executive directors have in respect of enforcement decisions?
But the executive directors, there will be 2 executive directors in relation to enforcement. They will make key decisions as regards the conduct of a case and the procedure of a case. But I will quickly add that all of that process is, of course, under review right now. But pending that review, or assuming that review to sort of go in the direction that I expect it to be, they will be discharging decision-making responsibilities on an executive basis, pursuant to, as I've mentioned many times before, better, more structured guidance, strategic guidance in particular, coming from the Commission, so that they are directed and guided in the execution of that decision-making discretion.
So will the 2 executive directors with enforcement responsibilities have the capacity to approve the commencement of proceedings?
Potentially in some cases, but of course there will be, what I envision that will come out of the enforcement review is that there will be thresholds for approvals of certain matters to go to the enforcement committee for decision, or perhaps other forums, but of course that is all part of the enforcement review. So there will be some discretion by the executive directors, but they will not have the entirety of the discretion, because we do have structures in place, committees and governance groups that will be providing key decisions moving forward.
Well, how does that work, Mr. Shipton? Because isn't the point of this to free up the commissioners so that they can engage in strategic roles and governance responsibilities? They're still going to have operational responsibility, are they, for whether or not proceedings will be commenced?
They will have decision-making roles. When a commissioner sits as a part of the enforcement committee, they will be reviewing papers. They will be objectively reviewing papers and submissions. They will be hearing from the team and then deciding upon, along with other colleagues, deciding upon the pursuit of the action. As I understand it, that is not dissimilar to the structure that is in place by the US SEC.
I may have misunderstood, but I thought that you said that they were going to cease to have operational and executive responsibility for regulatory work.
That's correct. But they will still have oversight responsibility and decision-making responsibility.
It's more than oversight. You're explaining that they remain the decision makers.
They remain because we are structured. The way we are structured, the Commission is the ultimate authority for ASIC. We are not a corporate body. We are not structured as a corporate body. So there is only so far we can take the analogy of a board and the executive leadership team. We can only take that analogy so far. What I envision by this is that decision making will still be made, because that is our statutory responsibility. Final decision making and sign off on key matters, on key items, will be decided by the full-time commissioners and others. And when I use strategic oversight and governance, I'm using that expression not so much in a corporate sense, but very much in a regulatory agency, government agency sense.
So exactly what is it that you are freeing them up from doing by creating these 10 new executive directors?
Because right now, on a range of different matters, the commissioners, or a number of the commissioners, not all of them, because we are already in effect transitioning out, a lot of them are actually having, or 2 or 3 of them, are actually having operational day-to-day responsibility. And that is why I keep on using the expression day-to-day, because that is where the distinction between the corporate world and a government agency world comes in. A commissioner under the proposed regime will not have day-to-day operational responsibility. He or she will not be making day-to-day decisions. Yes, there will be decisions that will come to commissioners on a regular basis, but we are designed by statute to be a decision-making body, and we will remain a decision-making body as a commission. What I'm saying is that we need to be more strategic. We need to be less involved in day-to-day executive responsibilities and operational matters to free up time so that when those decisions come to us, we have an objective mindset, not a subjective one, and that we can, when we are reaching those decisions, align them with our strategic thinking.
The 10 executive directors, the new position, they've now been appointed, have they, Mr. Shipton?
They've been appointed, but they have not yet commenced because we will be shortly transitioning.
And did you appoint external candidates?
No, we did not.
Did you have an external recruitment process?
No, we did not.
So how did you fill the positions?
We filled the positions internally.
Why did ASIC decide to limit the pool of candidates to internal candidates and, on my read of the documents, to a very limited category of internal candidates?
We decided because of a number of reasons. Firstly, we wanted this transition to take place as quickly as possible. Secondly, there was a realisation that we had essentially a majority of new external outside commissioners coming on board who were providing that external reference point and external experience. Thirdly, there was a recognition that we needed to retain institutional knowledge and regulatory experience. And then finally, and this is my own personal observation, it is having experienced this through the recruitment process for the commissioners, the additional commissioners, of which I was a panel member of, and through my own experience globally, it is extremely difficult to find outside of a regulatory agency people with demonstrably referable regulatory experience. So with that experience in mind, we opted to recruit from internally, but yes, we also only referenced or had a category of essentially the senior executive leadership pool, which is, practically speaking, the pool of talent within our organisation that is that would be qualified for these roles.
Wasn't this a prime opportunity to bring in, at a day-to-day operational level, some external people with different ideas and different skill sets?
Yes, and that's exactly why that was achieved by bringing in a number of commissioners with exactly that external mindset.
My question was about at the day-to-day operational level, Mr. Shipton.
And I was going to go on and say that I, in my own experience, over many years, it is difficult to find externally people with day-to-day relevant experience at that senior level, that regulatory senior level. May I also add something that it is very difficult. We perceived it would be very difficult to recruit into ASIC people at a senior leadership level if there was any doubt as to potential restructures. And I'd also emphasise that speed was a part, speed of change and action was a key driver. And we have also, and we are writing into the contracts, that these are 2-year contracts, and if people do not perform at this level, then we are clearly minded to make changes.
Well, Mr. Shipton, we'll never know if you're right about how difficult it is to find these people externally, because you didn't try, did you? You didn't open this to external applicants.
Miss Orr, we will never know, but all I can do is speak from my own professional experience over many years and from my own experience and professional judgment that it is extremely difficult to find at this senior level people with demonstrably relevant experience, regulatory experience. Because we are talking about a regulatory professional mindset.
And they might have come across from other regulators, mightn't they?
They may have, but again, my professional judgment and the judgment of my peers, and we did think about it, and your questioning and the premise in which you are presenting is not without merit. I certainly understand, but we decided, for the reasons I mentioned before, particularly because we have new, fresh perspectives coming from excellent new commissioners, that we wanted to balance the internal institutional regulatory knowledge with this new mindset and approach coming from the new majority of commissioners.
Mr. Shipton, I want to ask you some questions about the arrangements for oversight of ASIC. ASIC is subject to ministerial oversight.
Yes.
And it's overseen by the 3 parliamentary committees that you referred to earlier.
Yes.
Now, do you consider that the arrangements for external oversight of ASIC could be improved?
Most certainly.
In what ways, Mr. Shipton?
Well, I believe that we should be thinking and working with particularly the parliamentary committees about developing frameworks and metrics and methodologies whereby over time, not in the short term, but over time, they can measure, comment and assess our performance. I've spoken to a number of chairs of parliamentary committees about this idea, and I hope to take it further. I am also minded to try and find out more from our UK equivalents how they best utilise their parliamentary oversight, because I understand that they have, and I may be wrong, and this is why I want to find out, they have dedicated oversight hearings. I believe that dedicated oversight hearings which go to assessing us, this is parliamentary hearings, that go to assessing us with reference to that framework would be very, very, very useful.
Who would be responsible under this idea for developing the frameworks or metrics or methodologies that you've referred to?
Well, I think the starting point, and I was alluding to this before because this is a body of work, the starting point is better thinking around the qualitative and quantitative assessments that you were questioning me earlier about. I think that very same exercise needs to be broadened, as I said, broadened out and included in these frameworks. One area, and as I said before, one of the starting points is metrics, quantitative metrics that measure the hopeful improvement in the performance and the culture and the outcomes in the financial services sector. That's one of the starting points. And then working back from there is assessing how our tools, approaches and strategy is helping to move those metrics and the performance of the financial sector more broadly in the right direction. This is a very difficult undertaking, and I've spent a lot of time with regulatory experts globally on this, including Professor Sparrow at Harvard University, who I work closely with at Harvard. Developing metrics is a challenge for every single regulator around the world in almost every single sector.
And my question, Mr. Shipton, was about who would be responsible for engaging with that task. Would it be ASIC who would design the framework, metrics or methodologies, or would it be the parliamentary committees?
We would start by developing these metrics, and then we would propose it to the parliamentary committees, and we would work with the parliamentary committees to ensure that they are comfortable and agree with that methodology.
The Financial Systems Inquiry recommended the establishment of a regulatory assessment board to undertake reviews of the performance of Australia's financial service regulators. What's ASIC's position on that recommendation?
Our position is we would like to explore making the current accountability and review mechanisms work better than they currently do. And my personal position is that if that does not have the outcome that we would like it to be, then we should consider alternatives, and that could very well be one of those alternatives. But my proposal is to try and make the current system work better.
Now, an essential element of this proposal to make the current system work better is to attempt to measure behaviour in the financial sector. Is that right?
That's the starting point, Commissioner.
And how do you measure behaviour in the financial sector except through the regulator?
You would measure, the starting proposal is to measure using some baseline proxies. Now, I've mentioned quite a bit.
Well, just stay with my question. How do you measure performance in the financial sector except through the regulator? Who else knows whether the financial sector is behaving or misbehaving other than the regulator?
Oh, yes. So, yes, we would be conducting these metrics. That's exactly right, sir.
Yes, so the ASIC itself would have to determine and develop what you describe as a baseline about behaviour in the financial sector. Is that right?
What I would say is proxies for behaviour in the financial sector.
Yes. See, what I suggest to you is that it all just becomes self-referential. ASIC determines the base, judges itself against the base. What I want to ask of you is, where is the intellectual rigour in that process?
Well, I would submit that the intellectual rigour is that baseline would be for everybody to see. So if I may use the example of breach reporting, which I've spoken a lot about, we have now a baseline as to the performance of financial institutions, their poor performance. If we can see those baselines, and we and the world can see those baselines improving, then that must mean that both the financial institutions themselves are improving, and it also must mean that the regulator is improving, and that is, I believe, an objective assessment. So I would submit very, very, very clearly that what we would be developing is not subjective assessments, of which you would be rightly concerned about, but what we are developing is objective assessments for the world to see, and that we would use that as a benchmark.
One of the suggestions ASIC made in its submissions in response to the interim report was that reviews could be undertaken of ASIC's work by the Council of Financial Regulators. Why would that body be appropriate for that function, Mr. Shipton?
Because I am, again, influenced by my international experience, that I have found peer reviews by fellow regulators coming from different perspectives to be extremely useful. And the peer review mechanism exists under IOSCO. So that the idea that I had was to explore with peer regulators here in Australia, utilising their expertise to conduct a peer review of each other, and that the coordinating body for that could very well be the Council of Financial Regulators, who would also provide some level of oversight and inputs to these the metrics that we're talking about and the measurements we're talking about. I do not for 1 minute say that it's an exclusive. I believe that we should be thinking about complementary oversight mechanisms and exploring peer regulatory reviews domestically, exploring these metrics and frameworks with the Parliament, and exploring some other ideas that I've mentioned and we've mentioned in our submissions.
Why wouldn't it be preferable, Mr. Shipton, instead of having the heads of other regulators assess the performance of your regulator, for an independent assessment to take place by a body designed for that purpose?
Again, I'm not ruling that out. What I'm saying is that we should be working to make existing mechanisms that exist better, and see if we can improve the existing frameworks. I'm hopeful, I can't guarantee it, but I'm hopeful that those existing frameworks and existing systems would work better. And all I'm saying is that we can be making more of the Council of Financial Regulators, and we should be making more of parliamentary committees. But just one point of correction on your question, if I may. It would not be the heads of the agencies who would be conducting assessments of the others. But the way I envision it is that a team would conduct a peer review. This is a common practice in IOSCO, where a team from a foreign regulator would go and assess a peer regulator from across the seas. What I'm essentially proposing here with this construct, and it's only a proposal, I haven't had the opportunity to speak to my colleagues on the council yet, but is to basically provide an Australian version of that.
Well, if there was an independent body with that function, it could, in consultation with ASIC and perhaps even with the Council of Financial Regulators, design the criteria against which to assess ASIC's performance. Do you agree?
Yes, I see your point, yes.
And if an oversight body was created, would it be beneficial to have it assess ASIC's compliance with any bear-like obligations that you are prepared to adopt?
Yeah, that is, as I was saying before, I think it's a very good proposal to have those bear-like structures as a framework for parliamentary committees, or should, the government of the day decide for another oversight mechanism, yes.
An independent body could develop performance benchmarks against which to assess ASIC's work, couldn't it?
They could, most definitely.
And they could prepare a report of their findings against those benchmarks.
They very well could, yes.
And do you think the availability of a report like that would assist the Joint Parliamentary Committee in the discharge of its oversight responsibilities?
Yes, I would agree that it would. But I would also add that my suggestion to the parliamentary committees is for their secretariats to provide that sort of expertise, so that the parliamentary secretariats would have that. So again, this is why I have given a great deal of thought to this subject matter, and I believe that many of your very fine suggestions can be achieved within the existing frameworks.
I have no further questions, Mr. Shipton.
Yes.
No re-examination.
Yes, thank you very much, Mr. Shipton. You may step down.
Commissioner, that concludes our witnesses for today, and we will pick up again with a new witness on Monday in Melbourne.
Yes, we'll adjourn until 10 a.m. Monday next in Melbourne.
Thank you, Commissioner.